said, here's a video of what we were.
So let's on record.
Well, we're not on the record right now.
Let me show it to you and explain it to you, and then you can make whatever argument you want. So this is from his cell phone. He recorded it prior to the incident. That's it.
So I'll make the argument.
Yeah, okay.
Are those the only two pieces of evidence?
Yeah.
I think he showed me only up to the shoe when he gets back.
You want to see those? That's the only.
Counsel, you stopped at the shoe, is there anymore?
Oh, yeah, there's, I'm sorry, there's not a lot more.
16, sure man, we're at 16.
16, yeah, 17, that's, Mr. Katani. This is the house, and the surveillance footage of the.
Down to still two. Who's the other one?
What?
It's not across the street.
Okay,
It's down
our restaurant owner. Someone calling her?
16 and
Okay.
19.
You have this. You have both of these, and you have the videos.
19 and 20.
Do you have an issue with these two?
Yeah, if you'll pop it, it's not up. If you'll pop it up, they pushed it down.
But it's, here's what, I'm not.
There we go.
I'll put it, here's the, so it's the and it is, when you go to the video.
Hi, good morning again. 2 days in a row. No, I like it. I haven't seen you before in the other trials.
That's the house. That's the house. That's like the house.
Oh, I think that makes sense.
You got it. I'm 100% positive. this
Hey,
was-
boss. Question, the same thing I just said I needed you for the computer for, I need you for another person to do that with the computer.
Oh, that's,
The first-
yeah, there's,
You know what I'm talking
like the other stuff is like videos or cell
about?
phones.
Do you,
That's placeholders, so. if you-
Oh, okay.
It's like when
I guess-
so I label all my exhibits and pictures that way, and if there's other stuff, it's gonna be like
where's Jackson?
I just keep a placeholder, so that way I don't lose track of. Because if
Where
I,
you are now.
because it's not really matters, I'm gonna do it, because if I were to, so I want to change. 9%, it automatically numbers.
Yeah.
That's why I.
16, 19, You want to look at 19 and 20?
We received it?
Yeah, you want to look. Counsel, can you do 19 and 20 one more time for us, please, sir?
You want me to pull it up? for you?
Just a-
Okay.
Jermaine,
Yes, ma'am.
19.
19, okay. That's it. Including the hard copy. This is the hard copy.
Judges, are we having a repeat of the last trial?
Maybe there are two who aren't here, but one we reached directly. So we are having a repeat where we couldn't reach one. This one happens to be an alternate, so it's built in as an alternate. But it's the woman, alternate one, who said, oh, you know, it could be complicated childcare. My husband's moving his law firm. And we tried her phone a bunch of times and it went straight to, there's no voicemail. So we sent the email, but haven't heard anything. So I don't know. We won't wait too long for her. But juror 3, our first juror, the restaurant owner, don't know where she is. So someone's calling.
I really don't know.
Oh,
We need at least one of them.
but then we could be down to no alternates.
That would be bad. That's why we're getting at least one of them.
Remember we tried to call yesterday or today. I don't know how this works.
No.
No, it's showing that it's charging. Is it full? So the HTML is right there. But I understand now the purpose of the link. I'm just trying to confirm with the judge. I think the link is so that we could just share instead of unplugging, unplugging from the HDMI, because there's only one it looks like.
I think he says it doesn't, the HDMI cord can run.
There's HDMI right there.
All right.
That's not an issue. Just move the computer. No, that's why I think the only other way to do it is, that's probably why we got the link.
Judge, are you ready for the media? They have the Rule 22.
Sure, they can come in whenever.
Okay, all right. Thank you, Judge.
All right. Yep. Once we get our prosecutors back in here, I need to bring Pritchett in and see what we're going to do. So I'll see you in a sec.
Juror, is this the HDMI we can use for the system? Is it connected to your system, or do we have to run that black cord all the way over here?
So what people typically do is play through Zoom. I'm not sure what you need to hardwire anything to. So if your machines join the Zoom session, then if you've got an image or whatever, a PowerPoint, that should appear on all the screens because you're sharing your screen and you don't need an HDMI. It's just through Zoom.
Okay, is the videos or anything like that going to be delayed through Zoom, Judge?
The videos don't always work so well.
That's what I was concerned about.
Yeah. Are you playing a video in your opening?
No.
Okay, then let's cross the video bridge when we get to it. What the state has done in the past is actually either tried to plug into that one or they've rolled in some machine that's not on any of the systems and they just put a thumb drive in the side of that and you'd be able to use that as well if it's not in here. It used to be against that wall. But videos have,
Told me that the cord is long enough and that's why they put this coil cord for HDMI.
I don't know how long it is, but during maybe the lunch break, you can see. I'm assuming between now and lunch, you don't need to play any videos.
No, I don't know if the state was gonna, I changed my mind. I think the way the state is structuring their witnesses, that video is gonna become an issue before lunch.
Okay, well, you can try figuring something out now. As soon as I find one of these prosecutors and we get Ms. Rivers back, we're getting on the record and rolling. So I don't know how long cords are. There is a really long cord there,
Yeah,
and that may be,
I should be able to stretch all the way.
okay.
Like this cord, you see it? You can just send it right with this cord. You see how long it is? Yeah. And he says it'll project. Mhm.
Okay, so this one should all under here.
Mm-hmm.
Okay.
5A and 5B is officer rights report, right? 5A and 5B.
Yes,
Okay.
I think we've been deceived.
We had 11?
Not
I mean,
that-
13?
I don't think that cord, I'm following it here, I don't.
Okay.
Look
No,
like
it's
cable.
only supposed to come around and then going on the computer.
Not understanding, that has to have an end. So when you follow the cord from the TV all the way here, it's not an HDMI. So there's nothing to plug up, it looks like it's a cable cord.
Like 3 of the witnesses?
No, not this cord. This black cord that's on.
Yeah, that's what I thought you just said.
One said they didn't arrive. The worship problem, we get them here. That's why.
Hey, how are you?
Okay.
So that one's initially.
But I'm just giving you a heads up. There should be-
So break nothing? That's rule 1. Well, better yet, you get us whatever the new replacement value is.
How about I just get you a new one, Judge?
Yep.
Sometimes
That's what I mean.
it's
Then,
less expensive.
great.
Yes, do you have it?
Nope, he ended up going with his grandpa is a heart surgeon. And he's gonna watch a heart surgery this morning. Yeah, way cool.
Set him up a robot. No, man, some of
Yeah.
them knew that looked.
No, be careful.
All right.
Them all have a
All right, let's all be seated. We need to get rolling. There are a few things we can do while we wait for one more juror who is apparently at the checkpoint.
So you want anybody to think I was dragging them back to watch? Does he have to watch it? No, you need this, you want to. Killing me.
No, I don't need that. I mean, did need this for the PowerPoint.
That's disruptive. That's honest. Can you?
No, I mean the card,
The video of this.
because I need to throw it up on the screen. Unless you're gonna do this through the Zoom.
Don't be playing in the hallway and stuff, like it's.
He wants to see it. He's asked several times, and if it makes him comfortable, I'm gonna let him see it. If that's okay with you.
Well, I think I got it. Yeah, I got it, probably can.
Can you watch it? Okay, yeah, out. Hey, Jackson?
Excellent.
Don't let anyone else do it.
All right, Ms. Rivers, are you ready? Okay.
He's just been asking all day.
Can we bring Mr. Robinson out? Thank you. We'll start with Mr. Robinson and then don't worry, you'll get a chance to bring Mr. Pritchett out.
I didn't actually then read it. Hold on a second.
That's all I'm showing you, so you don't use the time difference, correct? Yeah, it didn't have to update it, it's updated.
Look at that.
You got it?
No, it's still.
All right, let's get on the record in State versus Robinson and Pritchett. We have our prosecutors here in the courtroom on Tuesday, the 23rd. Ms. Mignot and Ms. Blake are here with their client, Mr. Robinson, who looks like he got a haircut. Is that correct?
You
Yes,
got a
sir.
haircut, Judge.
Thank you.
Are we satisfied? I mean, is it okay for Union City standards?
Yes, John.
Okay, great. I'm glad that worked out.
Thank you, Judge.
Thank you.
You're welcome. I just asked. I didn't do it. I think we are good to go with Mr. Robinson. There may be a few things we need to talk about. What I'd like to do first, though, is bring Mr. Pritchett out to see if he's going to join us this morning. And then we'll take up anything we need to discuss outside the presence of the jury. So if you all could bring Mr. Pritchett, make sure that chair's available for him just in case he chooses to sit. It looks like it's right there.
Thank you. My copy?
Yes.
Thank you, sir.
We're good except for that one. Okay, thank you.
Your Honor.
Thank you, sir.
Mr. Watson says you want to speak with you.
Okay, we'll do that whenever we can. Thank you. All right, good morning, Mr. Pritchett. It is the start of the trial. We've got our jurors and they are about to come in. I wanted to check with you this Tuesday morning to see if you had had a change of heart and wanted to engage meaningfully, constructively, and non-disruptively and participate in your trial. Any update from you?
I'm on the record. I am not here to say I am here improper persona sui juris under the duress of coercion. I am not here as the legal name or legal person, Max Pritchett, that the state in this court has against my presumption of innocence, presumably enforced me to be. I am here in my private God-given Christian name, which I do not consent to being used for any commercial purposes in this courtroom. Furthermore, that the record show I do not understand the nature and cause of the proceedings and claims against me, nor do I understand the nature and authority of this court. How can I possibly understand these things and participate properly in this trial when the court has failed to disclose what jurisdiction they are operating under? The court has arbitrarily assumed personal jurisdiction over me by forcing me to be the legal name and person Max Pritchett when there has been no evidence proving such claim that I own that name or ever consented to that name on record. The court has denied my presumption of innocence in regard to those elements of the charges. The court has also prejudiced me by declining my request for full disclosure of the discovery that showed the evidence proving all the elements of the claims and charges against me, so I can prepare a proper defense.
Okay, Mr. Pritchett, Mr. Pritchett, I'm going to stop you because everyone in here has heard this now a bunch of times.
Continue.
Nope, you
Continue to make the record for this the violation of the rights.
tell me how much more you have, because if you've got 30 seconds or less, you can. Otherwise, you continue to disrupt these proceedings by repeating baseless allegations about lack of personal jurisdiction and these things about improperio personam. And you've made a record of that a whole bunch of times. We don't need to remake the record. But if you want to spend the next 30 seconds adding what you want to add, then I've got a couple questions for you. If you want to answer them, great. If you don't, then we'll check in with you during the morning break.
Okay, let the record show that the court has stated I can only see the full discovery only if I have an attorney. The judge of this court has practiced law from the bench by entering pleas on my behalf against my consent. I have been greatly injured by this court and stated I cannot properly participate or prepare a proper defense in light of these due process violations and the impartiality shown toward me. Mr. McBurney, are you prepared to rectify these issues and help me understand the full nature and quality of the claims and charges against me, along with the nature and authority of this court? If you cannot, do that at this moment. Can you please recuse yourself from the fact that you're impartial?
Hold on one second.
Biased toward me?
Okay, I'm sorry. Ms. Mignot was adding a machine. It was creating feedback, but it stopped. So keep going.
Again, I just want to repeat, Mr. McBurney, are you prepared to rectify these issues and help me understand the nature, the full nature and cause of the claims that are charged against me, along with the nature and authority of this court? If not, can you recuse yourself from the fact that your impartiality and bias toward me have been brought into question?
All right, thank you, Mr. Pritchett. I think that it's important that the record reflect that the issues that are being prosecuted in this case are things with which you're most familiar, since you represented yourself at your revocation hearing in your other felony case. And the basis for your revocation in that case were the facts and circumstances of this case. So I'm confident that you're familiar with the allegations. We've already discussed that. And when you were represented by counsel, you had full access to all the discovery, including discovery that you may not possess as an inmate at the county jail. When we had our discussion about you representing yourself. Okay, well, we have differing perspectives on that. Regardless, this is an opportunity for you to join the proceedings. Do you care to sit?
How can I possibly participate properly if I don't have the evidence of all the evidence and claims against me? You're not allowing me the opportunity to even understand the full nature of the cause and the authority of this court.
Well, I am by inviting you to join us for these proceedings, but you're declining. You don't want to sit and you don't want to engage in the way that someone who is meaningfully participating in the trial would engage. So I find once again that because you're unwilling to follow the basic rules of decorum in the courtroom, that I'm going to excuse you. I'll bring you back out in the next break. And if you want to participate, you remain welcome to do so as your own advocate, which is what you requested last week and is what I granted you. So, Deputy, if you would remove Mr. Pritchett from the courtroom, we will try again later this morning. Mr. Hiles, is there anything we need to discuss from the state's perspective before we bring in the one juror?
I just want to put on the record that I did provide all parties with an exhibit list, and I do have an extra copy for Mr. Pritchett. I just want to make sure that I'm bringing everything for him if he would like to participate, making it available for him.
Great. If you don't mind putting an extra copy over there where Mr. Pritchett is invited to sit every time he and I have the same conversation, I'll make sure that he picks it up and adds it to his collection of papers that he brings out and reads from to tell us about whether we can use his God-given Christian name or not. Anything else from the state?
That's all I have.
All right. Ms. Mignot, anything on behalf of Mr. Robinson?
Good morning, Your Honor. Yes.
Good morning.
This morning, the state was kind enough to go through the exhibits that they anticipate presenting in their case in chief. And I have a concern about at least one of the exhibits.
Which one is that?
Exhibit number 16 is a picture of shoes. And throughout the pendency of this case, there has been no discovery provided to our firm. And I want to be clear with the court, we didn't just go to previous counsels because there had been several. We provided the state with the terabyte, 2 terabytes, however many terabytes they requested. And they assured us that all the discovery that was in the states, that the state intended was associated with this case was produced. There has never been a photograph of any sneakers. There have been mentions of photographs of sneaker, but there has never been any. This morning, Mr. Hiles advised me that one of the victims or the alleged victims, Mr. Chris Riggs, produced last night the picture of the tennis shoes that's depicted in Exhibit 16. And I have concerns. And the reason I have concerns is because we are now, as defense, unable to do any type of investigation of when that photo was taken, to get any type of IT person to go in to make sure that it wasn't produced at a different time than it said it was produced, looking at a cell phone, any forensics associated with that photo. So now my concern is, we're here at trial, we have a jury ready, and we've mentioned sneaker, 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 and there's been no evidence presented about any sneakers, and boom, voila, trial by ambush, here's a picture of a sneaker that we're intending to show a jury today. So we would object to Exhibit 16. As it pertains to Exhibit 19 and 20, Judge, we do have that in discovery. However, my concerns is it's a different address from the incident address location, and it may create confusion for the jurors as to which house are we actually talking about here as the Airbnb house.
Okay,
And-
but that may be, should the state seek to admit it, a relevance objection. It's not a, we've never seen it before.
Correct,
Okay,
that is correct.
all right, so I'm going to table 19 and 20. We need to see the context in which it's presented. It may be relevant, but maybe it's a 403 because it's unduly confusing. But I appreciate you flagging that. Can you get Exhibit 16 up on the screen?
I have it for you.
Okay, great.
And, so Your Honor, this, and it mentioned also discovery. This is something, the picture that we had at the beginning, it was turned over with the original file. This case has been going since 2019. At some point, I did lose part of my file. We had issues with the game server. So it may have very well not been turned over to Ms. Minot. And last night when we met with, it's actually Jackson Heil, that was not with Christian Riggs.
Okay,
Those are his shoes that were reported as being stolen off his feet. He has it on his phone, so maybe if the defense would like to see when the picture was taken, I don't know if it's still got that data, but it's a picture of the shoes taken. He bought the shoes the day of the robbery.
okay. So the way you would use State 16, I'm assuming, would be through Mr. Heil, and he would authenticate it by saying, those are my shoes. I recognize them. Those are my legs attached to the feet that are in the shoes. And I took this picture the night of the incident.
Or the day.
Whenever it was, he took the picture. Not only could he provide a foundation for this, it's a fair and accurate depiction of his shoes on his feet, but he is the creator of the image.
Yeah.
Okay, all right. Ms. Mignot, I'm going to preserve your objection. You're free to renew it. You don't need to, you've made a valid objection that this is untimely disclosed. You don't need to make that full objection should the state seek to tender Exhibit 16, but I'll make sure on the record that I acknowledge you're renewing the objection you made now before the jurors came in. There may be other bases to object as well. So you're waiving nothing and preserving this. But I don't find that given how it will be presented, you aren't in a position to meaningfully cross-examine this person. I hear you that you didn't get a chance to have a forensic expert look at the metadata and this and that. But I don't find that disadvantage is such that the state shouldn't be able to use this photo, not of what they say was the weapon that someone used or et cetera, but shoes actually on the feet of one of the victims. I think the victim, alleged victim, is in a position to provide sufficient foundation for this picture. I also, as an officer of the court, I credit Mr. Hiles's claim that it was provided to your predecessor, but I credit you as an officer of the court. You started with a clean slate, which you should have. Here's the empty drive. Give me everything you've got. And if I were you, I wouldn't have relied on it trickling across from a predecessor. So I don't know why State 16 didn't make it across, but I'm not finding that the prejudice that this might cause is such that it ought to be excluded. I'm not finding bad faith by the state in this reappearing at this point. Okay, anything more you want to get on the record about State 16?
Just that counsel had previously communicated to me that it was not produced, and now he's telling the court that it may have been produced, so.
I communicated it was not produced to you, but it was produced to your predecessors. At some point, I lost part of my file and we had to go back and get additional information especially in 2019, at the end, our server went through issues and parts of our files were recreated. So I know it was turned over in initial discovery, and by initial, I mean to whoever entered the first appearance back when this case was.
How do you know, Mr. Heil? You're actually both correct, because what Ms. Mignot said is that you told her you didn't produce it to her, and you just said that as well. How do you know it's not in the 2 terabytes of data, or you're just relying on Ms. Mignot saying, I didn't find it in the 2 terabytes?
No, I haven't. I had that photo initially, and I've gone through this file, and then there was a couple ring videos that were gathered along with that that we're never able to recover. It shows the cars driving at different angles. We have recovered most of them.
Is there anything else that you intend to use at trial that you know you didn't produce to Ms. Mignot? What's that?
It's video states 27. I wanted to bring that up right now. It was not produced. It never has been produced to anybody. But last night when Miss Crean met with Mr. Heil, our out-of-town witness, he said, hey, here's a brief 30-second video of the party, and here's what was going on before anyone arrived. It just shows them engaging in a party game.
So
15 seconds.
Doesn't matter if it's an hour. Unlike the sneaker photo, which you believe you did provide to previous counsel and didn't intentionally omit from what was submitted to Ms. Mignot based on the server woes you had, et cetera. And we've all talked about these sneakers before. It's not a surprise that someone had green sneakers, and there was going to be testimony about it, whether it was corroborated by a photo or not. You've made plain in justifying, in part, the 2 videos in which Mr. Robinson appears, that the green sneakers that were taken from one of the victims are part of the connective tissue you're going to build between the defendants and the allegations. This video is different. This is an alleged victim saying, oh, by the way, here's this. Ms. Mignot, have you had a chance to view that video?
I have, and I have concerns, and I would object to it being used out of time discovery. Also, Your Honor, it really is not a picture of the party. So you're not getting a full room view of everybody engaging in games. What it is a short video of somebody just showing what looks like a Wheel of Fortune kind of thing with handwritten notes on it.
Okay. Tell me why you ought to be able to play that. You just got it. So, and you immediately handed it over. So it's not a discovery violation in the sense that you noticed it in the officer's file, and it's been there for 3 years. But it gives Ms. Mignot 0 opportunity to prepare for it. Why should you be able to play it?
So may I allow Ms. Green to answer that? It is her witness, and
Sure.
she's the one that wants it to be. So I will defer to her.
Sure. Tell me the significance of states 27.
So it's just a Wheel of Fortune game, taking a shot. It corroborates my witness's statements, a lot of the victim statements of what they were doing prior to the incident. It does not invoke any issues it doesn't have any allegations towards the defendant. This is way before the alleged males came into the home, but it just simply 15 seconds, probably like an Instagram video to show what they were doing right before this happened. It will show people were taking shots, why they were taking shots. They were playing a drinking game. So you're gonna get like evidence of underage drinking. It kind of just shows, it gives a visual to it. It's only 15 seconds.
Okay, yeah, you've emphasized it's only 15 seconds. It also got handed over today.
Yes.
So, Ms. Mignot, I'm gonna let you think about it more. I'm inclined to not allow it in because it's not late disclosure, it's immediate disclosure by the state. But it's late arrival for the trial. And so I'm inclined to exclude it. But you should think about it more. You may want to have the jury see these people drinking. For now, 27 should not be tendered. If you think about it more and decide you don't have an objection based on the time at which you received it. Again, I'm not characterizing it as late disclosure by the state. It sounds like they got it to you about as quickly as they could once they learned about it. It was late provided to them. I'm gonna provisionally exclude it, but let you think about it a little bit more because you may decide, go ahead and play. Does that make sense?
That makes sense, Your Honor. I just wanted to be clear for the record. I was shown the video from the state's computer this morning. It wasn't emailed, nor has it been produced in.
Okay, but you were alerted to its existence this morning.
That is correct.
As soon as we all convened. And so I want the record to be very clear. I don't find any bad faith or anything like that on the state side. They just got it. Now, why this gentleman didn't think until now to hand it over, don't know. I don't see anything sinister in that either. They were doing witness prep and he said, hey, I have this. I was a little late for the state. Not their fault, but I'm not going to allow that to compromise your presentation. So you should think about it. And with which witness would this come in?
It would be Jackson Heil.
Is that the same as a sneaker picture?
Yes, the
Okay.
creator of the video.
All right. So we'll know when Mr. Heil's testifying. That'll be the time for you to decide, you know what, I don't object to the lack of timeliness or basically when this was disclosed. Because I find that it's disclosed. They don't have to give you copies. They can show you what's in their folder. So you've seen it, you know it exists, and the state did get it to you, I find, as soon as they should have. They just didn't get it in a timely manner. And again, that shouldn't be your client's problem.
Understood.
Okay. Anything else, Ms. Mignot?
No, Your Honor.
All right. Can we bring Juror 3 out, please? You're not going to film any good. Hey there, you can sit right in that corner seat. Good morning, you're Juror 3, and Deputy Gordon told me you wanted to talk to us before we got rolling.
Yes. So, last night was like a hard night for us or whatever, because I was talking to my boyfriend about like everything that happened, and I felt like I could do this. I felt like I could be like, I wanted to be able to see objectively and be able to like give the defendant like a fair shot, because at the end of the day, like everybody deserves to have a fair, like you know, shot in court or whatever. But I know I said that I would try, but after the conversation we had last night, I know that I wouldn't be able to give him the fair shot that I genuinely feel like he deserves.
Tell me what you mean by that, because I know we had a very thoughtful discussion, you and I and the lawyers yesterday, and we tried to separate out the notion that you might reflect upon what happened to your boyfriend, which is natural to be expected and not a problem, versus your boyfriend's situation of several years ago somehow interfering with your ability to focus and process what this case is about. And you didn't promise anything because you can't promise because you don't know. But what I understood you to say in the end was that you appreciate that they're two different situations. And that while you might think of your boyfriend's situation, that wasn't going to cloud your judgment. You wouldn't use information you think you know about that and plug it in here, or bring in anger from that to say, you know what, because I'm upset about what happened to him, the state doesn't have to meet its burden. They just need to sort of wave their hands around and I'm gonna find someone guilty because maybe someone else had happened to them what happened to my boyfriend. I left our conversation hearing you say, that's not me. This might be difficult because of what happened to my boyfriend, but I can appreciate the difference between the two and I will not import information from one into the other. So tell me what's changed. And maybe nothing's changed, it just was a difficult evening.
So I wanted to be that person because I am extremely level-headed and tend to be more on the logical side. And I can't operate with any emotions in my personal and in my professional life. And so I don't do that, but seeing as though this is more so like a personal thing, and this is something that has affected many things that did or didn't happen within us in our relationship and our lives. Like our lives drastically changed, although it was so sudden. Like it went from us just meeting each other to him having to come and like live with me because of this event, which I was not prepared for.
Right.
And I had to take care of him and all the stuff that I wasn't accustomed to. And then so many things in our lives was affected by this. And then last night we just had like this moment in which like it was like it just happened. And I know that like I need to be honest, like big thing is though, like I said what I said because I know like I am a very logical person, right? And because of that, I know like I would not be able to give him the unbiased fair shot that I feel like we all deserve.
Everyone does. That's right. Both sides. It's not just one side. I mean, you need to be.
Yeah, for sure. I just feel like, oh no, I just feel like it's not right. And I needed to be honest about that. I prayed about it. We talked about it. I don't see it happening like for me, like I don't, especially not after last night.
Okay. Mr. Hiles, do you have any questions for Juror 3?
Are you saying you don't see you having the ability to only look at the facts as presented through witnesses? Are you going to look at the facts as they come out with an inference of guilt? Is that what you were saying?
Yeah, I think that if we're being honest, I could easily, I could say like, oh, I'm gonna look at the facts, but I think it's different when we have trauma. I think we can want to say we're gonna look at the facts, but if I'm being, I took it seriously when I swore on an oath to tell the truth. So I feel like I know that's not the truth after last night. Like I don't know what all this means from like what I'm saying, what's gonna come from this, but I just wanted to make sure that I'm like and telling being very honest, you know, like I just want to be honest about it.
Okay. Well, let me say this, and then I'll see if Ms. Mignot has any questions for you. What's going to come of this is nothing bad. You're not in any trouble. The honesty is essential. In fact, you took an oath yesterday to be truthful in your answers. And as you and your boyfriend processed things last night, you felt that maybe you needed to amend one of your answers, and here we are doing that. So there's not a bad outcome to this. It's important that you share this. Okay. Ms. Mignot, do you have any questions for Juror 3?
No, Your Honor, respectfully decline.
All right. If you would go back to the jury room, we're going to talk and we'll let you know what's going to happen. Thank you. Okay. So, your thoughts, Mr. Hiles, about Juror 3?
Well, I think my thoughts are that she point blank said that she lacks the ability to be impartial after discussing this. I don't know what she discussed with her boyfriend. I don't know if she discussed some of the facts of the case.
It sounds like they discussed his situation. Yeah. He was shot in an armed robbery. And so this caused them to revisit all that.
I do not want to, my thoughts are, I do not want to do this twice. I don't want to, that's what my thoughts are. My concern is that we are already down an alternate.
Right.
And if we go into this now, I mean, what's going to happen if we, I know you can continue with 11 jurors, but that requires I guess essentially a waiver by the defendant. That's not a call that I have the position to make. And like I said, I don't want to do this twice.
Right.
Have we heard anything at all from the alternate juror?
I don't think so. Ms. Nelson, can you shoot me a Teams text? Any update from juror 39? I'm assuming that that's a dead end, given that the calls didn't work this morning and she didn't respond to the email. I'll deal with that separately.
I think,
But we have an alternate who now won't be an alternate if we excuse, thank you, Ms. Hansberry. If we excuse juror 3.
Okay. My last question about is it juror number 39 that's not present? Last time we did the text, has she been texted? Because that was when we
Go for it.
Okay. Could I approach to get her number?
Yes.
And the only thing I would suggest is we don't hold up and we do as we did last time.
Right.
It becomes the second alternate. And if she misses opening, she misses both of our openings.
Right. Here you go. So Ms. Mignot, the trial we had a few weeks ago, we had a juror we couldn't reach through phone or email after jury selection. And then at about this time in the trial, Mr. Heil said, hey, why don't we try texting the person? And we texted this person and magically she called the chambers. That person was told, get yourself down here. She became the alternate. This person's already the alternate. And everyone involved agreed that that person who became the alternate would be able to join and be a full-fledged part of the jury, remaining an alternate. She just skipped the opening. She arrived in the middle of, there were 2 defendants, one of the defendants' openings, but rather than allowing her to hear 1.5 openings and not the state's, the agreement of the parties was she would join in once evidence began. And she ended up as the alternate, didn't deliberate, but we had that pressure relief valve. Here, I think we need to excuse juror 3. That's the first thing we need to address when it's your turn. But we then need to figure out what do we do? Because if juror 3 is excused, we have no alternates. We have 12 jurors. And I'm leery of going forward with just 12 unless I know that everyone agrees that they would go with 11 if we lose one, because then in effect we have another alternate. Otherwise, I'm gonna wanna sit around and wait. Some, but not too much, like Mr. Hiles, and I'm sure like you, and even more so Mr. Robinson, who isn't going anywhere if there's a mistrial. We don't want to try this again because he will wait until we can get this back on your schedule and mine to try it again. So that's what I'm trying to balance. Share with me your thoughts first about juror 3 and then how to navigate what we do if juror 3 is excused.
Juror 3's statements this morning, Your Honor, is clear that she cannot be impartial. It would be ineffective assistance of counsel if I went forward and something happened as it pertains to her deliberation and it was exposed after the trial. So I agree with the court. I concur with opposing counsel, Mr. Hiles, that she has to be excused.
Okay. So if we do that, then we're down to 12 jurors because juror 43 would become our 12th juror. And so the question is, how would you want to proceed? We can proceed with no alternates, or we can dispatch deputies to go grab this woman who has declined to respond to emails, has her phone going into non-voicemail, and we'll see if she responds to the text. That's going to take some time. Or we could go forward with 12 with an understanding on the record that if we have to excuse one more, just one more, that we'd go with 11, and that's a sufficient number. So I need to get your perspective on that, and you can have a moment to huddle up on that. But I don't want to excuse 3 till I know what our plan is going forward.
I agree. If we
Okay.
can just get some time to.
Sure.
Ever a dull moment in 8D.
Yep. Makes me rethink the let jurors go.
I was thinking about that.
It was working for a long time.
It's worked until I've tried your cases, if you must know.
Well, always happen to bring my surprises.
Yeah.
Your Honor, is it all right if I step out and refill my water bottle?
As long as you've got a colleague in here,
Just a legal assistant?
a lawyer.
All right.
I guess another thing we could do is have jury services send us 4 potential jurors. And just agree that we will be most expeditious in our approach with that, and then we could restock.
I'm not opposed to that.
I can do that in a heartbeat.
Okay, let me see if we can do that. Keep talking. Ms. Nelson, can you please check with jury services to see if they've got 4 spare jurors?
Juror service they need alternates too. It used to be that, I remember when I was in state court, there was no requesting jurors like the day before. It was like, if they're available, they'll send them. So here's one. We're either going to get a response from the juror that we texted,
Or go get
or
her.
potentially, if the jury services has 4 spare jurors, we might just wander a few of them. And we need one alternate.
I know. Can they go get it? Would that be easier than to volunteer 4 more? Which one is shorter? I don't know. I'm just
Yeah, I've never done
talking logistics, like which one will take longer? Go pick her up.
All right, I'm gonna fill my water bottle up, so
Okay.
just.
Can you hold, I need to use the restroom.
Right, go. I just need you in here, so he said we can.
Let me see where she lives. Because it'll be, I mean, if she's in Johns Creek, it'll be easier for us just to do this if we can get some jurors real quickly. Sandy Springs. Oh, I don't have the address. Oh, would it be, no, I don't have addresses. She told me Sandy Springs. Maybe there's another list? The two I have, just there's phone numbers and email address. She's got the super duper one. Hey.
So one of the family members wanted me to give the guy. in the back,
Pritchett.
Yeah. Paper.
This is the paper.
Mhm. You.
Okay. I mean, it's up to you guys whether you
Well, yeah, I
allow
will-
people to pass papers. If you do, you can have it.
I just want to make sure you.
Yeah, no, I appreciate that.
Did you decide?
We're just kind of waiting.
Okay.
All right, there are 4 jurors heading this way. We got 4 jurors coming. Are you doing all right back there? Yeah. Okay. Thank you.
Just keeping it warm for you.
Four jurors are on their way.
Cool. Do you have a Sharpie, or did they take that too? I don't care what color it is at this point.
No, I have to watch you.
Well, no, I gave it to, remember I gave it to Milanes, and Milanes was having people sign it. I don't know where Milanes went.
Okay, don't take that one. That's the last one we got. Bring it back.
Right there. Come on, man. You gotta be on point. She's here?
She said she wanted to talk in the journal.
She's.
Could we do a head count in there? So who's missing? Dude, where's Sergeant Palmer?
Oh.
That's awkward. I just wrote a contempt order.
I called her, I can tell you how many times, and she's,
You keep calling me and I'm sitting in the jury room. I'm like, what jury room are you sitting in? Thinking she's on.
Okay, just, can you guys both look? There should be 13 people. There should be 14 people in the room.
You didn't dismiss 3?
Not yet.
Oh, so 14.
So there should be 14 people in there. This is,
She's active in this room since 5 till 9.
oh, my order was,
You're excited about
yeah.
What happened?
She's here. She's been here.
oh, no.
No way.
They didn't know.
We're verifying. And someone's going back to counting school. We have 14 people back there? Okay. So, let's go back on the record, please. I won't name any names once we're on the record. All right, we're back on the record in State versus Pritchett and Robinson. We have a more official head count now, and we have all 14 jurors in the jury room. My thought is that we excuse juror 3 based on the record that was made when she came out to share with us the developments of last night. Sounds like, Mr. Hiles, you agree that that's the appropriate, based on the answer she gave and the things she said, that's the appropriate outcome. And Ms. Mignot, I know you agree with that as well. Any change?
No change, reluctant, but yes, I don't think there was any rehabilitating, kind of like juror 27 yesterday, so.
Okay, all right, Ms. Mignot, anything else?
Nothing else, Judge?
Okay, then why don't you bring juror 3 out? And then in a moment, we'll bring everyone else out. And if we could, Ms. Nelson, please cancel the 4 jurors who are heading this way.
Okay, I'm right here as well.
Oh, great, thank you.
Okay, cool.
Excellent. And we need to give Deputy Gordon
2 more.
2 more fingers.
Do you mind if I get 16 back whenever you get a chance?
Oh, sure, I thought that was for me. Juror 3, I want to thank you for your candor. And I'm sorry that being involved in this process has dredged up some of the difficult feelings. Hopefully it was I don't know, maybe a cathartic conversation that you and your boyfriend had. But your candor with us has helped all of us, the lawyers and myself, understand that while you would make an excellent juror in lots of cases, this isn't the right case. And so I'm going to excuse you, okay? I told you before, you're not in trouble. In fact, where you would have been in trouble would be if you covered all that up and then we got to deliberations and you completely melted down and said, I can't do this anymore. Telling us up front is the time to do it and not 4 days in, okay? No trouble at all. Appreciate you coming back. If you just grab your stuff, you should head on out, okay? All right, thank you.
It's right is now wins. That's why it's confusing.
Your Honor, could we run to the restroom really quickly with all the trauma I think I need to?
Okay, I don't know what you've been doing in the last 20 minutes, but if you'll go quickly, you can do that. Mr. Robinson, are you good? Because my plan would be we do these openings and we've had our morning break because we haven't started yet. So why don't you go? And give this back. Yes, all right.
Right, yeah, Jackson. Okay. And then Holden, we might bring let me see this
See you in that 2028.
No comment.
Huh?
No comment.
God willing.
It's all set to give the whole voir dire speech again, to reprogram. I've never had that happen before. That's fun. It's a new first.
You were excited about that order.
Yep, now I gotta get rid of it. Was she like under the table or? Okay.
I can't even like serve after she I said.
Well,
Yeah.
sure, that's what it was. Mr. Hiles, will you take this? I'm apparently not supposed to keep it.
I'm glad that it wasn't my jinx that was put on.
Right.
Yeah.
Oh, thank you.
Did she respond to your text?
No, but she must, I wonder if she got my text and like alerted you, like, hey, I'm here. I don't know how you figured it out. Did you do a recount?
Yeah, I recounted.
I think Ms. Hansberry went in there and either counted and realized there were enough, but that's when that juror said, hey, you keep calling me.
Yeah.
Maybe if you answer.
Yeah. There's blame to go around.
Exactly. They went that way.
Okay. Chair, how do I put this up? Council, are you plugged up through the remote? Are you plugged up with your PowerPoint through the remote?
What are you talking about?
Are you remote?
Am I oh, I got a like clicker.
Okay.
Is that what you're asking?
No, I was asking if you were coming through Zoom.
Oh, I will be, but I don't want to do it until I start.
Okay, got it.
Yeah, I don't want to have everyone walk in and be looking at the.
Yeah, so we'll wait on you.
Screen share, what's already logged in, so when it's your time, just maximize it.
Mhm.
and click on- I left this big, so it's easy to see. It's screen shared somewhere. So. I can put this right here.
You are in control of this when I am up there.
Oh, sure.
Yeah. So I have a push shot, but it's two of it.
Mhm.
Oh, you're back.
Yes,
I was
sir.
like, why are we just waiting around? Okay, let's try one more time with Mr. Pritchett, just so we're making a good record. Please.
Let me click for short. I'll do the individual one.
There's a little photo. To your right hand, there's like 4 different options. The one that looks like almost like this computer. It has a little.
I need to give you something to throw at me in case I'm not speaking loud enough. Yeah.
Just let me. Okay, well, then we'll call her first. then.
Sure. Let the fun, the government. We don't move.
But I think you're right.
Take it as large
Skip
as
it.
it can.
Difficult
I
to do.
think we'll play it through Golden like you said.
We don't move it. now.
I think it's better. It's a good call.
We're back on the record in State versus Robinson and Pritchett. Mr. Pritchett has been brought back into court. 2 things for you, Mr. Pritchett. There is an exhibit list from the state, and then some family member of yours brought a document that she said you wanted. So that's the second piece of paper. I want to make sure you add those to your collection. And I want to know again if you would like to join us and participate. And yes, you're on the record.
This is all the custodian.
I've given you an exhibit list and a document that a family member of yours wanted you to have.
On the record, Mr. McBurney, before you were a judge, you were a lawyer. And before you officially became a lawyer, you signed a title of nobility. How can this court lawfully move forward if you're not even supposed to be on the bench? And according to the Constitution, you are no longer a U.S. citizen.
That's an interesting question. I didn't know I had a title of nobility. Maybe because of that, I could retire early. But for now, I'm going to stick with the title of judge and ask you if you'd like to sit or if you'd like to go back to lockup again, and we'll check during the lunch break if you want to rejoin us.
I will sit down actually. I just have to understand what jurisdiction is this court operating under.
The jurisdiction of the laws and the Constitution of Georgia and the United States. So what's going to happen, should you choose to sit down, is the jurors are going to come out. I am going to swear them in and give them some basic legal instructions, and then it will be time for folks to give opening statements. You will have an opportunity to give an opening statement if that's what you want to do. When it's your turn, I will address you. It would be real helpful if you would tell me the manner in which you would like me to address you so that I don't get you upset by using a title or a name that for purposes of this proceeding you seem not to like. Are you prepared to answer that for me?
Yes. Can this court first take judicial notice that I am not a legal name or legal person, Max Pritchett?
I cannot take judicial notice of that, but I would love to know, I'm gonna write it down, how you would like me to address you when we've got the jury in here.
Why can't judicial notice be taken of that?
Because that's not the type of thing for which judicial notice can be taken. Judicial notice can be taken of records in the court's docket, of non-arguable things like today is Tuesday, or when the sun rises, the sun sets, things that are incontrovertible.
So that's an arguable claim that I am the legal name of the person, Max Pritchett.
That's not what you asked me to take judicial notice of. Why don't you repeat that?
You said that I couldn't take, that the court couldn't take judicial notice of it because basically it's an arguable thing, and it's not an incontrovertible thing. I'm asking.
I thought you asked me to take judicial notice of the fact that you don't go by the name Max Pritchett.
That I'm not the legal person, Max Pritchett.
Right, and that's not something I can take judicial notice of.
That's a fact, and it is an incontrovertible thing. Why can't you still take judicial notice?
Because it's not. And that's not what we're here for. We're not here to litigate by what name you want to go. I'm showing you the courtesy of asking the title or name by which you would like to be referred while the jury's in here. If you want to answer that, that's great. If you don't, I'm going to refer to you as Mr. Pritchett. And that may get you spun up in front of the jury. That generally doesn't help you. But if you want to tell me now, great. If you don't want to tell me now and don't want to sit down, we're wasting the juror's time again to accommodate you making this record about who you are or who you aren't, jurisdiction, admiralty, and things that actually don't have a bearing on what we need to do today and the next day and the day after. So tell me by what name or title you'd like to be referred.
I have an answer for that. I just have to make sure this court recognizes and understands the fact that I am not the legal person and legal name before me.
I don't recognize that, but I'm willing to refer to you by whatever name or title you would like.
So you're forcing me to be that?
I'm not forcing you to be anything. I'm just not recognizing something you want me to recognize. I don't force you to do anything. I am not recognizing the thing you would like to be recognized. In the same way, Ms. Mignot may have an objection. I may overrule it. I'm not forcing her to do anything. I just have disagreed with her.
So why is this court recognizing me as legal name Max Pritchett if there has been no evidence to prove that I own that name or claim that name as personal identification or consent to that legal record?
There is evidence of that. I don't know that it will necessarily be presented at trial, but we don't need to get through what the fingerprints show, your fingerprints are linked to, et cetera. But I'm pretty comfortable that Max XX Pritchett is a name that's associated with the guy standing in front of me with the red jumpsuit.
Please see the evidence.
Nope.
There's a claim that's being made. I have the right to see.
Okay.
And see the evidence.
That may be something that you want to argue. I don't present evidence or anything like that. The state does. So, all right. You've got 3 seconds to take a seat. If you choose not to take a seat, we're done this time of the merry-go-round, and we'll have you go back to lockup. You're going to take a seat?
Just before I take a seat, just to clarify, being that you are avoiding the claim and the evidence of why you're claiming me to be that legal person, Max Pritchett. I'm gonna clarify jurisdiction. You said it was jurisdiction of the state of Georgia. I just have to make sure you clarify some things that the Constitution speaks of 3 jurisdictions. Again, yesterday was our common law, equity, and admiralty. Which of these jurisdictions will operate?
We're done with that conversation. Do you want to give me a name or title you'd like me to use?
So this jurisdiction is not constitutional, is that what you're saying?
Mr. Pritchett, take a seat, please, or I'm going to ask the deputy to send you back to lockup. Okay, if you take him back, please. Because you didn't give me a different name to use.
Well, because you're still recognizing me. If I give you a different name or not, this court is still recognizing me as something that I did not.
This is a great opportunity to take a seat. Going once.
I'm still trying to understand the jurisdiction of this court.
Okay, well, I'm going to give you an opportunity to think more about it back in lockup, and we'll check in with you at lunchtime.
court is labeling me as disruptive because I'm not taking claim to something that they're forcing me to.
No, I'm labeling you as disruptive because you won't sit and you won't tell me by what name you'd like to go. So I am once again excusing Mr. Pritchett from these proceedings because despite my repeated entreaties, he declined to take a seat. And while he does go by the name Max Pritchett on all legal records with which I'm familiar, to include the indictment in this case, he declined to share with me by what name, title, or moniker he would like to go for purposes of these proceedings. I will note he indicated he was going to sit, which was a positive development. We'll see what happens when he next is brought out. Let's bring the jurors out, please. I guess it's only fitting they're making us wait now.
All right, the jurors.
You all can sit once you find a seat you want to sit in.
I'll do the president down for.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen. Sorry you had to sit around for so long. We had a couple logistical mix-ups. We're giving Deputy Gordon numbers 1 through 14 to count to next time. We thought one of you was missing and everyone was actually back there. And we had to work through something with one juror. But we are ready to go forward. I want to remind you that this is the case of the state of Georgia versus Tyrone Robinson and Max Pritchett. I chatted with Mr. Pritchett, and he continues to elect to not be present for these proceedings, but he is one of the named defendants. I'm going to give you some basic operating instructions, and then we will dive into the trial. First thing I want to talk about is notes. You are free to take notes. There's no requirement of note taking. There's no quiz at the end. What there is at the end is deliberations, when you all will be back in that room and you'll be asked to decide whether the state met its burden of proving beyond a reasonable doubt one or more of the charges in this case. And the way you decide that is by discussing with each other your feelings about the evidence, lack of evidence, conflicts in the evidence, strength of the evidence. Helping you remember what was said could be your notes. You will have all the exhibits that were admitted. So if there's a picture that someone shows of the house where the home invasion supposedly occurred, that picture will be with you during your deliberations. But what you won't have is a transcript of what the witnesses said. We don't record that. There is a transcript made by Ms. Rivers, but that official transcript takes weeks to prepare because Ms. Rivers has to line up with what she's taken down, with what was said, et cetera. So you will not have a transcript. That's why we give folks notepads. Don't try to write down everything that's said. You can't, unless you're a court reporter, and know how to use a funky machine that doesn't have letters on the buttons. But you'll also miss out on important things. One of your roles is the determiner of credibility, the believability of witnesses. And if you're buried in your notepad trying to write down everything, you're going to miss tells. You may have a witness who, when responding to one lawyer's questions, looks at you and is engaging. And the moment the questions get tricky, maybe she turns away or starts to get sweaty or who knows what. And you'll miss that if you're buried in writing things down. So feel free to take notes. Don't try to write everything down, and please keep your notes private until you begin your deliberations. You can use them as memory aids, and you can share them with your colleagues during deliberations, but not before then. All right, before I tell you more about the case and your role and my role and the lawyer's role, I need to administer a second oath. You guys are no longer potential jurors. You are about to be officially the jurors in the case of the state versus Pritchett and Robinson. So if you could all stand and raise your right hand. Do you swear or affirm that you shall well and truly try the issue that is formed by this bill of indictment between the state of Georgia and Max Pritchett and Tyrone Robinson, who are charged with home invasion, armed robbery, aggravated assault, aggravated battery, firearms offenses, and gang activity, and a true verdict give according to the evidence? Do each of you so swear or affirm? Yes. Does anyone not so swear or affirm? Okay, hands down, it's official. You are jurors. Thank you. So from here on out, your home away from home is the jury room. When you report each day, please go straight to the jury room. Don't come into the courtroom, and never enter the courtroom unless it's all 13 of you being ushered in by Deputy Gordon or one of his colleagues. When we're holding court, it's important that all of you hear everything that's said, not half of you, or we keep 7 down the hallway and 6 in here. So we'll have you all in here whenever we're presenting evidence or anything you need to consider as jurors. We try to run from 9 to 5. We were close to starting at 9. I think a couple jurors came in a little bit late, and then we thought we were missing one. We will stop around 5. It's not a bell goes off and we all run out of the building, because it's sort of contextual. If we're in the middle of a witness and that witness finishes at 4:50, and the next witness is a witness who's going to take an hour, we're not going to start that witness. So we may end a little bit early. If we've got a witness who might finish up at 5:05, and we believe the lawyer's time estimates, and you'll come to appreciate the believability of lawyers' time estimates as we go through this trial. But if we believe the lawyer's time estimate, we might go a little past 5 just to wrap that up. But it won't be, I say 5, but we really stop at 6. And we will take regular breaks. There's usually a morning break. You've kind of already had yours. It was an hour and a half long. We'll always break for lunch. That'll be about an hour, and we'll have an afternoon break. There will be other incidental breaks, either because you ask for them, because anytime one of you needs a timeout, you just need to let Deputy Gordon or me know, and we take a timeout. It could be a quick one. It might not be the full-blown 10 minutes, this or that, but just I need to stand up, or I got to go grab a water, and those waters in the jury room are for you, and you can bring the water out here if you need it. But we'll at least have morning, lunch, and afternoon break. During the course of the trial, it's important that the only people you talk to about, hey, what's going on, where should I go next, would be my staff and not the lawyers. The lawyers are going to treat you a little bit like you're radioactive, or they're radioactive and you're not. And that's nothing personal, but you can imagine how it would seem to a lawyer for one side if she's walking down the hallway and there's one of the lawyers and 3 jurors and you guys are laughing and this and that. And it may just be one of you said, where's the restroom? And the lawyer said something, told a funny restroom joke, whatever that would be. But we need to avoid that because there's an appearance that jurors and one side are talking. And that's not supposed to happen. It's all the jurors with everyone present. So if you're lost in the hallway or trying to figure out where a vending machine is, and here comes one of the lawyers and they see you and their eyes get big and they turn around, they're nice people, but they need to not interact with you that way. If they're going to be talking with you, it'll be here with me around as well. So I need to talk to you a little bit about the law, just some bedrock principles, and a little bit about the process. The main thing I want you to understand is that most of you haven't served on a jury before, and jury trials are not like what you saw on TV, if you've ever seen a jury trial. It will not occur during this trial that there'll be a witness on the stand and those doors burst open and someone comes in and says, I did it. That's not going to happen. It's going to be witnesses testifying, exhibits coming in. Some of it will be real exciting, some of it will be real dry and boring. That's the nature of trials, criminal or civil. We've talked about note-taking. I have told you that the defendants are charged with a number of offenses, that is, violations of the laws of Georgia. I'm going to read you now the indictment. I'm required by law to do that. This is long, it is dry, it has legalese in it. Don't worry about writing everything down. The document I'm holding in my hands will go back with you during your deliberations. You get the indictment, meaning you will receive the indictment. Both defendants, Mr. Pritchett and Mr. Robinson, are charged with almost all of the same offenses in this indictment. Count 1 charges, I should add this because you're going to have the indictment. Most of the counts charge 4 people. We've got Robinson and Pritchett, and then we have Ms. Riley and Ms. Kalish. They are not on trial before you now. They are named defendants, and you may well hear from them during this trial, but they are not on trial for this jury. So count 1 charges all 4 defendants, Kalish, Pritchett, Riley, and Robinson, with the offense of home invasion. And the allegation is that here in Fulton County on November 8th, 2019, those 4 defendants did commit the offense of home invasion in the first degree when, without authority and with the intent to commit a forcible felony therein, that forcible felony being armed robbery, and while in possession of a deadly weapon that is likely to or actually does result in serious bodily injury, those 4 defendants entered the dwelling house of Christian Riggs, while that dwelling house was occupied by Holden Carmody, Christian Hooper, Noah Walker, Rebecca Mears, Jackson Buckingham, Vikyat Gatani, and Christian Riggs. Count 2 charges the same 4 defendants with armed robbery, and the allegation is that here in Fulton on November 8th, 2019, the defendants did unlawfully, with the intent to commit theft, take a wallet, the property of Holden Carmody, from the person and presence of Holden Carmody by the use of a firearm, an offensive weapon. Count 3 is another charge of armed robbery. It alleges that all 4 defendants on that same date, November 8, 2019, in Fulton County, did unlawfully, with the intent to commit theft, take a wallet, the property of Christian Hooper, from the person and presence of Christian Hooper by use of a firearm. Count 4 is another count of armed robbery. It charges that the same 4 defendants on that same day in Fulton County did unlawfully, with the intent to commit theft, take a cellular telephone, the property of Noah Walker, from the person and immediate presence of Noah Walker by the use of a firearm. Count 5 charges the same 4 defendants with another count of armed robbery, same date, same location. The allegation is that the defendants did unlawfully with the intent to commit theft, take a cellular telephone, the property of Rebecca Mears, from the person in immediate presence of Ms. Mears by use of a firearm. Count 6 is another armed robbery allegation, same 4 defendants. And the allegation is that in the same place, on that same day, the defendants did unlawfully with the intent to commit theft, take shoes, the property of Jackson Buckingham, from the person in presence of Jackson Buckingham by use of a firearm. 7 is another count of armed robbery. The 4 defendants are alleged to have, on that same date, in that same place, unlawfully with the intent to commit theft, take the wallet and cellular telephone, property of Vikyat Gatani, from the person in immediate presence of Vikyat Gatani by use of a firearm. The final armed robbery count, which is count 8 of the indictment, alleges that the 4 defendants in Fulton on that same day did unlawfully with the intent to commit theft, take a laptop, keys, and wallet, the property of Christian Riggs, from the person in immediate presence of Mr. Riggs by use of a firearm. Count 9 is the first of several counts of aggravated assault. And the allegation is that all 4 defendants in Fulton County on November 8th, 2019, did unlawfully commit an assault upon Holden Carmody by pointing at, toward, and in direction of Mr. Carmody a firearm, that firearm being a deadly weapon. Count 10 is another aggravated assault charge, same 4 defendants, same place, same date. The allegation is that those defendants committed an assault upon Noah Walker by pointing at, toward, and in the direction of Mr. Walker with a firearm. Count 11, another aggravated assault, same 4 defendants on that date, in that place, allegedly did unlawfully commit an assault upon Rebecca Mears by pointing at, toward, and in the direction of Ms. Mears a firearm. Count 12, another aggravated assault, same defendants, same place, same date. The allegation is that the defendants unlawfully committed an assault upon Jackson Buckingham by pointing at, toward, and in his direction a firearm. Count 13, another aggravated assault, same defendants, same place and date. The allegation is that they unlawfully committed an assault upon Vikyat Gatani by pointing at, toward, and in the direction of Vikyat Gatani a firearm. 2 more aggravated assault counts. Count 14, same 4 defendants, same date, same place. The allegation is that the defendants unlawfully committed an assault upon Christian Riggs by pointing at him or towards or in his direction a firearm. And finally, for aggravated assaults, count 15, the allegation is that the same 4 defendants committed an assault upon Christian Hooper by pointing at, toward, and in the direction of Mr. Hooper with a firearm. Count 16 alleges aggravated battery. And the allegation is that the 4 defendants in Fulton County on November 8th, 2019, did maliciously cause bodily harm to Vikyat Gatani by fracturing his skull, causing permanent scarring. This having been accomplished by pistol whipping him and stomping on his head. Count 17 alleges that these 4 defendants committed a second offense of aggravated battery. And the allegation is that on that same day, in the same place, the defendants did maliciously cause bodily harm to Christian Riggs by seriously disfiguring his nose, this having been accomplished by punching him in the face. Count 18 charges all 4 defendants with the offense of participation in criminal street gang activity. The allegation is that on November 8th, 2019, here in Fulton County, the defendants did unlawfully, while associated with a criminal street gang, participate in criminal gang activity through the commission of at least one of the named offenses, specifically armed robbery, aggravated assault, aggravated battery, and home invasion. Count 19 charges all 4 defendants with possession of a firearm during commission of a felony. And the allegation is that on November 8th, 2019, here in Fulton County, the 4 defendants did unlawfully have on and within arm's reach an assault-style pistol, which is a firearm, during the commission of at least one of the following felonies involving Christian Riggs, specifically home invasion, armed robbery, aggravated battery, and aggravated assault with a deadly weapon. And finally, count 20 charges Mr. Pritchett only with possession of a firearm by a first offender probationer. And the allegation is that on November 8th, 2019, here in Fulton County, Mr. Pritchett did knowingly and without lawful authority possess an assault-style pistol, having been sentenced pursuant to the First Offender Act to a term of probation on December 10th, 2018, in indictment number 18 SC 158229. Now, ladies and gentlemen, I just read to you a whole bunch, and it is proof of nothing. It is evidence of nothing. It's the way in which charges were brought against these four defendants. It should not be considered by you as evidence or implication of guilt of any crime whatsoever. Mr. Robinson and Mr. Pritchett are before you with the presumption of innocence in their favor. And this presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that these defendants are guilty of one or more of the crimes charged. A defendant should not be convicted of any crime unless each element of the crime is proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt, stays with the state throughout the trial. There's not a point where I hit a buzzer or blow a whistle and say, all right, we've heard enough from the state. Now let's hear from the defense. The defense has no burden in this case. Mr. Robinson and Mr. Pritchett don't have to prove anything at all. They don't have to mount a defense. Ms. Mignot doesn't need to say anything during this trial. I bet she will, but that's only because she's choosing to be a zealous advocate for her client and that she thinks that zealous advocacy involves saying some things to you. But there's no burden on Mr. Robinson or Mr. Pritchett to prove or say or do anything during this trial. Proof beyond a reasonable doubt does not mean the state must prove a defendant's guilt beyond all doubt or to some mathematical certainty. Reasonable doubt means just what it says. It's a doubt based upon common sense and reason. It's not a vague, arbitrary, or speculative doubt. It's a doubt for which a reason can be given, and that's a reason that arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. If, after giving careful consideration to the evidence in this case, you find that your mind is wavering, unsettled, or unsatisfied, that is reasonable doubt, and you must acquit the defendant or defendants. But if no reasonable doubt exists in your mind about the defendant's guilt, you would be authorized to convict. Now, the basic structure of the trial is, in a moment, I will be quiet, and the parties will be given an opportunity to present what we call opening statements. These are a preview of what the lawyers think this case is about. It is not evidence. In fact, nothing the lawyers ever say in this trial is evidence. What witnesses say under oath is evidence, and exhibits that are admitted is evidence. That's it. Not what the lawyers say, not what I say. When the opening statements are done, the lawyers have shared with you what they think this case will show or will fail to show. Then I'll turn to Mr. Hiles and ask him to call his first witness. He'll call Jane Doe. She'll come up here. And once Jane Doe is sworn in and begins answering her first question, you'll begin receiving evidence. Evidence begins when that first witness starts talking under oath. That's when you start hearing the facts of the case. Evidence will also come to you in the form of numbered exhibits, like I mentioned, a picture or evidence that was collected. Anything that's admitted, given a number, is likely going to go back with you for your deliberations. At some point, when I ask Mr. Hiles or Ms. Green to call the next witness, one of them will say, "Judge, the state rests." That will complete their case in chief. And I will turn to Ms. Mignot and ask her if she's going to call any witnesses. She may say, "I've got none, I've got a bunch." But again, no burden on the defense. So the trial may be done for evidentiary purposes when the state rests. But a defendant has an absolute right to present evidence if he wants to do that. And Ms. Mignot will be given that opportunity to do so on behalf of her client. When the evidence is closed, when everyone has said, "I rest," then we have what we call closing arguments or summations. And the lawyers will get back in front of you and they'll be given an opportunity to persuade you to decide the case in their favor. They will argue to you, this is what the evidence showed, or it failed to show, this witness isn't believable or is believable. You should feel free to be persuaded by the lawyers, but don't take what they say as evidence. You decide what the evidence is. If they're telling you, man, it was raining that night, and you don't think it was raining, then they didn't persuade you of that. But the fact that the lawyer said it doesn't make it so. When the lawyers are done with their closing arguments, I will give you more law that you must apply to the case. And that'll be when I tell you the elements of the crimes and things like that. Excuse me. After all that, you will retire to the jury room and begin your deliberations. Before then, you should not talk about the case with each other. And that may seem a little counterintuitive. Like, Judge, we have a day's worth of evidence. Shouldn't we already be saying, how do you feel about this? Answer no, because you don't have all the evidence. And more importantly, you don't even know the law that you have to apply. What are the elements of home invasion? You don't know. So how do you know if the state has met its burden of proving home invasion beyond a reasonable doubt until I tell you the state has to prove A, B, C, and D? You've got that framework, and then you begin to drape the evidence over it to say, I'm convinced beyond a reasonable doubt that happened, or I'm not. Element 3, there was no evidence of that, or the evidence in conflict. So resist the temptation to talk about the case amongst yourselves before that point of beginning your deliberations at the end of the trial. During trial, the attorneys have a right to object to the evidence that is being presented. This you've seen on TV, someone, objection, hearsay. You'll hear things like that during the trial. I need to rule on those objections. I will sustain the objection, which means the question needs to be changed or withdrawn, or I'll overrule the objection, which means the lawyer can keep on going in the direction she was going. You should not consider my rulings as any type of commentary on good lawyers, bad lawyers, good evidence, bad evidence, someone's doing a better job. I'm simply applying the rules of evidence as I understand them to the objections that are being raised. Every once in a while, an objection will be raised only after the witness has started to answer, because the question was a neutral question. Lawyer heard it and said, oh, that's a fair question. And then a witness strays into an area that might be legally objectionable. And so a lawyer could say, objection, judge, hearsay, whatever it is, move to strike. And that's a request to have me tell you to disregard what the witness said. That may seem like an unfair task. Judge, I heard what the guy said. You may even have written it down. If I tell you to disregard it, you should cross it out. And if for some reason during your deliberations, one of your group says, hey, remember that guy who talked about what color shirt that woman was wearing during the situation? And that was what I told you to disregard. I need you to police that and say, hey, we're not supposed to consider that. Oh, I promise you, if it is something fundamental to your deliberations that sneaks out, I won't tell you to disregard that. That's when you're going to hear a lawyer say the dreaded words, Judge, I have a motion. What that means to you all is you get a bonus break, because a motion is usually something that we need to talk about outside your presence. I can handle the objections. Lawyer can say it's hearsay. Here's why it's hearsay. It's not hearsay. And you can listen to all that. But a motion usually involves a lawyer saying, I believe the witness just did X, and here's the problem. Or the witness is about to say these things that the jury shouldn't hear. They need to talk about that outside your presence. So this notion of you needing to unremember what you were told is actually a fairly bearable burden, because it's usually something that is almost a non sequitur to the trial. But if it was improperly admitted, it needs to be stricken. And so it could well be that, the person said, oh, someone told me it was cold that night. Well, it's hearsay. Someone told you that, move to strike. It doesn't matter whether it was cold that night or not. And so you ignore that it was cold. It never comes up again. I've talked about my role and the lawyer's role. I rule on their motions, and they make motions and objections. They ask the questions, etc. You've got an important role as well. You are the fact finders. You are deciding what happened in this case. And while I will instruct you on the laws that you have to apply to the facts, you'll be deciding what happened in this case and what the state has proven or failed to prove. And in doing that, you will necessarily be deciding the credibility or believability of the witnesses who appear before you. And in deciding credibility, you are free to consider all the facts and circumstances of the case, as well as the manner in which the witness testifies. That's you watching the witness as she's answering questions, and the witness's interest or lack of interest in the outcome of the case. Now, In fulfilling your role as the fact finder, you may have questions sometimes. Questions usually come from the lawyers, answers come from the witnesses. And the lawyers generally do a pretty good job of covering the landscape so that when a witness leaves the courtroom, like, okay, I understand what was going on there. It is perfectly natural and not at all uncommon for you to have a question that wasn't answered by the lawyer's questions. And the way we scratch that itch is by having you, and they're not out there right now, but there's going to be a big stack of note cards on the little shelf there. And you should feel free to write down any question you've got for each witness. And we'll do this for every witness. When the lawyers are done with their questions, I'll turn to you to ask you if you've got any questions. And if you do, you don't raise your hand and belt the question out, but you write it down, as many questions as you can fit legibly on one side of the card. Don't put your name on it. Doesn't matter whose question it is. It's a juror question. Deputy Gordon will collect those questions. I'll review them with the lawyers because just like a lawyer can ask a question that's an objectionable question, jurors can as well. And all the legally proper questions I will pose to the witness. So you will get your question asked if it's a legally appropriate question. The lawyers will get a follow-up after that because most times you guys ask a really interesting question that the lawyers didn't think about or they would have asked it. And so they have some follow-up. But I encourage you to do that because that is your only outlet to getting questions answered. It is improper and will cause a mistrial and get the infractor into a whole lot of trouble if you do outside research. If it is really important for you to know what the weather was like the day of the incident, write it down on a card, and for the appropriate witness, that witness can say, I don't remember, or it was raining, or it was sunny, or whatever's going on. Do not go online and look up on the Farmer's Almanac what the weather was like in Atlanta on November 8th, 2019. That is outside research. That's information you are bringing into your deliberations that the lawyers didn't get a chance to object to or rebut or supplement. And I certainly didn't get to tell you that's not even admissible, that's irrelevant or whatnot. So this has been the downfall of many a trial in America since the advent of cell phones and Google. People get online, hey, I'm going to look this thing up. The lawyer used this word or this expert witness used a word. I don't know what it means. And no one explained it. So I need to figure it out. And you go back in the jury room and you tell everyone, I looked up the word sanction, and sanction means to prohibit. It sure does. It also means to authorize. And you've introduced the wrong meaning of the word for the purpose of this trial. And the jury just took a left turn when they should have taken a right turn. So if you've got questions, write them down. And if they're proper questions, they will be posed to the witness. You may, during the course of this trial, receive evidence that one or the other defendant, Robinson or Pritchett, has been involved in other acts that are not charged in this indictment. Should you receive that information, it will be for a very limited purpose and it will be for that defendant only. And you'll be told before it happens. You don't need to be on the lookout for it, but I'll be giving you limiting instructions that the evidence you're about to hear, if you credit it, should be considered only as to Mr. Pritchett or Mr. Robinson and not the other. And I'll let you know the purposes to which that evidence must be limited. 99% of the evidence is to be used in whatever way you think is appropriate, but there may, during the course of this trial, be some evidence that is to be used only for limited purposes and or against only one of the two defendants. It is critical that you pay close attention during the trial. There's no rewind button. If you come in tomorrow saying, hey, that witness from yesterday, she was kind of hard to hear. Could you bring her back? No, can't do that. So if at any point you cannot see, you cannot hear, or you just need a break because we've been going on too long, stop us. You don't have to stand up and yell, stop, but just like make a gesture, get the deputies' attention, get mine. We'll have a witness speak up more, speak into the microphone, shift the microphones around, or give you the break if that's what you need, because you all need to receive this evidence. I don't, the lawyers don't, you do. So be comfortable, let us know if there's anything we can do to address it, any discomfort that you have. It is critical that you approach this process with an open mind and avoid the temptation to begin deciding the case, in particular as a group, that's prohibited, but even individually early on in the trial. You need to decide this case based only on the evidence presented here in court, no outside research, but you should make your decisions only after you've received all the evidence and not how that first witness was amazing. I know what this case is all about. You don't, you've heard from one witness, and there's much more to go. And again, you don't know the law that you must apply to the facts as you find them to be. There will be some media coverage of this case, as you may have noticed when you walked into the courtroom. So you need to remain vigilant as you're driving home. If you start to hear a story on the radio, or you're at home and you're watching the news and they say, next up, trial of Max Pritchett or Tyrone Robinson or home invasion case, change the channel. Don't watch that news coverage because that is a reporter synthesis of what he or she thinks the evidence was all about. And they're not a juror. Don't know that they even got it right. I've read some stories and I sometimes wonder, were you in the same courtroom I was in? You need to be on a little bit of a news blackout. That means that you need to be thoughtful about how you interact with people close to you in your life, because you may have a friend or a family member who said, hey, I just saw this story. Is that your trial? Don't tell me what you saw. I don't want to engage with you on that. You may want to engage with them, but you can't engage with them at that point because they'll say, hey, I saw this story and I can't believe this happened. You actually know what happened because you were here in court. So this is a little trickier than our usual trials where there's zero coverage. There'll be a little bit here, and you need to isolate yourself from that. It is not to the level where I need to sequester you. I have had a trial where the jurors had to go to a hotel every night and stay in that hotel with no TVs and come back to court. That's not this by any stretch of the imagination, but just be aware. And when you are interacting with people outside of court and they ask you how it's going, say, it's great, full stop. How about those Braves? Or you can watch the NFL draft or whatever it is you want to talk about. Don't talk about this and tell folks you can't really engage with them on it. When the trial is over, it's open season. You want to write a book about it. You want to do some pottery based on the trial. Anything you want to do, you're free to do. The news blackout, you can look at all the stories you didn't get to watch. You can go online, but that's after you're done. Whatever verdict you reach or you don't reach a verdict, when I excuse you at the end of the trial, it's open season. Between now and then, you're going to be kind of boring amongst your friends when it comes to, hey, how's your trial going? Can't tell you about it. Judge is great. That's it. So that, my friends, constitutes my preliminary instructions to you all. I fear that our camera went out again, just as we're going to shift to, let me see if I can bring it back. We have a camera above your heads that captures what's going in the well so that folks can see the lawyers but not see you. And as I was talking with you, some of you noticed because you suddenly looked at the screen because what was on the screen shifted. And that camera, there's a computer, I think at someone's feet down there, whatever it is, don't kick it if you see a computer, but there's some device that controls it that's in the jury box. And so IT can't fix it while you guys are there. I'm going to see if I can reconnect it. And then either way, we're going to go forward with the state's opening. But give me 1 second. It's back. Voila, Mr. Hiles.
1 second to share the screen here. This is the state of Georgia versus Max Pritchett, Tyrone Robinson, Lindsay Kalish, and Lauren Riley. It's the trial of Max Pritchett and Tyrone Robinson. But as you've heard, both Ms. Kalish and Ms. Riley are charged with the exact same offenses as their co-defendants. The reason they're not before you right now is because you are going to hear from them during this trial.
Technical issues?
Of course.
Of course. I got the jury camera back on.
Basically, a case about gangs, greed, guns, and lust. It's a collision of two worlds. You're going to see two privileged girls that grew up in North Fulton who were obsessed with the studio life, the gang life, the YSL criminal street gang. They're privileged girls lusting after a life that was not theirs, that they did not need to be a part of. And then you will see that this was also an opportunity of gang members to take not advantage of these girls. These girls put themselves in the position they did, but to seize on an opportunity to rob some of their friends of drugs and of cash. Now, this took place on November 8th, 2019. Some of the planning started on the late hours of November 7th, going into the morning of November 8th. But Lauren Riley, Lindsay Kalish, Tyrone Robinson, and Max Pritchett together committed a home invasion at 1040 Wiley Street just after 2 a.m. Now, not all of them were robbed. Each one played a different role. But because this was a conspiracy, this was an agreement to commit a crime, an armed robbery, a home invasion, each of them is equally responsible for the actions of the others. And that's what the evidence will show. And that's what you will learn. Lauren and Lindsay, they first arrived at the house. Only one of them knows one of the victims, Christian Riggs, and Christian Hooper. And they go in, they scout the party, not knowing anyone else, but they take pictures of where the drugs are located and then send them back, that picture back to Pritchett and Robinson, who are waiting armed in the car. The girls leave, leaving the house unlocked, and then Pritchett and Robinson come in. Pritchett and Robinson were masked. They were wearing clothes, backpack, guns. There's not going to be a single victim that is going to point to the two individuals that are charged in that case and be able, those are the two that robbed them. All of them were consistent when this incident happened, and are consistent now that they couldn't pick anybody out. They just know that they were robbed by two men wielding AR-style pistols, wearing what they described as purge masks from the movie The Purge. 7 victims inside the Airbnb, which was rented by Christian Riggs, Jackson Heil, and Holden Carney. You will see on the indictment, Mr. Heil, he is charged as Jackson's Buckingham. He actually has four names, 2 middle names, and so Buckingham on his ID appeared as to be his last, and no one bothered to look at that second line. But these are the defendants in this case, is what this case is about, not the victims. The defendants made the decision to beat multiple victims as they stormed the house, masked and armed. Once all the evidence is presented, there's going to be no question as to the key facts. The defendants, Mr. Robinson, Mr. Pritchett, Ms. Riley, and Ms. Kalish were all present at this home invasion. And all the evidence will agree with that. You'll hear it both in testimony, but you'll see it also corroborated in records, Instagram records, cell phone dumps, the conversations in between the execution of this home invasion and the individuals getting caught. They were discussing how they were going to get the proceeds from the robbery, how they were going to sell the drugs that were stolen, referring to each and every person by the names that they knew by. And we'll talk about the names of these individuals by shortly. But what you'll see with these defendants, they committed this as a member, Robinson and Pritchett, as members of the YSL, Young Slime Life, criminal street gang. In the particular set that they were a part of, they referred to themselves as one of one. You'll see the defendants planned this home invasion of condo of young Vance, who is a gang member and a rapper who goes by the name of Boss Coleman, and then returned after the invasion back to that same residence where the proceeds were dumped out and discussed. Mr. Coleman actually is not charged. As this goes on, you will see that yes, he was a co-conspirator. He was involved in the planning. But this case is about the four that are charged, not who isn't. Here's what I expect the evidence to show. So, Mayfair condominiums, that's where Boss Coleman, Young Vance, that's where he lives. On November 7th of 2019, you will see conversations that he invites Lauren Riley over to the house where he discusses Pritchett being at the house with him, and that he also is informed that Lindsay is with Lauren and that Pritchett wishes for Lindsay to come over together. So the individuals leave from the Mayfair condominiums. They go to 1040 Wiley Street, which is in Fulton County, which is where the home invasion, the Airbnb rented by the individuals is located. Crimes are committed, and they go directly back to the Mayfair condominiums. All right. Riley and Kalish were the ones invited to the condominiums. When they arrive, they see Max Pritchett, who goes by the name of Rick Rare. That's his nickname, I guess it's his stage name, but it's how he is known amongst his peers. It's how he holds himself out on the internet. That's his Instagram name. Voss Coleman, Young Vance is there, but those are the only two individuals that Lindsay and Lauren know. There are other individuals present. I don't know who they were, and Lindsay and Lauren were not able to tell me or the police who they were. But while there, one of the girls receives a Snapchat, a message through the Snapchat application of a party that's going on at 1040 Wiley Street. They get a picture of drugs. I think they described it as what they thought was ketamine and what they knew to be large amounts of THC edibles. And instead of saying to Lindsay, let's go to this party, what Lauren says out loud is that let's hit a lick, let's commit a robbery. And at that point, the individuals that are there start conspiring, decide who's going to go along. It's decided that Pritchett is going to be one of the members that goes wielding a firearm, but they begin looking for another individual. That individual is Tyrone Robinson. But Tyrone Robinson is known only to the girls, Lindsay and Lauren, as Baby Slapped. You will hear the significance of that name, SLAP, standing for slime love all the time, which is a common greeting of the YSL criminal street gang to one another. And you'll see the significance it holds in his involvement inside that particular criminal street gang. But Baby Slap is called. He arrives at the house and Mayfair condominiums, and then all four then go to commit this armed robbery. So Riley, she drives her Mercedes that her parents bought her, occupied by Lindsay and Pritchett, as well as Robinson. Kalish, you'll see the video of the two girls entering through the front door. You will see the text messages that Riley actually sends to Lindsay's phone. And that's an important aspect of this case, because what you're going to hear about Pritchett is that Pritchett was involved in another home invasion style case very similar to this. And the way that he was caught, and the way that his co-defendants were caught, was to cell site location information. And so this time, Pritchett was insistent that his phone not go to the front scene of the crime weapons. When they get there, they leave the house, both Robinson's phone and both Pritchett's phone remain at the Mayfair or Wayfair condominiums. This is corroborated through cell site location information, because prior to the armed robbery, there is activity on the cell site closest to that condominium on Mr. Robinson's home. And the duration of the robbery, there's no activity on that phone. But around the time that it said that they returned to the house, you start seeing more activity on that phone, showing that it's still pinging in that same area close to the Wayfair condominiums. You'll see Riley fleeing, you'll see individuals coming in, and you can even hear the screaming in the initial attack as the armed gunman, Pritchett and Robinson, begin to hit the victims as they enter the house. They steal the wallets, phones, and the edibles, THC edibles that were at the party. And then it was 2:20 a.m. the 911 call was received by dispatch. You're going to hear from the victims in their perspective what happened. You're going to hear from all 7 named victims in the indictment. This was an Airbnb that was rented for a Halloween party. 2 of the individuals were coming in town, traveling through Atlanta on their way to Houston to go to a Travis Scott concert. When they got together with another friend and decided that on their stay over, or get together, pool their money, rent the Airbnb and host a party. Not everybody at this party was close friends with each other. Each person seemed to have a close friend there, but not everybody was close with each other. But everybody had the confidence that who all was there, they knew they were close to someone they trusted. So there was some sort of circle of trust for what was going on at this party. The party was all but over when Riley and Callis showed up. And that's ultimately what broke this case, is that everybody at the party got a sense of unease when Lauren and Callis came in looking for, they didn't say hello to anybody. They just went all around the house like they were scoping it out. They were scoping, they were scouting. Only one person there knew Riley and Callis, Christian Cooper. And he had introduced Christian Riggs to Callis. But all the people at the party found the behavior to be odd. You're going to hear that there was a heavy presence of drugs at the party. Not going to shy away from that, but I honestly and truly believe, and I think you will see, it was that presence of drugs that was the motive for this robbery. That is what was going to be taken. Not everybody was partaking. Some people were drinking. Some people were using drugs. Some people were partaking in either. You'll also hear that everyone was caught off guard. When the 2 gunmen entered, they were wearing masks, and the individuals thought that maybe this is just some sort of prank continuing on the Halloween party. But as soon as they came through, the first person was immediately struck in the head. And that's when the reality of the situation came about. Some of the victims tried to confront the assailants, and they were dealt with violence. But Vic, Mr. Gacani, the DJ, he was the one person that was not confronted. He was beat without mercy. He would hear from all of the people that Mr. Gacani was begging, pleading with the individuals, taking them to go hitting them with their gun. He's the one that sustained the worst injuries of all. So most of the people who were there, they're not even going to be able to tell you the race of the individuals that attacked them, that robbed them. What you'll hear is that when they realized that it was a robbery, they did everything they could to not make eye contact, to stay away, make as little presence as possible. There are a few of the individuals who were able to identify the race. Now, most of those are people who actually physically engaged with the assailants. They were able to see the hands that they were hit with, and they were able to see the neck area that was left uncovered in between the hoodie and the masks. But other than that, that's the only clue as to the race or the identity that the members, the victims are going to be able to tell. Most of the folks that were there were able to see the firearms. Like I said, some people just went into a cocoon and did not want to be present. But all that saw the firearms described them as AR or AK style pistols that looked to be like some sort of military grade. So this occurred on November 8th, 2019. The lead investigator, Carlos Maldonado, was not assigned the case until November 10th, 2019. And that's really when the investigation took off. Maldonado immediately interviewed all the victims. And he centered in on Lauren and Lindsay as being the facilitators of this armed robbery, this home invasion. He was able to identify Lauren Riley through Christian Hooper, who had gone to high school with her. Once he identified who she was, he was also able to obtain her Instagram handle through Christian Hooper, and saw that Lindsay Kalish was consistently with her. I mean, they were inseparable at the time. But Kalish was easily identifiable as the second girl to enter that house based off of ring footage that was provided to the officers. The big break in the case comes on November 16th, 2019. That is when Lindsay and Lauren are called to APD headquarters to actually give an interview. They voluntarily show up. Initially, they are not under arrest. And initially, they're not truthful. They do not give a full account of what happens. They act as if they are victims. They lie about their involvement in this case. They're not truthful at all. They try to distance themselves. But Investigator Maldonado was armed with a search warrant for their cell phones when they showed up. He already had the probable cause to believe they were involved, but maybe not to arrest them. So he immediately gets their phones. They are able to get into them with passcodes, not having to wait for assistance from the cyber department. And it is quickly apparent that they were involved in the planning. They're discussing how they are going to, what they're going to tell police, how they will distance themselves from it. They're also discussing whether or not they should flee. Should they even go talk to police, or should they get an attorney? But it's very apparent based off the messages between them that they were involved. A lot of what they told Maldonado is what I have described to you. They didn't know these individuals as Max Pritchett, as Haas Coleman, as Tyrone Robinson. They knew them as young bands, Rick Rayer, and Baby Slap. They said Baby Slap by name consistently. Now, when asking with help to identify Baby Slap, when the couch is like, well, if you give me Instagram, I think I can find him. I think she initially says something like his name is Baby Slime, or his Instagram handle is Baby Slime. I know him as Baby Slap, and she can't find it initially. It's not till Maldonado confers with Lauren Riley that he's able to actually confirm the Instagram handle of Baby Slap, which was at the time 1100 Baby Slap. 1100, again, being a reference to the 1100 block of Iris Street, which is the, I guess, home base of where that one-of-one set of YSL operates out. So, knowing that now Kalish and Riley have identified Pritchett and Robinson as the gunman, luckily he doesn't just go on what the girls told him. He follows this up to find some corroborating information. He gets search warrants for all of the parties involved for their Instagram records, which shows not only pictures, but also communications through direct messaging. It showed video calls of who they were communicating with through the app, and really a footprint of who these individuals were about. You'll also see that Pritchett and Robinson have deleted most of their accounts. And you will see that there was a conversation between Lindsay and Baby Slat, Tyrone Robinson, that was had discussing the selling of the proceeds of the armed robbery, which both parties had deleted. However, it was Lindsay's cell phone that maintained that data and maintained that conversation through the unique identifying numbers of their Instagram accounts. She deleted it, they deleted it from Instagram, she did not delete it from her messaging app on the phone that she was using to communicate through Instagram. Phone searches for Kalish, Riley, and Robinson were done. Evidence of the gang membership was abundant on Robinson's phone dump. It was really corroborating what his Instagram meant, what was being posted on his Instagram. The little bit was left. And the cell location records for Pritchett and Robinson were obtained as well. The records for Pritchett will show that he was using a voice over IP address to communicate with his cell phone. So whenever he communicated, it would not activate the cell site towers, which were his downfall in this other case that he was structured. Now, there is no smoking gun saying, we did this, I did this, this is how the plan happened, but it's discussions of things that would only be known to the people that committed these robberies that are contained in these conversations that corroborate what Lindsay and Lauren told the police officers. But I think what's important is not necessarily what Lindsay and Lauren told police, but it's what's important is what they told each other between the robbery occurring and them getting caught. They were consistently talking to each other about, do you think Rick and Baby Slat are actually gonna pay us? Hey, please call Baby Slat and tell them we're giving money. Lauren Riley is actually so persistent trying to get the money from young bands that he outright blocks her. And you see these conversations dwindle as the girls realize they're being ignored, that they're likely not going to get the proceeds from the robbery. The sale of the edibles is where they were hoping to get cash from. And you'll hear them tell you this, but you'll also see it in how they discussed it without any knowledge that police were looking at them or that they may have been in any sort of trouble. You see the Instagram conversation that I just talked to you about. Here's what I really want to talk to you about. You might not like the witnesses in this case. A lot of what Lauren and Lindsay said to each other, it's disgusting. It's gross. And the message that I'm talking about, I put it is that once the girls, I don't think the girls knew that Mr. Pritchett and Mr. Robinson would be pistol whipping people, but they found out later that the individuals were beat up. And the messages between each other was, why is it so hot that the boys were beating people up? The response was like, so sexy. Even to the point that she said, man, I want my break. And that is what is said between them and their thoughts on this robbery initially. So I want to prepare you for that. Both of them are facing the same criminal charges as the two men that are sitting trial right now. Neither of them have been made any offers to resolve their cases, nor have they been made promises of anything of resolving their cases for their choice to testify. I think you will hear from both of them that they are hoping for grace, that they are hoping for a lighter sentence in testifying. But as they sit right now, they sit in the same position as their two co-defendants. Now, Lauren will hear that both of these individuals got a bond over my objection. They were granted a bond. Lauren, when she was out, she gets rearrested. She's going to tell you she started dating another YSL member, another young Swine Life member. She gets in trouble with him. That relationship fizzles out. And then she dates a second higher ranking YSL member, which gives her some inside knowledge of the workings of the criminal street gang. Not a lot, but some. And she's ultimately rearrested. When you hear from Lauren, she will be in a jumpsuit, in handcuffs. And she has been shown no favoritism. You're going to hear from a gang expert, JP Miller. I say expert in the sense that he is going to explain to you the knowledge, share with you his knowledge of how the gangs operate in the state, what it means to be a hybrid gang, what it means to be a set of a particular gang, and how these gangs commit crimes to truly further their interests, whether that be in a flagrant manner, how it intertwines with the music industry, how they're part and parcel. And one of the things he's going to really talk to you about is the importance of colors to gangs. That's kind of faded for most traditional gangs, but YSL, they still cling tightly to their color coordination. Well, it's slime green. You'll hear about that and you'll see the interplay of that in this case as it is unfolded to. Burden of proof, all on me, all on the state. Never shifts. It is on me to prove this case, each and every element, beyond a reasonable doubt. That's not some unsurmountable task. If it was, there would never be convictions. What it means, and the judge will tell you, literally the definition is beyond a reasonable doubt. A reasonable doubt is that doubt of a fair-minded and impartial juror honestly seeking the truth. That's what I'm asking you all to do as jurors. Honestly seek the truth. I do want to mention that regardless of whether Mr. Pritchett decides he wants to participate in this trial, that doesn't change the burden of proof on me. I still have to prove every element of every charge that he is charged with. He has a right not to participate. He does not have to say or do anything. So please keep that in mind as well. Hold me to my burden, which I feel confident I will meet. All right, remember, the victim and the witnesses are not the ones on trial. You might not like all of them. They might come from a different place than you've come from. So keep that in mind. This is about the actions of Tyron and Max Pritchett. But there's no justification for robbing. There's certainly no justification for violence associated with physical violence. You already have the upper hand. And there's no excuse for the defendant's conduct. No excuse, no justification. This case is about an unjustified home invasion, uncalled for violence, innocent victims, and a gang that conspires to commit violent crimes. The evidence will be clear about all of them. Proof I've told you about. And I will also state that these crimes were committed by members of YSL, and that this was a conspiracy and part of YSL. As a conspiracy and part of YSL, each defendant is guilty of all the crimes, regardless of who hit who or who took what property. It doesn't matter if one of the gunmen was the only person beating the victims. Everybody as part of this conspiracy, including Lauren and Lindsay, are guilty of those same crimes. So there is no, oh, well, that was that person that took this cell phone, but I might have taken this cell phone. I don't know which one took whose cell phone. It doesn't matter. This was a conspiracy to commit these crimes as part of a gang, as part of a illegal enterprise. Once this evidence is done, it's presented, we'll have our closing arguments in which I will ask you to return to the jury room and give a verdict of guilty on all counts.
Thank you, Mr. Hiles. If you'll stop your screen share, which you did, Ms. Mignot, your opportunity, should you wish to give an opening on behalf of Mr. Robinson.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Once again, my name is Marcia Mignot. I am the attorney for Mr. Tyrone Robinson. I have the pleasure of representing him as he sits here innocent of the charges that he is facing. I've been practicing law now approximately 21 years. And I wear a mask not as a political statement or a fashion statement, but because I have a special needs type 1 diabetic. And what might be a common cold or a runny nose for me can be an ICU visit for him. Thank you all for your patience as I put it on and off so that you know that it's not part of a gimmick or a game. If I limit exposure as much as I can protect my son. This case is about more than just young people at a party being robbed. I submit to you that the evidence is going to show Lauren Riley and Lindsay Kalish went to an individual's condominium by the name of Young Bands. Now, Young Bands is a rapper that has signed a contract for music. So as we all know from our experience, rappers can make a lot of money. So Young Bands is making very good money, and his home is at a Buckhead high-rise. At that apartment, Lindsay and Lauren go in on November the 7th of 2019. And they're there hanging out because they know Young Bands very well. And somehow, someone sends a Snapchat to one of the girls saying, Chris is having a party. Chris is not having a regular party. This is not a bunch of teenagers that's gonna sit down and play games, maybe drink some beer, and we all know how we were when we were teenagers. Maybe somebody might have some marijuana. This was a drug party. And this Airbnb has been an eyesore for the neighborhood for quite some time. Because what do they do there? They rent it and they have drug parties. These are not innocent, we just go to college students. These are drug dealers. These are the individuals that we worry about as parents at night, because our child could end up at a party consuming ketamine, marijuana, pills, and we get that dreadful phone call from the morgue. Your child's not coming back home. That's who these 7 individuals that the state is going to present to you as choir boy victims are. Lauren and Lindsay came up with a plan. They concocted a plan because these girls are living a double life. In one of their lives, they're going to college, they have scholarships, they're playing lacrosse, and in their other lives, they're criminals. They're getting arrested. They're doing drugs. And what did they do? They said, Chris, who we know to be a drug dealer. That's what the evidence is gonna show. They are telling the detective when they finally start telling the truth. Chris is a drug dealer. They know he's a drug dealer. But Chris is not so dangerous. We can rob Chris because we know Chris. We know someone that went to school with Chris. They're gonna trust us. So we're gonna rob what we believe to be an easy target. They show the Snapchat to young bands, somebody they refer to as Rick Rare, Lauren is there, and Lindsay is there. And guess who was not there when the plan was concocted? That gentleman, Mr. Robinson. That's what they told the state. In fact, the evidence is going to show that Mr. Hiles is asking Lindsay in an interrogation room with a bunch of people in there. So was baby Slat there when the plan was being concocted? No, it wasn't there. That's not good for the state. Because the state knows there were 4 people involved, 2 girls and 2 other males. Unfortunately, they caught up with who they thought it was. They could only get one of them in. Mr. Pritchett. Because he has a relationship with Lauren and Lindsay. He knows them very well. They don't know my client. And they've already told Mr. Hiles he wasn't present. The conversation doesn't stop there. Because Mr. Hiles then says, so how does baby Slat get into this? Oh, I see. Remember, we're talking about manipulative people who are living a double life. Ah, I get it. I know what they want me to say. Baby Slat, oh yeah, baby Slat was there too. Because they need a 4th guy. Because the community wants to know where is the 2nd guy that was there that night. You're going to see the evidence in this case that Lindsay and Riley also told Mr. Hiles, hey, guess what? This is not our first one. Lauren had talked about robbing somebody else by the name of Maddie. Another rap gang, whatever Maddie does, or sells drugs just like Chris. But I thought, oh, no, we're not gonna rob Maddie. Because guess what? That drug dealer, Maddie, is probably way more dangerous and she doesn't know him like she knows Chris. Chris is an easy target. Chris is probably not gonna call the cops. Because what are you gonna do? Call the police to say, hey, guess what? I was giving underage minors alcohol. I was giving them a bunch of ketamine. I was giving them drugs. I was giving them all this stuff. So, hey, can you help me? Chris is not calling the police. But somehow things got out of hand that night. People got hurt. Well, let me tell you what. Watch the evidence. Clear as day, the statement was, Mr. Robinson, who's known as Baby Slat, was not present. Let me tell you who Mr. Robinson is. Young, same age group as the girls, grew up in poverty, went to school, is struggling, and there's 3 ways that you get out of poverty. When you're a young black man, ball player, rapper, or jail through the police. He chose rap. I want to rap. That's a way that I can make some money and help my family, I can help myself, I can help my sister, and buy my mom a house. These are the things that these children will talk about doing if they ever have an opportunity to get access to funds. That's what Mr. Robinson was looking for. So we're not running from the name Baby Slut. That is the name he used to rap. The evidence is gonna show that when rap videos are getting produced and they say, hey, we need people to come to rap videos and we're gonna be in a video, you need to show up. There's flyers that go out to them. And the young individuals who are trying to make a name for themselves in the music industry will show up and play roles in the videos. No different from, I wanna be a model. And they said there's gonna be a photo shoot, and there might be some supermodel, producer there, somebody might sign me, and I might get it to you. No different. That's what his hand, Baby Slut, is about. The evidence is also gonna show that the location, 1040 Wally Street, Lauren and Lindsay arrived. You're gonna see that. You're gonna see them get in. You're gonna see them go in. Because there's no video of what's going on the inside of the building. You can only see what's going on the outside. They enter. And when they enter, state's gonna call them. They're gonna tell you there was underage drinking, drugs, people passed out. They're lucky nobody died from the drug use that night. But the state is not concerned about that. That's why the prosecutor told you in his opening statement, well, this case is not about the victim. Oh, don't look over there, look over here. Underage drinking, illegal, crime, no charges against Chris or anybody at the party. Having drugs there, crime, no charges against Chris or anybody there. Passed out, people passed out from drug use. No arrest. No case against anybody there. And the evidence is going to show that the state could charge everybody at the party and everybody who they thought robbed the party. And everyone would get liberty and justice. That should be the case. Let's talk about what else happened. You're going to see footage of Lauren leaving the party. She walks out the door, and you're gonna see her go to the right on Wiley Street. And she's heading to the right because she's telling law enforcement, that's where my car was parked, because the cars are parked on the street. Street doesn't have a whole lot of garages, and you have to park on the street. So I parked on the street, somewhere on the street, and when you see me go out the building and go to the right, I'm going back to my car because I forgot my cell phone. My phone battery was dead, and I had to go get it. She comes out. Lindsay is still in the house. And according to Lindsay, she's in the bathroom when she hears this whole commotion. People screaming and she's hearing yelling and she stays in the bathroom. And she was so terrified that she thought about coming through the window when she saw how high it was. She didn't want to hurt herself. So she waited. And she waited until she heard somebody say, we gotta get out of here. And that's when she came out of the bathroom. Chris is there. They're all there with the drugs. Nobody has any pictures or evidence of that. Lauren and Riley are outside because Lauren now gets in the car. She's waiting on Lindsay. And Lindsay's delayed for some reason. Because that's what they planned. They planned. And according to their testimony and their statements and the evidence, Mr. Robinson was not part of that. They added him later because they needed a fourth guy. And it's easier to solve the case if we let's just go on our phones and see if we can find who we can make the fourth guy. So she's using the word slime. And slime is used by not just one, but several of these groups. It's used by the rappers, it's used by some, what the state believes are gang members, it's used by some of the people in the evidence, this slime. It's kind of like Nickelodeon green slime. Maybe that's where the name came from. They're talking about slime. They're telling the state, we don't really know the fourth guy. We have no idea who the fourth guy is. When you meet the fourth guy, I met him that day. So everybody knows everybody, except Mr. Robinson. Gonna see the video. We don't really know who's driving that Mercedes. So the evidence is gonna show that Lauren's Mercedes is moving, but it's hard to see who's actually driving. So it could be her, because she's outside. And you can't see who's in the vehicle. It's hard to even tell if anybody other than a driver is in the vehicle. No other person can be identified on the surveillance other than the two women, Lauren and Lindsay. So you have to ask yourself, when the evidence is closed, state told you it's open. Evidence is gonna show, you're gonna hear from them. Ask yourself why. How would it be important that they go last? Two masked individuals are gonna be seen in the state's evidence, leaving the house party after Lauren Riley and walking in the direction of where Lauren says she parked her Mercedes. No one can see in the surveillance who the two masked individuals are. In fact, the angle of the camera makes it difficult to determine even a height of the person. Lindsay and Riley, they were called by the police. This is November 16th, about a week later. Because the area is in an uproar. It's a popular area. Everybody wants to know, hey, are we gonna catch these guys? Are we safe? What's going on? So law enforcement brings them in. And when they bring them in, they start questioning. And in questioning them, Riley is questioned first by Detective Maldonado. She's questioned for about 20 minutes. Then you'll see Officer Jean-Pierre come in, and he questions for about another 20 minutes. Finally, Detective Maldonado brings a supervisor, because the girls are going, hey, we just went to the party, we were by ourselves, nobody's with us, we went in and just living there first. Finally, one of the sergeants that's in the video says, hey, we know more than you think you know. It's time to come home. We got footage, this is your video. They're showing the girls a little few clips to get them to believe that everybody knows. We already know, so just go ahead and confess. Lauren says, Lindsay, we went into the party and we went to Sandy's house. And then after we went to Sandy's house, we went to the party and they leave out the young man's piece. The question again. And you're gonna see that when they're questioned again, the story starts changing. You're gonna see Lindsay Kalish get questioned by a female officer. And she's assisting Detective Maldonado with the investigation. They're asking additional questions of the girls. They start running. During the questioning, Lindsay says she only knows Rick. State has the burden. I don't know who Rick is. There's times in her questioning, she was like, and the other guy, I met him the same day. I think his name might have been Sly. Then she says, I really don't even know if Rick is Rick. But never forget, members of the jury, as you process this evidence, we need a fourth person. You're gonna see the evidence that Detective Maldonado starts going through his life. And he's questioning Lindsay. And Lindsay is saying, it goes by slime, I think it's slime. The word baby slut never comes up. You're gonna see where Detective Maldonado gets to a place on his phone where he's searching and says to the sergeant, you'll see in the video, the sergeant looks, they look at each other, and they head nod. And they crop and show to Lindsay. So now instead of Lindsay giving information to law enforcement that law enforcement is going to use to locate the real fourth guy, what you have is law enforcement is giving information to Lindsay. What does she say? Yeah, that's it. That's the ticket. And he says, well, so is that his name? She was like, well, I guess it's Slack. I guess it's Slack because that's what that says. So now the name Slack comes into the case. Because we're doing phone searches as detectives to try to determine who the fourth guy is. Approximately a month later, Lindsay realizes, oh my God, this is real. I have a problem. I'm still in custody. I'm not home. This is not just, oh, we got in some trouble and then we're back home. I'm not home. She is still in custody. So a month later, she's being questioned. Detective Maldonado's in the room. Mr. Howes is in the room. Our attorney's in the room. There's another male in the room. They're questioning. Now her story changes. Oh, it was me, Lauren, Baby Slut, and Rick. And we came up with a plan, and now the whole idea was really Lauren's idea. It wasn't really my idea. And I said before it was the boys, but it wasn't the boys. And I really don't know the fourth boy because I met him that same day. The story is all over the place. And the evidence is going to show that. That during the interview, she never ever said slut until Detective Maldonado brought up something on his phone and showed it to her. She mentions, thank goodness, because if she didn't mention, we wouldn't know. I guess it's slut since it says that on the phone. Ladies and gentlemen, this case is what I put together when I thought about what am I gonna tell these jurors to use as a synopsis of this case, that they can filter all the evidence through it as the evidence comes in this case. And I remember when I was growing up, the things they used to say is, oh, what a tangled web we weave. When first we practice to deceive. These girls are deceptive. It's hard to tell what happened. But one thing you're going to be able to tell is that nobody, not one person, is going to be able to tell you of the 7 that the state is calling alleged victims can tell you that they saw Mr. Robinson. And when you connect that with the statements of Lindsay and Lauren, it's gonna be consistent because they said baby Sly was not there. Make the state prove this case beyond a reasonable doubt, because the burden is on them. They must prove Mr. Robinson guilty beyond a reasonable doubt. The state conceded that in their opening. Oh, nobody's gonna be able to tell you that, you know, they look like this or they look like that. They've already conceded that at the gate. So if the state is telling you that, filter your evidence through it. Nobody can identify him. That's a reasonable doubt. They have to prove it beyond a reasonable doubt. They're not gonna be able to. And the two people that the state wants you to rely on to give them a guilty verdict against someone who their evidence says wasn't present when the corroboration of this plan was put in place is the two women who cannot be believed because of the many lies that you're gonna see throughout the evidence. So we filter it, ladies and gentlemen, and filter it through that old wives' tale. And render the only verdict that justice demands in this case, that is not guilty. Thank you.
Thank you, Ms. Mignot. So, ladies and gentlemen, we're at our first potential crossroads. We could have the state call its first witness and get a little bit of witness testimony under our belt, or you could take your lunch break. You're getting a lunch break either way. It's not an either or. It's just a question of, do we want to do about a half hour, a little less of witness testimony, get your lunch from, call it 12:30 to 1:30, or do you all need your lunch break now? Any consensus? You good? How about this? Is everyone okay going a little bit longer? Saying mostly yes. Let's go a little bit longer. Mr. Hiles.
State's gonna call Sharon Latners.
Okay. We're not off to a great start with having our witnesses ready. Is there a different witness we could bring in?
They're all in the same spot, but do you
Well,
want me to?
apparently Ms. Latners is not in that. Either the spot is very far away or Ms. Latners is not in that spot.
I think she's coming, Judge.
Okay.
Raise your right hand. Do you swear or affirm that the testimony you will give is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Go ahead and have a seat. Will you stand and spell your name for the record?
Sharon Latners, SharonLatners.
And Your Honor, before we move forward, go ahead.
I failed to invoke the rule, Your Honor, and I don't believe the court did before.
I didn't. So great point. If there's anyone in court who is planning to be a witness in this case, has reason to believe he or she will be a witness, you need to step outside. All right, and I'll rely on the lawyers to continue to enforce that. You're going to recognize witnesses more so than I will. Let's go.
Good morning, Ms. Latners. Can you give your occupation?
I am custodian of records for the city of Atlanta,
And how long have you been working in that position?
20-some years.
And what does that job entail?
I handle all 911 police audios. I handle all the CAD report incident numbers. I handle all the subpoena cases, and I handle all the court cases.
Does your job as a record custodian include the responsibility for maintaining 911 calls?
Yes,
And how do you pull a particular call?
by incident number.
Okay. And what is a CAD report?
CAD report is computer aided dispatch. On that CAD report, you will have the date of the call, the incident number. You will have the location, the time the call came in, who requested the call if they provide their name and their phone number. You will have the call type, which is signals for a police department. And you have the remarks from the caller. You have the remarks from the officer in the field.
And just to clarify, CAD report, CAD?
CADS,
CADS, and what was the acronym for?
computer aid dispatch system.
And in the normal, ordinary course of business, when is the information that is included in the CAD report generated?
It's generated as soon as the caller advise the operator that he or she would like the police department, fire department.
Okay. And does the information in the CAD report accurately reflect the information?
Yes.
After this report is generated, the CAD report is generated, how long is it kept with the department?
We go back to 2000 at this time.
And how long are 911 calls kept within the department?
With 911, Atlanta takes over 1,000 calls a year. State advised us we have to keep 5 years, but with us taking so many calls, the system purged the calls out. So at this time, we would say we go back to 2019.
And during your time at the department, how many CAD reports and 911 calls have you maintained? Rough estimate.
I've been there 35 years, so
Big number.
a big number.
Okay. Do you recall pulling calls as it relates to this case?
Yes, I do.
And Your Honor, am I free to leave to approach?
You are.
One time, I remember the court's rule.
Thank you.
And Your Honor, may counsel show me
Oh,
before the
sure.
witness?
Always a good idea. We're not gonna play it.
State is now approaching the witness. Two separate cases.
State is the 911 call from the date of the incident.
And what is the assigned case number to those, to the, I'm sorry, what have I just handed you, placed on the desk?
You handed me the CAD report, which is the incident number, and you handed me 2 911 calls.
Okay. And how do you recognize the 3 items that I sent you, put before you?
On the CAD report, you will see my name printed by S. Latner. On the 911 calls, I listened to the call and I put my initials on the tab.
And was the recording in that CAD report kept in the regular course of regularly conducted business?
Yes,
And the record is one that is routinely made and kept in the course of business?
yes,
It's a usual practice?
yes,
And was these calls that you pulled made at or near the time of the call that when it came in?
yes,
And was those calls made by a person with the knowledge and from the information transmitted by a person with knowledge? And who reported the knowledge in the regular course of business?
Yes.
Yes. Okay. Has there been any changes, alterations, deletions to that information that I just handed you?
No.
All right, Your Honor, at this time, the state moves to enter in State's Exhibit 1A, which is the CAD report of case number 193-120-264. The state moves to enter 1B, which is the 911 call associated with that same case number. And the state moves to enter 911 call associated with case number 153-422-982 as State's Exhibit 2.
All right, Ms. Mignot, any objection to the admission of states 1A, 1B, and 2?
No objection, Your Honor.
They're admitted.
Ms. Lattner, let's go over the CAD report that you have in front of you briefly. Permission to publish, Your Honor?
Yes, ma'am.
According to this CAD report, can you see it on your screen? Oh, you have the paper in front of you, okay. According to the CAD report in front of you, can you tell me what time the call came in?
02:20:21 AM hours.
And can you tell from the CAD who made the 911 call?
It just shows E911 caller and gave a phone number from the cell tower.
Okay. As you flip through
Is that, I'm sorry, so there's on our screen, we've got a 843 area code. That's the phone number that made the 911 call?
Yes, sir.
Okay.
And what, according to the CAD report, what is the location of the incident?
1040 Wiley Street, Southeast Atlanta,
And where is that located?
Zone 6,
In which county?
Fulton County.
What time, according to that CAD report, you can scroll down, what time was the officers dispatched to that call?
First officer was dispatched at 02:23:55 AM hours.
And can you tell, well, let me back up. What are the notes? What are the notes in the CAD report? Just generally, what are the notes? How are they inputted into the CAD report?
Operator, 911 operator types it in.
Okay. And so this writing that we're seeing, you might see on your screen so that we're following all along. Are those remarks, notes that I'm talking about?
Are we talking about right here?
Yes.
Those are units that the dispatchers, operator and dispatchers are two different people.
Yes. Let me scroll down to the notes.
Page 3.
Okay. So the page we just passed through was the dispatching of officers, correct?
Yes.
Okay. Page 3, what we're looking at now, would this be the notes?
Those are the notes from the 911 operator.
Okay. And what all right.
What do you mean? No, you're good. That's it.
All right.
No.
All right, thank you, Ms. Lattners.
Ms. Mignot, do you have any questions for Ms. Lattners?
Just briefly, Your Honor.
Deputy Gordon, can you get the note cards? I don't know if there'll be any juror questions for Ms. Lattners, but I promised they'd have note cards and we're not obliging. Thank you.
Good afternoon, Ms. Lattners.
Good afternoon.
As it pertains to States Exhibit 1A, 1B, and 2, you don't have any information as to who's responsible for anything associated with the incident, correct?
None whatsoever.
Thank you. Nothing further.
All right, any redirect?
No redirect, no
Okay.
redirect, Your Honor.
Any questions from the jurors? Well, thank you, Ms. Lattners. Appreciate your time. Who's your next witness?
Can you tell me how long you want to go so I can gauge which witness to call so I don't?
Sure. I mean, you should call any witness you want. We'll interrupt that witness, but I figured we'd go another 10 or 15 minutes. I was thinking break for lunch around 12:30.
All right.
So if you've got a witness of this duration, i.e. Ms. Latner's, that would be a perfect fit. If it's longer, we'll pause it.
We'll do that. It won't really. Can we call Ian Grady?
Mr. Hiles, if you come get up at the podium as evidence from the previous witness.
Getting ready right here. You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth of God. Yes, I do. Put my hand on my feet. Spell your name for the record.
It's Ian Grady, IANGRADY.
Are you going to be asking the witness any questions?
Yes, I am.
Okay.
All right, Mr. Grady. So what is, or what was 1040 Wiley Street to you?
That was my Airbnb Fort Fiesta, is what I think the name on the listing was.
Fort Fiesta was the name on the listing? All right.
Yes, sir.
Did you own the house?
I did not. It was a rental arbitrage. John Morrison was the name of my landlord.
Okay. Did you have permission to run it as an Airbnb?
Absolutely.
Okay. How often were you renting it out?
Pretty consistently, although this was the last booking.
Yes,
My Airbnb.
I understand. And how many people would the house accommodate?
It was a big house. I think the listing had it 4 bedrooms, 4 bathrooms, 4 porches. I remember that being. And then we also had a separate basement apartment. And I had a buddy of mine from elementary school living in the basement, which it had its own access point and you could lock it. So that was like a separate unit that was not rented out during this instance. So.
Okay. And were parties allowed at this particular?
They had
Airbnb?
been in the past, although a week prior, they had been outlawed by Airbnb. There was another Airbnb party that had gotten out of hand. And so this one in particular, although in the past I would have authorized a party if they'd asked, as long as they, follow basic rules. I don't believe that there was one asked about for this particular party.
Okay. And did you maintain ring footage of the front entryway?
Yes, sir.
Okay. And did you provide ring footage from the early morning hours of November 8th, 2019 to investigators in this case?
Yes, I did. The morning after I woke up and all the missed calls, I pulled the footage and I was able to kind of see all, I guess what you're about to show me, but it all kind of came together pretty quickly. That morning, I kind of could see what had happened.
Okay. All right, I'm approaching with what has been labeled as State's Exhibit 22. And it is a thumb drive. Do you recognize that thumb drive?
I do.
And have you been able to view the contents of that thumb drive?
I did. I watched it on a laptop outside.
Okay. And is that your signature on the thumb drive?
Yeah, I initialed my ING on the thumb drive, so that's the same one.
And are those video clips, are those full and complete clips of the information that you turned over to police officers from your ring footage camera?
Yes, they get clipped by like the software itself, like it triggers when it turns on, turns off, but those are the full ones that I was able to download.
So is the camera triggered by motion?
Yes, sir. Motion, and Those were Arlo, so those were triggered by sound as well.
Your Honor, this time the state would move State's Exhibit 22 ring footage from the 1040 Wiley Street address on November 8th, 2019 into evidence.
Ms. Mignot, any objection to the admission of states 22?
Your Honor, no objection, conditioned upon that being the exact same footage that we've actually seen.
Well, I'm admitting 22. If there are issues, I guess we can take them up later.
Yes, sir.
So, because there are sound issues in the sound will lag behind the video, I'm going to direct your attention to the television screen. So where was this camera actually located?
I know, even though I can't really see from, or I guess you haven't put it up yet, but it was located in like the corner of the front porch. So you had like some steps up to the front porch, which was kind of underneath the porch above it. So it's kind of boxed off. And then up in the corner, it was aimed at, so you could see the front yard, a little bit of it, like the path, the sidewalk leading up to the steps, and then them walking into in and out of the home. So it was a good spot for, it wasn't actually like the doorbell ring camera. This was an aimed camera. It also would cover, like, you know, cars coming in and out of the driveway.
Okay.
So we have some form of record. You just played something. I know it's part of Exhibit 22. What did we just see?
So I just played for you what was labeled in the exhibit as girls arrived to the party.
Okay.
From what you saw from that clip, is that how long the normal duration of each clip? Is it only active so long as somebody is in the frame?
Yeah, it's triggering events in the frame. So if there was more commotion, and there isn't like, there's a limit to that. I would notice that even if there was someone in the front, like constantly moving, it would eventually clip it regardless.
Okay.
And pick back up. But yeah, that was very normal.
Okay. All right. That's all that I intend to publish through you. I don't know if.
Okay. Do you have any other questions for Mr. Grady?
Yes. Did you have any complaints that arose from your property being a quote unquote party house?
I did. I tried to implement measures to, you know, I was young once but I tried to implement measures to make them, you know, I don't see any reason why a party can't not bother your neighbors. And so I had very strict rules about, I did it based on the chairs that are on the porches. So on the front porch, you'll notice that there was only 2 chairs, which is, I guess, plenty for someone to wait for an Uber while their friend is with them or smoke a cigarette or something like that. Right. And so that shouldn't bother the neighborhood, 2 people on the front porch. And then on the back porch, there was more chairs, rooftop porch and side porch, you know, so it was kind of laid out proportionally despite my best efforts. And then this is, like I mentioned earlier, this was kind of the final straw. And I was like, I'm shutting the Airbnb down. But despite my best efforts, you know, there would still be issues where, now I didn't always find that the issues were warranted. Sometimes I thought the neighbors are complaining just to complain, some of them in particular. But yeah, there definitely, for the couple of years I operated that Airbnb, It definitely this wasn't the only time that there was a complaint from the neighborhood.
And was that your primary source of income at the time?
I'm trying to think. At the time, yeah, I had stopped practicing law for a little bit. My father had gotten sick, and so he had a heart attack in the summer 2017, a throat cancer diagnosis in the summer 18, and then a stroke in the summer 19. So.
And Your Honor, I would have checked to relevance.
Okay,
Anyway.
that's okay. You don't, let's just keep the witness focused on what we're doing right now.
Yeah. So anyways, at the time I had stopped practicing. I don't remember exactly in that timeline. This was 2019. I guess I was practicing law again. So no, this wasn't my only source of income.
Okay. And throughout your, outside of what you've provided us, the videos of the girls coming in, would you be able to identify anybody who was involved in this robbery based on your involvement?
No, I recognized the, I remember, I didn't even like, they're too small to even tell like who these faces are. The only people I was in contact with in the aftermath of the robbery was I believe the young man that actually rented it, because I hit up everyone afterwards. I'm like, what's going on? So I think I communicated with him a little bit and I had his profile picture, but other than that, I don't know, the people who are involved.
Okay. And did you have any other context within or contacts with officers in this investigation outside of providing the video?
I think following up on the video, but no, that's it basically.
Okay. In what county was this house located in?
This was Fulton County.
Okay. That is all the questions that I have for this particular witness.
Ms. Mignot, any questions for Mr. Grady?
That's briefly, Your Honor.
Good afternoon, Mr. Grady.
Good afternoon.
Did you have knowledge or in your investigation, were you aware that Chris, the person you said was renting, is that Christopher?
I don't recall actually off the top of my head. I hadn't got a chance to review anything at the time. They do have a name, like there's a user that rents it on Airbnb. I do recall that, especially after it happened, I went back and rechecked all his reviews, and there was only one negative review is for getting a couch dirty. So he had nothing, like 12 stellar reviews at the time and no mentions of parties or anything like that.
Okay, so the person we're talking about is Chris?
I don't know. Whoever, I'd have to go back. I could figure it out for you. I just didn't prepare that for today, but I could go back through and look and see who actually booked. I have, screenshots of the Airbnb transaction.
Okay. Did any of your investigation reveal to you that this was allegedly a drug party?
I don't think a drug party. I don't know. I'm sure there are kids with drugs, but I did, I think, eventually get details from the news and stuff that there was, I think.
Unobjective hearsay?
Yeah.
Okay.
Yeah, sustained.
I don't have any personal knowledge of that.
Okay. Thank you, sir.
Okay. Any redirect?
No redirect, Your Honor.
Any questions from the jurors for Mr. Grady? Seeing none. Mr. Grady, thank you for your time.
Thank you, Your Honor.
Ladies and gentlemen, we're going to take our lunch break. It's about 12:35. That clock is slow. My computer clock is fast, so I triangulate in between. If you could try to be back by 1:40, that's about an hour. That ought to give you enough time. There are not a ton of places to eat real close by, but there are some. I think we have a list on the table in the jury room of the nearest places. American Deli. There's a Thai restaurant up Mitchell Street. There's often food available down on the first floor here in the courthouse. Whatever you choose to do, and you can bring in your own food tomorrow. And you can take phone calls during the lunch break too, so you're off by a minute. Don't talk about the case with each other. No outside research. The way, if you had a question of Mr. Grady about did he own other Airbnbs, not sure why that would be relevant, you'd write it down. And then I'd ask him that question. He'd say, I arbitraged 2 other Airbnbs. That's how we would do it. During the break, otherwise be at ease. There are 2 things I forgot to mention. One, this back hallway is yours to patrol quietly. If you feel a little cooped up in the jury room, there's not a problem moving up and down the hallway. You can post up way down. There's some glass and you can see sunlight. Just don't make a ton of noise in the hallway because there are two other judges and I don't want to get the equivalent of the angry neighbor calls like, there's a party in 8D. Because I can't throw you guys out. But it's not a problem to just be on a phone call way down at the end of the hall. So feel free to circulate that way. Second, when you come back in, you don't have to sit in this order. In fact, I'm going to fuss a little bit if the same people are always at one end or the other. As you've now seen, some of you get a real close view of the witnesses and some of you it's pretty far away. So rotate. Don't always be in the back row. Don't always be in a corner. Move around. There's no assigned seating. Any logistical questions? 1:40. We're going to try to start back up. Thank you so much. Mr. Hiles, anything from the state before we break?
Do you plan to bring Mr. Pritchett out before the break, or is that after the break?
After the break. Nothing to do right now. He'd just be sitting by himself. So I'll bring him out when we're done with the break to see if he wants to join us for the afternoon. And then we'll do the same during the afternoon break. Anything else?
No, Your Honor.
All right. Ms. Mignot, anything on behalf of Mr. Robinson?
Just briefly, Judge, there might be. I think the court's intentions was not to have the juror seen. Am I accurate?
Not necessarily. I mean, they're not being filmed there. They may periodically, you may catch the leg of one. What is being shared on YouTube is whatever is zoomed in on the screen. And I switched to the juror camera. So in general, they wouldn't, but every once in a while it remains the witness camera and people see them walk by. The public courtroom, all these members of the public are seeing the jurors. What won't happen is our friends from WSB won't be filming them, but we've got a good understanding on that.
Understood, Judge, because
Okay.
I did see them and I didn't want to not bring it to the court's attention.
No, I appreciate that. And if you saw it on one of the little cameras, that's not what's being live streamed. What's being live streamed is the big one.
Thank you, Judge.
Okay, not a problem at all. Mr. Robinson, was your ankle situation fixed yesterday? It's not occurring again today?
No.
Pardon?
They got dates, so they got,
Not a problem?
not just no problem.
Okay, excellent, good. Then we're gonna break for an hour. We'll be back, and you'll have witnesses pretty close to that door, ready to go, for the afternoon.
I told them not to use the.
All right, what you need is your investigator back, so you guys don't have to run out and do that. All right, that's it. Thank you, everyone. I'm gonna mute the podium microphone so you can speak freely.
Miss.
Can we bring Mr. Robinson out, please? Thank you.
On the witness list, she is Officer Wright. She has a different last name. And she had,
You were Officer Wright originally, 7393?
Yes.
Excellent. Were you the first responding officer? And back then you were right?
Yes, sir.
Okay.
This up to here is hers. That's it. No, that's how we're the court order. So that's her, everything written below is out.
We broke up because how we got it.
That's how.
So what I do is, this is her, make file A and file B. Just so that, you know.
All right, we're gonna get on the record. I was a little late, so you had lots of time to talk about whatever you were gonna talk about. So we're gonna dive into things if that's all right. This is 20 SC 176922, State versus Robinson and Pritchett. Mr. Robinson is in court with his lawyer. Our prosecutors are here. Our next witness is going to be Officer Weems. But before we bring the jury in, I'm gonna ask the deputy to bring Mr. Pritchett out. And we can try again to see whether he wants to join us.
I'm gonna take this from you.
Yes, sir.
Ms. Mignot, did you figure out if that cable 1 reaches and 2 connects in the way you need it to connect?
Mr. Runner, I did everything, I was efficient, and I'm ready to rock.
Excellent. Glad to hear that. Good afternoon, sir. We are on the record, and I wanted to chat with you again to see if you have decided that you want to join the proceedings. Are you prepared to take a seat and let me know by what name you'd like me to refer to you when I introduce you to the jurors?
Sure, I'll sit down. No, at no point do I waive any of my rights. Yeah, I'll take a seat.
Okay, I'm not asking you to waive anything at all. As you know, my default has been to refer to you as Mr. Pritchett. That's how you've been introduced to the jurors in terms of a name. Is there a different name or title you'd like me to use when I'm turning to you? For example, with this next witness, Officer Weems, when she's testifying, the state's going to ask her some questions. Ms. Mignot may ask some questions on behalf of Mr. Robinson, and then you'll be entitled to ask questions if you want to. You're waiving nothing and you're obligated to do nothing at all. But at some point I'll turn to you and I need for the record to say Mr. and I plan to say Mr. Pritchett, but I don't want to say that in a way that causes you to become agitated or frustrated or feeling like somehow your rights are being compromised. So again, my default would be to refer to you as Mr. Pritchett unless you tell me now by which name or title you'd like to go.
You can refer to me as the accused.
Okay. I think I can make that work. If it becomes unwieldy, then I'm gonna ask you for a substitute, okay?
Can you let the jurors know that by default you made a mistake by referring to me as Mr. Pritchett?
Nope. When you are given an opportunity to address the jury, which you'd have in your closing argument, because you elected not to be here during opening statements, you can talk to the jury about your theories and views of names and identities and all that. But so you're not surprised or confused, I'm going to explain to the jury that Mr. Pritchett has decided to join us, and he has asked that I refer to him as the accused from here on out, and then that's what I'll do. Okay?
Can you just referred to me to as the accused, and leave the Mr. Pritchett part out. That is not something I ever went by.
Okay, and you'll be given an opportunity at the appropriate time to share with the jury your claim that you've never gone by the name of Max Pritchett. But I've told you how it's going to play out. I have to explain to the jury who this gentleman who is appearing in the middle of trial is. And then I'm going to explain that you've asked to be referred to as the accused. And from that point forward, that's exactly what I'll do.
You should let them know that I believe that there has been a mistake as far as the court referring to me as that legal name.
I'll fashion something along those lines, okay? All right, let's bring the jury in, please. That's up to you, if you're comfortable with them not being on. But if you're gonna take them off, let's do it before we bring the jury in. That is a security question, not a McBurney question. Is that, he has a pen? That looks like a pen, and that's all right?
Yes.
Okay, great. Okay, let's bring the jurors in. How are we doing with jury charges, state? We got jury charges from the defense. Yours were due soon, as in they're late.
Huh?
When are we gonna get your jury charges?
Shortly, I just sent them over to Mr. Abadi to add a couple more.
Great.
But I thought you said your email. I will have them by close of business.
Is that what my email said?
Yes.
Then they're not late. Business hasn't closed. Here we are. Thank you, Deputy Gordon. Everyone else can be seated. Ladies and gentlemen, welcome back from lunch. We are joined by the person who has been indicted as Max Pritchett. He has asked that I refer to him as the accused. So at the appropriate time, when we are cycling through state asked questions, Ms. Mignot asked questions on behalf of Mr. Robinson, I will turn to, as requested, the accused to see if he's got any questions of the witnesses. He has got the very same right as Mr. Robinson to participate in the proceedings. As I told you when the accused wasn't with us, he also has no burden of proof whatsoever. And so it may be that the accused doesn't ask any questions of witnesses, and you should draw no inference from that because he has no burden to do anything, in the same way that Ms. Mignot, on behalf of her client, may choose not to ask questions of a particular witness. But I wanted to explain, we have a new member in the courtroom, and that's who we're talking about. So we got ready while we were working through some of those other things, and the state's next witness is seated at the witness stand. That witness is?
Here's gonna be Officer R. Weems.
Great. Officer Weems, we got to swear you in, and if you'll spell your last name.
Raise your right hand. You swear affirm that the testimony will be able to be true, the whole truth, and nothing but the truth, so help you God.
I do.
Can you state your name for the record?
Name is Roxanne Weems, Roxanne Weems.
All right. Good afternoon. Thank you for being patient with me today. Where are you currently employed?
Atlanta Police Department.
And what capacity are you employed?
I am a patrol officer.
Okay. Are you post-certified?
Yes, I am.
And how long have you been post-certified?
About 4.5 years.
Okay. And what are your duties as a patrol officer?
My duties are to answer 911 calls.
Okay. And all right. What
More
are-
in detail.
A little more detail.
So I would do preliminary investigation. So I would go to a scene, speak with victims, render aid, call for medic if I need one, get crime scene out there to take photos, collect evidence, and just gather the preliminary information that will be then passed over to the investigators.
Okay. So if you respond to an armed robbery, that doesn't mean that you are going to carry the case throughout the investigation.
No, sir.
Okay. So is it when you refer to an investigator, what do you mean by giving it to an investigator?
Well, I do the report. The report is then assigned to a detective who would then follow up with the case.
Okay. And is that just the structure of Atlanta Police Department and their policies?
Yes.
Okay. Where were you working on November 8th, 2019?
The Zone 6 precinct.
Okay. And what were you doing that night?
Answering 911 calls.
Okay. And did you respond to a 911 call at 1040 Wiley Street?
I did.
Okay. And what prompted you to respond to that location?
I was dispatched to that call.
What type of call was it?
It was a robbery at a residence, or what you would call a home invasion.
Okay. And when you got there, what did you encounter?
When I got there, I immediately was met by some of the victims. They were outside off the location. Some were injured, and they were very frantic, but.
And what was the scene, I guess, as you saw? You said very frantic. What was the scene that you came upon?
It was a little bit chaotic. Young kids just frantic, just, nervous about everything that went down. They were saying that they had some people over and that two men came in, injured two of their friends. So it was just very chaotic.
Okay. And without stating what anybody told you specifically, were you able to do some initial interviews on this scene?
Yes.
Okay. Do you recall how many people roughly that you interviewed while on the scene?
Approximately 7.
Okay. And what did you do with the information that you collected from those 7 individuals?
I completed a report.
Okay. Who did you turn that report into?
So when we complete a report, it goes to our supervisors who then reviews it and signs off on it.
Okay. How does it get assigned to an investigator?
Once it's signed off by my supervisor, it goes to that unit supervisor, and then they assign it to a detective.
Okay. And on the night of November 8th, 2019, were you wearing a body camera?
I was.
Okay. And do you always wear a body camera?
I do.
Okay. How does a body camera work? Or what does do you have to activate a body camera?
Yes,
to record?
you have to activate the body camera.
Okay, so is it always recording?
Yes, it records until you deactivate it.
Okay.
Mhm.
Was your body camera activated the night of this incident?
Yes, it was.
Okay. What did you do with what do you do with the footage after an incident is?
Once we're done with the caller at the end of the night, a number, which is a case number, is assigned to the body camera, and it's just uploaded to our system.
Okay. I'm approaching you now what's been marked as States Exhibit 3. All right. And do you recognize the thumb drive on States Exhibit, labeled as States Exhibit 3?
Yes.
And how so? How do you recognize it?
Because it has my initial.
Okay. And did you review the contents of it, your body camera from November 8th, 2019?
Yes,
Is this a true and complete recording of the events recorded by your body camera?
yes, sir.
Your Honor, at this time, I would read State's Exhibit 3, Officer
Weems.
Weems' body camera into evidence, and note that at the time it was recorded, it was Officer Wright was her last name.
Same person, different name.
Yes.
Familiar with that concept. Ms. Mignot, do you have any objection to the admission of States 3?
I have not seen 3, Your Honor. I'm assuming it's in discovery and assuming there's no hearsay issues with it, then I would have no objection.
Okay. Was States 3 included in discovery as best you understand, Mr. Hiles?
Confident it was turned over.
All right. And the accused, do you have any objection to the admission of States Exhibit 3?
And I haven't seen it. Send it to me. Don't have any objection.
Okay, thank you. 3 is admitted. Remind me, we'll have during a break, we need to talk. It's a problem when I hear from Ms. Mignot. I haven't seen this before. And so I guess my request of maybe Ms. Blake would be to run down it's not a very long exhibit list, and see if you can find stuff, because if you can't, they need to find it for you. I know it's a billion things in discovery, but it just makes me a little wary when you say, I believe in good faith. I haven't seen it, but also in good faith, I'm not saying it wasn't in there. But we're going to press forward. 3's been admitted.
Thank you, Your Honor.
Now, at what point does sound turn on these videos?
It buffers for like 2 minutes.
Okay. So what do you mean by buffers?
So it would capture 2 minutes before I actually activate it.
Okay.
Those 2 minutes would be captured, and that's like a buffering mode where there's no sound until 2 minutes after.
I'm not going to play very much of this, and I'm just going to ask you one question.
Put your marker, time marker on the record.
For the record, this is the 2 minute and 52 second mark. And I fast forwarded to 3 minutes and 25 seconds in the video. The timestamp is UTC time 7:28. Now, looking at the screen, is this the scene as you observed it when you pulled up to the incident?
Yes, sir.
Okay. And so were those your first introduction to the victims in this case?
Yes, sir.
Okay. Were all of the victims outside when you
No,
pulled up on
not,
scene?
not immediately, no.
Okay. Let's see. And what county is 1040 Wiley Street located in?
Fulton.
Okay. And
I'm sorry, that would be DeKalb. That's on the DeKalb side.
do you know? If you don't know,
I
it's
think
okay.
it's Fulton, actually, sorry. Mhm.
Okay. You said you interviewed 7 individuals?
Yes.
Anything
Mhm.
else? I don't think anything else. No, I don't want to know with other witnesses. It's hearsay. Right? That's all I have for you at this time. I think.
Ms. Mignot, do you have any questions for Officer Weems?
Briefly, Your Honor.
Good afternoon, Officer Weems.
Good afternoon.
Did you ever enter the 1040 Wiley Street location after arrival?
I did not.
Okay, so your entire involvement was what we've witnessed on the body camera interactions with alleged victims outside?
Yes.
Okay.
So usually it's a collective effort. There were multiple officers on the scene, some of which went inside. I was mostly outside trying to speak with the victims, one of which was being transported. So my main focus was making sure I got all the information that I needed to be able to complete that report.
Okay, and your report is associated with the work you did with interviews of people who were outside?
With all the victims, because
Okay.
they came out. All of them came out. Initially, when I arrived, I was met by 3 victims. The other victims came out eventually.
Do you recall which 3 were outside?
I can only speak to the female in terms of Rebecca, because it's easier for me to identify that name, because she's a female. But the other 2, I wouldn't be able to specifically say their names.
Okay. And as it pertains to this incident, you don't have any physical description, you don't have any evidence that the individual involved in this robbery is this gentleman sitting right here, correct?
No physical evidence, no.
Okay, thank you. Nothing further.
And now to the accused. Sir, do you have any questions for Officer Weems?
Again, I never received any of this evidence, or, knowing that I know that she was going to be a witness. I was not able to prepare, so I don't have anything.
Okay, no questions. Any questions from any redirect, Mr. Hiles?
I don't have any redirect, Your Honor.
Okay, any questions from the jurors? All right, you jot it down on a note card. SOP.
I labeled it Riley car footage because it's her car circling. We don't even need to play it. We just need to admit it through him.
Yeah, I'm just making sure it's the right thing. His initial wasn't missing some of it.
You give him too much time, going once, going twice. It's terrible. Be a good auctioneer, though. All right, counsel, I'm gonna let you look at these. There's not a question for me to ask this witness, but you should see what the jurors were asking about. You may. And the standard will be, we'll go back in the hallway and talk about them. We don't need to talk about these. Okay. Thank you. They wanted you to play the whole body cam, but that's not your role. Okay, thank you for your time.
Okay, thank
You are free to go.
All right.
Next witness.
The state calls Jonathan Vergras.
Well, you see, can you raise your right hand? You swear affirm that testimony you will give will be the truth, the whole truth, and the truth of God. State and spell your name for the record.
Jonathan Vigras, Johnathon, Vigrass.
And Mr. Vigras, you're soft-spoken, which is fine. Just make sure that you talk into that microphone so the jurors can hear you.
Gotcha.
Thank you.
Good afternoon, Mr. Vigras. What is your occupation?
I am a sales engineer.
Okay. And what area do you stay in generally?
Currently, I live in Canton, Georgia.
Okay. And were you at one point a homeowner?
I was
Okay, and what was the address of that home?
1016 Wiley Street.
Okay. And was that, did you live at this address November 8th, 2019?
Yes, I did.
Okay. And what, if any, type of security did you have on the home?
I had multiple security cameras on the exterior of the home.
Okay. Describe how the cameras work. How are they operated?
Sure. So they record locally to a hard drive that I had in the house.
Okay. And what happens to those recordings?
So those recordings are stored for 5 days and then they're deleted automatically off of the server.
Okay. And what, if anything, triggers your devices to record?
Any type of motion.
Okay. So they're activated with motion?
Correct.
And then it's saved to the hard drive?
Correct.
For 5 days?
Correct.
Who operates this hard drive that's inside your home?
I do.
Okay. And how do you access the videos that you want to view on the hard drive?
Sure, via computer.
Okay. So you have a computer attached to the hard drive?
Correct.
Okay. Do you recall being contacted by law enforcement regarding an incident that took place on November the 8th, 2019?
Yes, I do.
Okay. And do you recall providing video footage to law enforcement?
Yes, I did.
How did you know what video footage to pull?
Sure. So the excuse me, the police knocked on my door and they asked me if my video cameras worked, and I told them yes. And I told them that they could see video in the house from the previous night. So they came in the house. We watched the videos. They identified some videos from the time in question. They asked for a copy of those videos, and I provided a copy of those videos.
Okay. And have you seen that footage since you provided it to the office?
Yes, I saw that video this morning.
Okay, you're pointing at me. So are you talking about this?
Well, I don't know what's in that envelope. I can't see a video in that envelope.
Permission to approach the defense?
Yep. So all the lawyers, the parties have permission to approach witnesses.
Yes, Judge.
Thank you.
Let the record reflect that I'm approaching the witness. Okay, and what did I just hand you?
An envelope with the flash drive of the videos that I watched in the lobby, and I initialed it.
Okay. Let the record reflect the state just presented the witness with State's Exhibit 21. When you reviewed that footage, was a full, complete copy of the footage that you provided to law enforcement?
As I remember it, yes.
Okay. And the same footage that was extracted and provided to law enforcement?
Yes.
Okay. At this time, the state moves to tender State's Exhibit 21 into evidence.
Ms. Mignot, any objection to states 21?
No objection.
And the accused, any objection to states 21?
Same thing before, that's something I never seen before, so I have no objection.
Okay. And ladies and gentlemen of the jury, I should make clear to you, the accused has elected to represent himself. That was a decision made fairly recently. His counsel was provided all the discovery in this case. It is complicated for things like a DVD or a thumb drive or whatnot to be viewed where the accused is spending his time. So you should process what he's sharing with you consistent with what I've just shared with you. State's Exhibit 21 is admitted.
Thank you, Your Honor. And at this time, the state will not publish it.
Okay.
It'll happen later. So the state will be
You done with Mr. Vigrass?
done with Mr. Vigrass. No further questions.
Ms. Mignot, do you have any questions for Mr. Vigrass?
Mr. Vigrass, good afternoon. My name is Marcia Mignot.
Good afternoon.
I represent Mr. Robinson sitting here at council table with me, and I have just one question for you. You don't have any information as to whether or not Mr. Robinson is involved in any incident that occurred at 1040 Wiley Street, correct?
No, ma'am, I do not.
Thank you, sir, for your time. No further questions, Judge.
All right. And turning to the accused, sir, do you have any questions for Mr. Vigrass?
No, I would just speak on the fact that again, when I did have the attorneys that were assigned to me and discovered that they did have, I did not see all of the evidence that was presented to them or being presented here today. And when I did relieve them of their duties, I thought I would have my full right of discovery.
Okay, well, we discussed that outside the presence of the jury, and I'm happy to take that up with you again outside the presence of the jury. Right now, I just needed to know if you had questions for Mr. Vigrass. It sounds like you have no questions for Mr. Vigrass. Is that correct? Okay. Any questions from the jurors? Seeing none, Mr. Vigrass, thank you for your time.
Thank you.
Back to Canton.
Yes.
Yes.
All right, thank you.
All right, next witness.
The state calls Jackson Heil.
Thank you.
Did you want me to show?
Anything you're going to show to a witness, you should show to Ms. Mignot as well as to the accused.
Will do.
Thank you.
We have shown Ms. No all of the exhibits. We need to show the accused.
As long as both sides have seen it, both defendants need an opportunity to see what you're going to share with the witness.
What is it? Can you raise your right hand? You swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
Can you state the spelling name for the record?
Jackson Heil, JACKSONHILE.
Good afternoon, Mr. Heil. Can I get you to give us your full legal correct name?
Jackson Beckett Buckingham Heil. You know, spell the whole thing too?
No, we're good with the first and the last, but what I do need you to do is sidle up a little closer to the microphone. It doesn't move, so you'll need to move, and the chair doesn't have wheels, but it moves. If you give it a heave ho, you'll get closer. Thank you.
Is that better?
Much.
Cool.
Mr. Heil, would you let me call you Jackson?
That's fine.
Okay. Jackson, how old are you?
I'm 23 years old.
Okay. Are you at school, working?
I'm full-time in sales at Hudson Nissan of Charleston,
Okay. Charleston.
South Carolina.
So you live in South Carolina?
Yes, ma'am. Born and raised.
Okay. How old were you in November 2019?
I was 19 at the time. Or, yeah, 19 at the time. Yes, ma'am. Yeah.
And at that time, were you working?
I was working in Los Angeles. Yes, ma'am.
Okay. So born and raised in South Carolina,
Mhm.
right? Then tell the jury about how you ended up in Los Angeles.
So after high school, I moved out to Los Angeles to pursue a modeling career with my buddy, and I ended up getting into the cannabis industry. And then we were working with legal cannabis, and it was a whole type of like a new career for me. It was a new experience, and it's something that I loved. I loved being in sales. I loved working with the community and with people. And during my job, it was kind of like, not only did I get to help out different communities through the homeless community, we're selling marijuana to different dispensaries, but some of the profits that we took from those charitable events were given back to the community as well. And that was something that was a big drive for me.
Okay. Are you still in sales or no?
I'm in car sales. Yes,
Okay,
ma'am.
so still a salesman?
Yep, I love sales.
Okay. Would you call yourself a people person?
Yes, ma'am.
Okay. Now you said at the time you were working in Los Angeles under a company?
Yeah, per se, it wasn't like an established LLC, but it was like a branded company, I guess. I don't know how the laws work with like.
Well, I'm not gonna ask you the legal
Yeah.
jargon. Did they employ you? Were
Yes.
you an employer,
Yes.
employee?
Yes.
And did you get paid?
Yes.
And how did you get paid?
Through cash and through checks.
Okay.
Cashier checks.
Were you paid hourly? Were you paid about?
It was commission based.
Commission based,
Yes.
okay. And you sold to dispensaries?
Yep.
So you got paid selling to other dispensaries?
I was like a middleman sales broker is what my title was essentially. Yeah.
Okay. And at this time, based on your knowledge, was the sale of marijuana legal in the state of California?
Yes, ma'am.
Okay. So, what brought you back to this area around November 2019?
So I newly met Chris in the summer of 2019 and we became good friends and I ended up making a good amount of money out there and I wanted to bring some party supplies and drugs essentially back to Atlanta for us to have some fun. And I hosted a party at an Airbnb and I invited Chris.
So I was just trying to get a very specific thing, and that's my apologies. I should have made it more narrow.
Hold on one sec. We gotta make sure those devices aren't making unhappy noises.
Where's your? Okay. Your Honor, I apologize. My type 1 diabetic alerts when there's something going on.
Then we should let that alert happen, if that's what it is, as opposed to your fan base texting you, okay, then by all means. And if you ever need to step outside, and we need to pause, let me know.
She's gonna step out for me. Judge.
Okay, thank you. Next time, let me know that you might have an important beep, because I usually assume it's, hey, buy this new Nissan, whatever he's selling. There you go.
Usually he's over.
Okay.
Okay, Jackson, so you were talking about how you met Chris. We had to clarify who Chris is. Do you know Chris's full name?
Christian Riggs.
Christian Riggs?
Yes.
Okay, so would you feel comfortable calling him Riggs?
Yeah, Riggs, yeah.
Chris's, okay. Okay, so we're gonna refer to him as Riggs.
Mm-hmm.
Okay. You met Riggs. Where did you meet Riggs?
On social media, on Instagram.
Okay.
Yeah, so he reached out to me because I was out there. I was doing a little bit of modeling. He wanted to get into modeling. He's still doing a little bit of modeling. I'm out of that career path.
Okay, you met him where?
On social media.
Okay, and where was he living when you met him in social media?
Atlanta, I'm pretty sure.
Okay.
Yeah, he was here. And then
You were in California.
yes.
And you met him on social media and he was in Atlanta.
Yes.
So that's your connection to Atlanta?
Mm-hmm.
Okay, understood. And just to clarify, how did you said something about modeling?
Yeah, so I invited him out there to a modeling event that we were going, that was, I got invited to, and he had the modeling look. So I flew him out there and we became best friends essentially upon arrival. So
Okay.
and we created like a flourish of friendship. And then he wanted to bring me back here.
So you flew him out to Los Angeles.
Mhm.
Y'all participated in some modeling.
Mhm.
And then he wanted you to come to Atlanta.
Mhm.
So that's how you ended
Stop.
up. Can you give a verbal response? Sorry.
Yes, yes, ma'am.
Great, and I caught that a little bit earlier, but Mr. Howell, when you're answering, it needs to be a yes or no, or whatever the words are. They don't have to be yes or no, but
Okay.
the court reporter says inaudible or unintelligible, and we know we can hear you, so make sure you use the words.
Yes
Thank
to
you.
the previous questions.
Okay. Do you recall the incident that occurred November 8th, 2019, when you were in Atlanta?
To my best ability, yes.
Okay. And how did you arrive to Atlanta?
Me and Holden drove. Yes.
So you were in Los Angeles.
Mhm.
Okay.
Yes?
Yes, sorry, yes.
Give us a step by step.
So me and Holden flew from LA to Charleston, and then I met Holden's father, and then we drove up to Atlanta.
Okay, so let's back up and you just introduced us to a person named Holden. Who is Holden?
He was a good high school friend of mine.
Okay, give us his full name.
Holden Carmody.
Holden Carmody.
Yes, ma'am.
Okay. Holden, you've known him since when?
High school.
Okay,
Yep.
so by the time 2019 is happening, how long have you known him?
Say 2 to 3, maybe 4 years.
Okay,
Yeah, don't know. I don't know the exact timeline,
Okay.
but sometime during high school.
and where is he from?
Charleston as well.
Charleston,
Yes,
South
ma'am.
Carolina.
Yes, ma'am.
Okay. He flew to Los Angeles.
I flew him out there.
Say yes or no.
Yes.
Okay. And then you guys flew back to
Charleston.
Charleston together.
Mhm.
Okay. And then you said you drove from Charleston to Atlanta.
Mhm.
Okay.
So we're gonna be here forever if
Yes.
you have him repeat everything he said, because you break it down into little bite-sized pieces. So we'll let him, it's okay if he says 5 sentences, we'll process all 5. We don't then need to go back. And your first sentence was you flew to Charleston, and then otherwise we're gonna get stuck.
Okay.
Thank you.
He's introducing us to new characters.
The characters I get. I'm sorry, I just feel like we've now gone to Charleston about 8 times, and it was only 1 time.
Okay, thank you.
You're welcome. Thank you.
So you drove to Atlanta. What was the plan when you drove to Atlanta?
To meet up with Chris, I had a Airbnb set up, hosted with Ian, the owner, and it was a party Airbnb. So I was like, perfect. Let's have a little get
I
together.
apologize, Your Honor. Is his mic on? Because I am struggling with.
It's on, he's soft-spoken, so if you just make sure you talk right into it, I don't know if models have loud voices. Do models have quiet voices?
Yes, sir.
Then use your non-modeling voice, okay? You're saying like, I'd like you to buy a Nissan. Yes.
There you go.
Sell us a
Salesman voice.
car, but
Okay.
instead testify.
All righty.
Great.
So may you repeat the question for me?
Sure. What was the plan when you came to Atlanta?
So essentially it was like a welcoming party for Chris to introduce introduce me and Holden to his friend group. And I hosted the party through Ian's Airbnb, his party Fiesta, Fort Fiesta is what he called it. So from there on, that's where the party started.
Did you know Ian prior to this incident?
No,
How did you locate the Airbnb?
through the Airbnb app.
Okay. Based on the name of it, the Fiesta.
The Fort, yeah, it was literally called Fort Fiesta, like party household.
Okay.
Yeah.
So the plan was to throw a party?
Not really a party. It was like a group of like 10 people. So I guess a get together. We were never going to throw like a rager because we're trying to be respectful of the neighborhood.
When you arrived at the Airbnb, can you describe the location? Was it a business, house, something else?
It was in a house. On the listing, it looked in a nice area. And when we got there, we realized it wasn't that much of a nice area. So from the get-go, we kind of had our guard up.
Okay.
Yeah.
And what, if anything, did you do to keep your guard up while you were in the house?
Making sure the doors were locked at all times.
And who was at the party?
Christian Riggs, Holden Carmody, Becca, Victor, the DJ, and those are the names that I can currently recall.
Okay.
Yes.
Were there more people?
There were more people, yes, yes.
Do you recall around what time you got there?
I'd say it was dark, so I'd say around maybe anywhere between 8 to 10 p.m. I'm sure Ian has the check-in log and.
We're just going off of your memory.
Okay, okay.
And when you arrived at the location, what was happening?
Currently nothing. We were the first ones there, so we were setting up the party.
Okay.
Yeah.
And what did you do to set up the party?
Just put out the bottles of Coke and just like beverages, solo cups, stuff like that. Because we were underage, so we couldn't buy the alcohol. So we had to have other people go buy the alcohol for us.
So when you said bottles of Coke, I just want to clarify for the record. Do you mean like a soda product?
Yes, yeah, like the Dr. Pepper and Coca-Cola.
Okay.
Yes.
And And around what time, if you can remember,
Mhm.
did people start arriving?
I'd say around 11.
Okay.
Yeah.
And you said overtime of 10 altogether?
Approximately, yes.
And what were you doing?
I was just trying to have fun. I was making sure everybody was having a good time. We had this cool like wheel, like spin wheel, where we would expo marker in different actions, like take a shot or take off a layer or whatever it is, and you would spin the wheel, and then whatever would land on is what you would do, like take 2 shots or like flip a card, and if the card says this, you do this. Just like cool stuff like that. Where we were just trying to make the party fun. We had a DJ there, just like a welcoming party to Atlanta for the first time ever being here.
Did
And
you meet the friends that
yep, that I was anticipating on meeting, who we're still friends to this day. And then everything happened.
we're gonna get to that.
Yeah.
Do you recall any substances that you intook, like you took it?
So I did drink alcohol. I smoked marijuana, a little bit of marijuana. And then for the first time, I got introduced to a substance called ketamine. And I took a very, very low dose of ketamine. And within probably 20 minutes is when the robbery occurred.
When you take ketamine, how do you put that in your body?
It was insufflation, snorted it. Yeah.
And getting there, after you took the ketamine, am I saying it correctly?
Yes, ma'am.
Did you feel any effects?
It did. I wasn't noticeable probably for around 10 minutes, and it was a very minor effect. It was more of like a laughing gas when you go to the dentist type of feel. So I was still like cognitive. I was still there, but it just made me feel goofy and just loopy a little bit.
You stated it was your first time. Where did you get it from?
Whoever had it, I don't know.
Okay, so you didn't.
No.
10 minutes in, you're feeling the effects.
Mhm.
You said like laughing gas.
Mhm.
Okay, and what happened next?
About 10 to 15 minutes after that is when me and Chris started noticing some sketchy things with the females.
Okay, and when you say Chris, who are we?
Riggs.
Okay.
Riggs.
You and Riggs started noticing sketchy.
Activity. They were going up and down the stairs, doing weird things, and I was like, "Can we get them out of here, please?" I personally did not know them, and I only wanted people that I relatively knew and that everyone else knew in the party there. So we kicked them out essentially, and within 2 minutes, the robbery ensued. Yeah.
Now let's back up. The 2 females you
Mhm.
said, is that what you call them?
Mhm.
Okay, were they a part of the group that
No.
was invited?
No.
Okay, so let's go back to that moment. When did you notice that 2 young ladies were there that wasn't a part of the group?
I randomly just noticed 2 girls there that I had never seen before, and I was like, "Who are they?"
Okay.
Weren't most people there, people you hadn't seen before, because you were being introduced to Riggs's crew?
Yes, sir. But I was introduced to them. These girls were never introduced to anybody.
Got it. They appeared and no one took the step to say, "Hey, Jackson, this is X."
They were sneaking around.
Okay.
Yes. They're being very sneaky and just sketchy, I guess.
We're gonna get into that.
Yeah.
Were there any other young ladies at the party?
Becca, and there might have been another young lady. I don't recall, but Becca is a good friend of mine who's the only one I remember being there.
Okay.
Yeah.
When you said that their behavior was sketchy,
Explain. So they were keeping to themselves. They were very like conjoined. They were not talking to anybody else. If we would ask them questions, they were very dodgy. They ran upstairs, and when they ran upstairs, Holden noticed, so he followed them up there, and they quickly scurried down the stairs, and that's when we were like, okay, what's going on? And we got them out of the house. One of them left, one of them stayed inside the house. 2 minutes after one of them leaves, the robbery ensues, and this is.
You said one of them ran upstairs
Mhm.
and someone followed. Who was that person?
Holden.
Okay. What, if any reason, would you be or would anybody be concerned about upstairs?
Because that's where the product was essentially. That's where the party supplies were.
I'm
Okay.
sorry,
Party
I
supply.
couldn't hear the answer.
That is where the party supplies were
And-
stored.
Okay. And we didn't go into what these party supplies
Mhm.
were. How did these party supplies get to the house?
So I brought them with me from Los Angeles.
Okay.
Yes.
And how did you obtain them in Los Angeles?
Through my company or through the people I was working with. Yeah.
Okay.
Yeah. So it was legal out there. Yeah. And I understand it's illegal here, but I was young and dumb and I didn't really, it was a mistake and I take full accountability for it.
Well, let's talk about what those products were.
Okay.
Okay. What products did you bring here?
I had
From LA?
marijuana edibles and marijuana cartridges. And I think that's about it. 'Cause I didn't think I brought any actual marijuana. It was just the edibles and the cartridges.
Okay.
Yeah.
And how were they, can you describe them?
Gummies, and like vaporizers.
Okay.
Yeah. It's like CBD, THC vaporizers, stuff like that.
Something you can
Yeah.
smoke?
Yeah.
Okay.
Yeah. Like you can get them at the gas stations now, those type of.
Was there anything else upstairs of concern?
Cash. There was cash upstairs. Yes, ma'am.
And why was there cash upstairs?
For a transaction for some of that product.
Okay.
Who? For rigs.
Okay.
Yes.
So someone was gonna buy those items
From me, yes, ma'am.
okay, and that was Rick's.
Yes.
And how much cash was there?
It was around 15,000.
Okay.
Yeah.
And why that amount?
Just because that was what I was charging. And that was what I was sold to by my company from LA.
Say that last part again, I didn't hear you.
That's what I got sold to by a certain price from LA and was told to sell it for this certain price here.
Okay.
Yeah.
Okay, so let's go back. Got the girls out.
Mm-hmm.
Did you notice anything? I know you said from the moment you were there, your guards were up. Did you notice anything about the door once you got the girls out?
I think it was either Holden or Chris noticed that the door was unlocked, and with
You noticed that?
I didn't because I was laying down on the couch.
Okay.
And then, do you have anything more to say?
I just want you to talk about what you know. So we're gonna skip past anything else, okay?
Okay.
You were laying on the couch.
Mm-hmm.
What do you recall happening next?
I remember the door being busted open, kicked open, and these two males screaming with guns. And I got up to try and stop them because I was under the influence. I didn't know exactly what was going on. I saw a monkey mask and I thought it was.
I'm sorry, I can't hear you.
I saw a monkey mask and I thought it was a party. I thought it was just. I don't know. And they had, as soon as I saw the gun, I was like, that's a gun. Can you get it on my face? And he hit me with it over the head and I fell to the ground and I was bleeding and I laid on the couch and I was incoherent for probably 30 seconds. Then I woke up to the DJ getting his head stomped and beaten by the butt of a rifle. And to this day, I'm still traumatized by the thought of going through this whole process again. And it's very hard for me to relive all of this. And I just want this to be over.
I'm gonna take you back to the moment where you interacted with the two males. First, how do you know they were males?
Their voices.
Okay.
Very deep, Southern voices.
Okay.
Yeah.
Anything about their build?
One was skinny in a gray hoodie, and one was big in a black hoodie. Like big burly, probably very tall, 6'2", 6'3", maybe. Big, yeah.
And how close do you recall it initially interacting with the gunman?
He was within inches of my face.
He, the gray hoodie or the black hoodie?
Gray hoodie with the monkey mask was within 6 inches of my face. I specifically remember what the gun looked like because it was so close to my face.
What was the other mask?
Some type of purge mask.
Okay, so one monkey mask, one purge mask.
Yes.
Monkey mask is gray, the gray hoodie.
If I
The mask
recall-
may have been purple, but gray hoodie.
Yes.
Okay.
Yes.
And you said something to that person.
Yes, I said,
What did you say?
get that gun out of my face.
Did you think it was real?
At the point, no. Because I thought it was a prank. I was under the influence and I thought it was a prank. I've never been through a situation like this before. It was just terrifying to me. I was in so much shock that I just thought someone was playing a prank on us. I mean, who could do this to a group of kids?
And it became reality.
After I got hit in the head.
Okay.
And I realized that my whole face was covered in blood. And then especially when I completely sobered up when I woke up on the couch to Victor getting his head stomped. And that's when I immediately, he was.
So let me pause there. You said you woke up on the sofa. Did you go out, in and out?
So I like stumbled over to the couch, just laid down, and I was just going in and out of consciousness. But when I finally came to, I was completely aware, completely sober, like I don't know, my fight or flight instincts kicked in, and just seeing him, like seeing everyone else like huddled up on the couch, it was just a terrifying experience.
So let's describe that for the jury, the interaction that you saw with Victor. Victor was the DJ?
Yes, he was the DJ. So Victor is the DJ. He was the only one who was begging for mercy. He said, I don't have anything. I have no money. I came here to make money. He was begging for his life. And that is the only reason that this masked gunman grabbed him by his shirt, threw him on the ground, and started stomping on him. That's why he started beating him by the head, because I feel like this masked gunman had so much hate in his heart that he just wanted to hurt somebody begging for their life.
So was it one?
Yes. It was the gray sweatshirt guy.
The gray sweatshirt?
Yes.
Do you recall where the other person went?
Upstairs with Holden to try to grab the cash.
Upstairs
To obtain the edibles. Holden. Yes. But I think he only obtained the edibles. Yeah.
All right. And the gray hoodie was stomping on Victor. Where was he stomping on Victor?
In the middle of the living room.
That should be more clear. Where was he stomping on Victor's body?
His right here. Because I
So describe for the record what part of your
okay,
body you touch
the right temple, because he was laying, I guess left temple, because he was laying down looking at me as I was looking at him, and his head was getting beaten right here. So his left temple. It was.
What happened after the attack on Victor?
I'm pretty sure they came over to me. They took my shoes off, and I tried to fight back. I kicked the assailant in the face. And I was screaming, "They're not real! They're not real!" But he still ended up taking them anyways. I think he got a wallet, and then they ended up leaving. And immediately from there, I got up and I tried to make sure everybody was okay. I first checked on Vic, made sure he was okay. Checked on Becca. Went upstairs to check on Chris and Holden. Made sure everybody was okay. And then I realized that Holden was on the phone with the police, and I was like, "Holden, you got to get off the phone, because
You said they took your shoes.
Yes.
And they took a wallet.
Yes.
Your wallet?
No, not my wallet.
Okay. What, if any, interactions or words exchanged when they took your shoes? Did they say anything to you?
They said, "If you don't give me your shoes, I'm gonna kill you."
And what type of shoes did you have on?
They were Nike Air Force Ones, the off-white editions. So they were like $1,500 shoes. They obviously knew they had some value to them, or else they wouldn't have taken them.
Was it a nude color or bright color?
It was a bright lime green highlighter yellow color.
How long have you had those shoes?
6 hours.
Okay. How did you obtain those shoes?
We went to Heat Atlanta, which is like a shoe store down here. and we got those shoes and then another pair of shoes. And within 6 hours, they were stolen from me.
So you, were talking about how someone was making a 911 call.
Mhm.
Checked on everyone. Who was making the 911 call?
Holden.
Okay. And what did you say to Holden?
I said, please hang up the phone.
Okay.
Yeah.
Why would you say that?
Because at that time, in my mindset, I was more worried about getting the product out of the house. I was more worried about getting anyone going to jail rather than realizing that we just got burglarized and attacked. And my logic at the time, being a 19-year-old kid, was just trying to save us from going to jail for drug charges.
Were you aware that you were seriously injured?
No, at the time, no.
Do you know if Holden hung up the call?
I'm pretty sure he did. I think so.
But you're not positive?
I'm not positive, no.
And did you wait for the police to arrive?
Yes, yes,
Did you provide a statement to law enforcement?
yes, ma'am.
What, if any, items were recovered of yours?
Mhm.
Were there any items recovered of
No.
yours?
Nope.
And did you stay at the house after the incident occurred?
Nope. We had a flight to catch at 7 a.m. and I did not want to anything to do with Atlanta anymore. So I got on that flight and I left.
Was that flight, that it was already pre-scheduled?
It was pre-scheduled, yes. Yeah, but we had the option to cancel it and go to the hospital and stay in Atlanta. And I was in so much shock. I just wanted to get out.
When I asked earlier, what was the plan?
Mhm.
Was the plan to come to Atlanta, then go to?
Houston.
Okay.
Yep.
And why were you going to Houston?
For a Travis Scott concert.
Okay. Do you recall, what you were wearing that night?
A Travis Scott hoodie.
Okay.
That got ruined.
At this time, record reflect that I am showing pictures pre-marked states exhibit 14 through 16. You've already seen them.
So the exhibit list, it starts with 12. It's 12 through 15. We're not, for some reason, we're using a subset of that. You can use whatever you want. It just makes the exhibit list a little confusing.
Yes, I'm only using the one T recognized.
Okay, so 14 through 16?
Yes.
Okay.
Your Honor, 16 is the only one that.
Okay, and we've discussed that outside the presence of the jury. You made a number of objections about 16, which are preserved. If you showed the accused, 14 through 16 as well?
4 through 16.
Oh, 4 through 16.
Yes.
Oh, that's what I misheard. 4 through 16, so it all matches together. Okay, I thought you said 14.
I might have.
Okay, 4 through 16, much better. That tracks your exhibit list. Great. All right, any objections from the accused to exhibits 4 through 16 that you've had a chance to look at? Okay, they're admitted. 16 is admitted subject to the objection, Ms. Mignot, you raised earlier today.
Thank you, Your Honor.
You're welcome.
Approaching the witness. What did I just hand you?
Picture of the Airbnb.
Well, let's not go through, just generally, just shuffle through them.
Okay.
And let me know generally, what did I hand you? Don't go into specifics of each picture.
Well, I may have gotten ahead of things because I just asked the lawyer for Mr. Robinson, I asked the accused if they had any objections. They have no objections because they're familiar with them, but I guess you may still want to establish a foundation through Mr. Heil. I didn't mean to get ahead of things. I just, once I had been told you'd already shared them with counsel, that made me think they understood the foundation. But why don't you press forward with that, and I may renew my ruling that they're admitted based on his answers. Yes, sir.
That is the only objection you have. I was not familiar with those.
Your objection is you're not familiar with them. Okay, thank you.
Okay, so if you could just briefly just give me a general description of what you're looking at.
This first photo?
No, just in a collection. Are those photos from the night?
Yes, ma'am.
Okay. And how do you recognize them? Are you in them?
My blood is.
Oh, keep going, see if you're in them as well.
Yep.
Okay, is the Airbnb in the photos?
Yes, ma'am.
Okay, so is that how you're familiar with them, because they're from that night?
Yes, ma'am.
It's loud.
And the picture on the top, can you just go to 16?
16. These are the shoes that were taken off of my feet.
So don't show them to anyone yet. Do you want to ask him any more questions, or are you now tendering 4 through 16?
Tendering 4 through 16.
Okay. I don't think anything's changed, Ms. Mignot, but do you have any, other than the objections you made this morning, any objections to 4 through 16?
Just foundation, Your Honor.
Okay.
Are they a full, is the court, has the photos already been admitted, Your Honor, or am I still going through foundation?
There's an objection to foundation. If you think you have laid a sufficient foundation, tell me that. Otherwise, ask the standard question you'd ask about photographs.
Okay, are the photographs an accurate depiction of that night's incident?
Yes, ma'am. These photos are a very accurate description of the
Have
event.
there been any changes to them?
No, ma'am.
All right, Ms. Mignot, other than your earlier objection to 16, now that we've heard a little bit more, any objection to these exhibits?
Your Honor, is this the witness that took the photo?
I don't know. You can ask him that. He doesn't need to be the one, as long as he testifies that they're fair and accurate depictions of the scene when he was there, which he has testified to.
We'll follow up on cross if the court is already.
Got it. To the accused, you've indicated you object because you're not familiar with them. You've preserved that objection. Do you have any other objection to the admission of those photos? Okay, you've preserved that. They're in, you can publish what you want to publish.
The state publishes State's Exhibit 16.
Yeah. This is
So yeah, hit stay mute, and then that'll go away, and then you should be able to see what we see. All right.
Okay, on State's Exhibit 16, I'm just gonna ask you a few more questions on this picture.
Yes, ma'am.
Who took this picture?
Me.
And whose shoes are those?
Mine.
Whose legs are in the picture?
Mine.
Okay, so you're wearing the shoes in these pictures?
Yes, ma'am.
This picture? Are these the shoes that you say were taken from you?
Yes, ma'am.
It looks like almost like a zip tie or something sticking
Yeah.
out between your feet. Is that on your pants or the shoes or the ground?
That was Virgil Abloh's special tag that he threw on his Off-White edition Air Force Ones before he passed.
The state is now publishing its State's Exhibit 12. 12. And who was in this picture?
That is me.
Is that the Travis Scott?
Yes, ma'am.
hoodie You said you were wearing?
Yep. Yes, ma'am.
State's Exhibit 13. Who is that?
That is me.
Okay, you look a little different today. Bleach blonde hair,
Yeah.
Change?
Yeah.
Any other, would you say you're a little bit smaller there?
I'm a lot smaller there. I was around 140 pounds.
Okay. 2019, right?
Yes.
States Exhibit 14. What are we looking at in this picture?
That is right where the gun hit me in the side of the head.
Okay. And what, if any, injuries did you sustain from that? The obvious laceration.
A concussion that lasted 3 to 4 days.
Okay. Is that your first concussion?
No,
Um,
through sports, but
concussions through sports?
Yeah.
So you know how concussion,
and then, yeah, I knew exactly how it felt.
can you describe that?
It's foggy memory, kind of minor to moderate headaches, and memory loss.
And you're saying that didn't happen immediately?
Not immediately, no.
So when did that occur in relation to the incident date?
Probably 24 hours post after the incident.
While you were in Houston?
Mm-hmm.
Yes?
Yes. Sorry.
At States Exhibit 15? And is that a close-up picture of 14?
Mm-hmm. Yes, ma'am.
Was there any actual physical, I know you had a concussion, was there any physical injuries to your scalp or head?
Yeah, there was about a 1 to 1.5 inch contusion on the side of my head. Yeah.
So now we're gonna move on to the photos of the incident location, States Exhibit 4. What is that?
That is the front of the Airbnb where you can see the camera pointed at the front door on the left side of the porch.
So help us out, actually. Can you get up and point to?
No, why don't you stay seated, and you have a touch screen and it's easier for you to stay put. Tap the screen once, in the lower left-hand corner, there's a pencil. Now your finger can draw.
That's the camera that was pointed at the front door that was viewing this area.
Okay. Space Exhibit 5.
And you can erase those with the, you did it, wow. Is that from modeling or from selling cars?
Tech savvy.
Tech savvy.
Yes, sir.
What are we looking at here?
1040 Wiley Street.
Okay. In Space Exhibit 6,
The front door.
is this the front door you were speaking that the camera points at?
Mm-hmm.
Yes.
Yes, ma'am.
States Exhibit 7.
This is right where the incident occurred, where the beating took place, right here.
Okay. Do you recall where you were?
Yes, right. So say the photographer is the gunman. I'm standing right in front of that wine glass right down.
So use that tool like.
Yeah, so I would be standing right here. And the gunman was essentially where the cameraman was taking a picture of. So say I was like this close to the gunman and the other one was like right here.
So there's something that looks like blood on the ground, not saying it
that's-
is, but would that be from you or from Victor?
So if we go to the next picture,
I'm gonna use that in the next picture.
I'll show you whose blood is whose.
Okay.
We'll skip, due to that question, we'll just skip over to 9.
Okay. Okay, so we go back to draw. This is Victor's. This is mine. Could you hear that?
Yes.
Right.
So the small circle,
That's Victor's. His head was getting stomped. So that's the pool of blood from his skull fracture. And that was from me pulling myself away from getting hit to where eventually I landed over here on the couch. It looks like a little bit of blood right there as well. And then I was laying on the couch watching him getting his head stomped.
okay, is it States Exhibit 10? For the record, that is an up close of the blood stains that are in States Exhibit 9. And States Exhibit 11, that is an even closer footage of the smaller circle that you circled as victim's blood?
Mm-hmm. Yes,
Okay.
yes,
Yes?
yes.
Okay. And Jackson, I know it's a lot, I'm asking a lot, just remember to say yes or no.
Yes, ma'am.
And let me know if you need a minute, okay?
Yes, ma'am.
State's Exhibit 8. Do you know what angle we're looking at?
So this is from the behind the couch looking towards the kitchen. I use my marker. The DJ stand was right behind this wall. And up the stairs was up here, going up like that around the wall. The first assailant followed Chris up there, while the other one in the gray was pointing guns at Becca. Noah over here. Vic was over here begging for his life while the gunman grabbed him and pulled him over here while I was on the couch, incapacitated.
I'm just gonna back up to, you saying this is not your first concussion, you had it from sports,
Mm-hmm.
right? Did you go to the doctor?
No, I never really took care of myself as a young adult and up until recently. So I really never treated any of my injuries. But I've had enough brain contusions and knockouts to the point where I know what it feels like. Yeah.
Has there been any other effects from this incident that you had?
Traumatic effects, PTSD.
Okay. Would you want to share that with the jury?
This is live.
What's the relevance of how things are now versus
so
back to,
It is an aggravated assault. He was a victim of a crime.
all these are true?
And it is relevant what long-term effects he's had. It goes to his credibility, and I mean, it's evidence of his assault. It's the state's last question.
Ms. Mignot.
Your Honor, I don't believe that's a credibility question. Also, this witness is not a medical provider, and I think it borders on medical diagnosis.
Okay, I concur. So if you want to ask it differently, if you want to explore with this witness his ability to recall what happened back then, you can. I'm not sure why you're exploring that rather than Ms. Mignot, but you're free to do that. But rather than have this witness talk about what doctors or other care providers have, that's what you're doing indirectly if he's going to give a diagnosis, because that would come from a medical provider.
Yes, and Your Honor, I did not gauge that he would actually say PTSD. The long-term mental effects that he has experienced after the incident is what I'm asking about.
Okay, so
directly to him.
So move to strike that testimony.
I'm not going to strike it, but I'm going to have you ask a question in a different way, and we'll see if Mr. Heil answers it. And it sounds like you're about done with the witness otherwise. Okay.
So any cognitive issues you've had since this time?
Cognitive issues, from like fogginess, not being able to think before I act. I would say memory loss for sure. I feel like I can go into what you were asking earlier. I can.
Can't give any medical diagnosis.
Not medical diagnoses. I mean, I know what we've spoken about, if that's okay with. So after the incident, I fell heavily into drug abuse, and I admitted myself into a rehab facility after realizing that using substances to subdue the pain and trauma from an event like this is obviously not the right way to go. So I spent 2 years of battling addiction just from some small event that shouldn't have never happened. And I've taken 180-degree turn since then. It's been 2 years. I've been clean for 2 years. And I'm the best person I am today. I'm the best person I can be. And every day I'm doing everything I can to better myself and my life and my family and everyone around me.
And do you recall, I understand that you said you could tell they were males, back to the description.
Yes, ma'am.
You could tell they were males by their voice.
Yes, ma'am.
Were you able to tell anything else about them?
I could tell that they were African-American males.
How could you do that?
They had gloves on, but I could see the skin past the gloves. Yeah, and their voice, the tone of voice, is, and then I think either one of the other witnesses stated they saw.
Well, you can only talk about
Okay.
what you saw.
Okay,
right?
so then just above the hands.
Okay. All right, and as far as height, do you recall?
One was very tall and one was about my height.
Thank you.
Ms. Mignot, do you have questions for Mr. Heil?
Good afternoon, Mr. Howe.
Good afternoon.
I'm attorney Marcia Mignot, and I represent Mr. Robinson, who has the pleasure to sit next to me at council table. I'm going to be asking you some questions following up on the questions that the prosecution just asked you. We do have a court reporter taking down what both of us are going to say.
Yes, ma'am.
So if you would allow me to finish my question before you begin your answer, and I will be respectful to do the same. Because as human beings, we normally speak over each other. That is difficult for court reporters because their job in a courtroom is to make sure that everything that each person said is properly recorded. Okay?
Yes, ma'am.
I know it's difficult for lay witnesses to remember to say yes or no and not uh-huh and uh-uh.
Yes, ma'am.
So if you would pay close attention to that for me, please, I will be very expeditious in my questions.
Yes, ma'am.
All right, so let's start with questions opposing counsel asked you on direct examination were regarding the drugs that you had that night. You testified that you had smoked marijuana and drank alcohol, correct?
Yes.
You also testified that you had a feeling of loopiness or goofiness, correct?
Yes.
And isn't that the same feeling that you have been describing as it pertains to the effects you've had from this incident?
Can you rephrase that question?
Okay. So you testified that you have some collateral effects of this incident that you experienced on November the 8th of 2019. Do you recall that testimony?
Collateral?
Okay, so I'll use a different word. You had some medical effects. I think you testified PTSD.
Objection.
Yeah.
The defense struck that testimony.
Well, I didn't strike it. She moved to have it stricken and I said, we're not going to strike it. It didn't rise to the level that we needed to do that. So it's out there, came in through his testimony on direct. So if we're going to go over his testimony on direct, that's an area to which he testified.
Permission to proceed?
Yes.
Thank you. So you testified about having or battling addiction after this incident.
Yes.
You had an addiction before this incident, didn't you, sir?
I wouldn't say that, no.
You used drugs regularly.
I dabbled in marijuana. I smoked marijuana, but I did not have any hard drug addictions, no.
So you had a marijuana addiction, fair to say?
I wouldn't say addiction, no.
Okay. Do you recall testifying that you spent 2 years battling addiction?
Yes, ma'am, after the fact.
Okay. And is it your testimony that the addiction that you started battling was after the November 8th incident?
Can you repeat that?
You testified that you spent 2 years battling addiction.
Yes.
Is it your testimony that your addiction began on November the 8th of 2019 because of the incident that happened at the Wiley Street location?
Can you rephrase that?
Did you start using drugs because of the robbery, the alleged robbery at Wiley Street?
Objection, Your Honor, that's a different question.
It has to be a different question. He's asked her to rephrase it. And so she's getting more and more concise and blunt with the question, which you may need
I
to
would
do.
say yes. I would started using them heavily afterwards to suppress the trauma that was ensued. Yes.
Okay, what did you start using afterwards?
Percocets, Xanax, anything to numb the pain.
Okay, and you were using ketamine before the November 8th?
No. So that was the first time I told my counsel, I was introduced to ketamine that night, first time ever doing it. And 15 minutes after, 20 minutes after doing it for the first time is when the robbery ensued.
So let me ask my question again. You started using or tried ketamine before the robbery incident, correct?
Yes, ma'am.
So you started drugs before this incident occurred?
But it did not start the addiction, no.
Okay, so you were using, but you were not addicted?
Yes.
Okay. How young were you when you started using drugs?
Let's say 16, started smoking marijuana.
So between the age of 16 and you testified the age of 19 on November the 8th of 2019, correct?
Yes, ma'am.
All right, that's quite a few years that you were using drugs, isn't it, sir?
Not on a daily basis, no.
Now, you testified that the females were not invited to the party. Do you recall that testimony?
I testified that I did not invite them.
Isn't it true that Riggs, and that's Christopher Riggs, who we're going to refer to as Riggs so that the record is clear regarding which Christopher, isn't it true that Riggs sent out a Snapchat notice about the party?
Objection, Your Honor. That was not in his testimony, and that is eliciting hearsay, a message between someone else.
So two things. Yes to the hearsay, but it's not your role to tell the jury what his testimony was or wasn't. That's his role. So if Ms. Mignot asks him a question and Mr. Heil thinks, that's not what I said, he should say, that's not what I said. But don't make that objection again. That's not what he said before. On redirect, you can clear that up because the lawyer shouldn't get into an argument with the witness on the stand about what they think he said or didn't say. But the hearsay part, I do sustain. Let's not ask about the contents of communications from other folks.
Rephrase the question, Your Honor.
Sure.
Riggs invited the two young ladies, Lauren and Riley, to the party, correct?
Yes, ma'am.
You testified that what is depicted in State's Exhibit 16, a picture of, I think you called them Air Force Ones,
Yes.
were taken from you that evening.
Yes, ma'am.
Now, those are, I believe you testified, were $1,500 sneakers.
Yes, ma'am.
And isn't it true that there's a sneaker community that places value on sneakers?
Yes, ma'am. I am aware.
You're aware of that?
Yes.
And anyone who is a fan of sneakers or has knowledge of the value of those sneakers, if they're going to rob you, would be interested in those sneakers, correct?
Yes, ma'am.
Now, you testified that you brought drugs from California to sell because it was legal to sell in California. You
Yes,
remember
ma'am.
that testimony?
Yes, ma'am.
And you brought with you, I believe you said marijuana, gummies,
Yes.
and you said you also brought vapors,
Yes.
marijuana vapors.
Yes.
And did you bring any pills with you?
No.
Okay. So all the drugs you had that evening were marijuana-based drugs.
Yes, ma'am. That were legally sold in California.
Okay. You are aware that those drugs were not legal in Georgia, correct?
Yes, ma'am.
As it pertains to your testimony, you also testified that you asked Holden to hang up from calling 911,
Yes, ma'am.
and you asked him to hang up because you were scared if the cops came, they would see the drugs and you all would be arrested, right?
That is true.
Now, let's talk about the exhibits 4 through, and I'm going to say 15, because we've already talked about 16. As it pertains to the photographs that we saw, isn't it true, as you sit here, you cannot say that this gentleman, Mr. Robinson, was one of the two individuals that you testified invaded the home on November the 8th, 2019?
I don't know how to answer that question.
You cannot say you saw this gentleman, correct?
I did not see his face.
Correct. So you don't know if it was this person, right?
To my account, no.
You also cannot say that Mr. Robinson pointed a weapon or hit anyone with a weapon that night, correct?
I stated that the man in the gray jacket was the one doing that.
And the man in the gray jacket, as you sit here today, you don't know if that person is Mr. Robinson, correct?
I do not know.
Now, you also testified that I believe 7 a.m. the next morning, you took a flight.
Yes, ma'am.
So you're interacting with law enforcement at around 2 a.m. on November the 8th?
Yes, ma'am.
And a few hours later, you jumped on a flight and left to California?
No, to Houston.
To Houston?
Yes.
You still attended the concert that you were planning on attending?
Somewhat. When the concussion started to ensue, I decided to leave the concert and go back to the hotel because it was I was in a lot of pain.
Well, let's back up a little bit.
Yeah.
Let's talk about arriving at the concert. You actually went, correct?
Yeah. I had tickets. I bought my tickets. I was going to go. Yeah.
And you never sought any medical treatment from a hospital or urgent care facility prior to leaving, correct?
Nope. I was young and I thought I was invincible. That's all I can say.
You're not a doctor, correct?
No.
And you don't have any special medical training as it pertains to diagnosing injuries?
No, I do not.
As it pertains to any of the conduct associated with the two masked men that entered the Airbnb that evening, you cannot under oath say that either of those men was Mr. Tyrone Robinson. Isn't that correct, sir?
They were masked.
You could not say that it was Mr. Robinson, correct?
Yeah.
Thank you. Nothing further, Judge.
I'm going to turn now to the accused. Sir, do you have any questions for this witness?
No, just being that I didn't have, full discovery, I couldn't properly prepare. The only thing I was like staying on the record that since I am being accused of what is being said, I do believe it's been a mistake. And this is definitely not something a servant of Christ or child of God would do. And I deny the allegations.
Okay, thank you. Is there any redirect?
No, Your Honor.
All right, any questions from the jurors for Mr. Heil? All right, take your time to write them down, and Deputy Gordon will collect them. Thank you.
I know what you're saying. Do they need to?
How do you want to do this? The accused needs to be part of the conversation. Can he come back with us? No? Okay, I'll let him look at these. Ms. Mignot and Ms. Green, this way, please.
There you go. Stuff.
We'll talk about it during the break. Come on. Can you share these with the accused? Sir, you're about to see questions that the jurors have, and I plan on asking those of this witness. But if you have any objections to any of those questions, you need to let me know. I'll let you know that Ms. Mignot had no objections and Mr. Hiles had no objection. Sir, do you have any objection to any of these questions? Okay. Mr. Hile, first, how tall are you?
I'm 6 foot. Sometimes I'd like to say 6'1", but you know.
But if you're being honest and we mush your hair down, 6 feet?
6 feet.
6 feet. All right. What sports did you play in the past in which you received concussions?
I ran track and then I tried football, and that is kind of what led to the concussions. And then from there, I started fighting in high school. I was a bad kid around that time of like from 14 to 16. And first concussion was through sports, and the second one was through fighting. And then the third one is where the gun came in. So yeah.
One through football, not track.
Yeah.
One through, we'll call it boxing. It just wasn't sanctioned boxing.
Yeah, boxing. UFC. Sure. Yeah, we'll do that. UFC,
okay.
Yeah.
All right. Question about how you testified about being able to see skin on the two assailants between gloves and sleeves, but you also testified there was a gray hoodie and a black hoodie.
Yeah.
So help the jurors understand how and where you saw skin on the arms.
So when I remember specifically when he was trying to take my shoes off, like I was fighting, kicking back, and like when he's pulling on my shoes, his sleeve started to pull back, so you could see the skin color, and I kicked him. And then at some point, I just figured out that he was an African American male, and that's how I came to the conclusion. Obviously, seeing the skin color. Becca also saw the skin color.
Okay,
sorry, didn't mean to.
Okay, that's okay. Don't talk about what Becca said.
Yep.
All right. Did you see any other part of either of the assailants' uncovered bodies?
Not to my recollection, no.
Okay. You testified that there was cash upstairs. If you orient us, there was the room with the blood on the floor. Upstairs means upstairs from the room with the blood?
It's like literally directly above the.
Okay. Yeah. And how much cash was upstairs?
Probably between the three people, like 12 to 15 grand. I'd say 15 max.
Whose money was it?
It was me, Chris, and another person who was not involved in this named Victor.
Not Victor,
not the DJ.
DJ, different Victor.
Different Victor.
Okay. Did you submit to any type of blood alcohol content or drug content testing that night after the police arrived?
Whatever the EMS asked me to do, I was in full compliance with them. I just wasn't going to the hospital because I knew that I had to fight to catch.
Okay.
So whatever I don't really like. I was in and out through the shock. When I was in the ambulance is when the shock really set in. So whatever they did in the ambulance is what they got.
So
They treated you in the back of the ambulance, but did not transport you to an emergency room?
no,
Okay, so you were never in an emergency room hospital where they would draw blood?
yes.
Okay.
Yes. So my main focus was again, just trying to get out of Georgia.
Get out of Georgia. Well,
Out of
welcome back.
Atlanta. Yeah.
Okay. Ms. Green, do you have any questions for Mr. Heil based on the exchange he and I just had? Ms. Mignot?
Did EMS provide any medication to you?
No. Oh, I think they gave me Advil. Yeah, I requested Advil. Or Tylenol, something for the headache.
Where did you put the drugs that was upstairs and the $15,000 once the police arrived?
It was still up there. I'm pretty sure the assailants took most of what we had. The cash was hidden. I don't recall exactly what happened to it, honestly, after that.
Okay.
Yeah.
So you never got your $15,000 back?
No, we got it back. I just don't recall exactly what happened to it after the incidents.
Okay.
Yeah, I don't know where one of the three put it somewhere.
Isn't it true that on the date of the incident, you were wearing black and white tennis shoes?
No, I was wearing my airsoft ones. I had black and white Air Jordan ones, and then for the party, I changed into my different outfit, my party outfit, and which was the yellow off-white Air Force ones.
So if there's
and my Travis Scott hoodie.
I apologize, go ahead.
And my Travis Scott hoodie.
So if you're in your Travis Scott hoodie with black and white Air Force Ones on, you would have had those on at the time of the incident?
No, I had the Air Force Ones on at the time of the incident. I remember changing out of that outfit probably around 9 to 10 p.m.
Were you arrested for anything?
No.
Were you granted immunity in this case?
I've never been charged for this case.
No, my question is, were you granted immunity from the criminal conduct you just admitted in this courtroom today?
Yes.
When were you granted immunity, sir?
I'm not sure. Can you rephrase that?
Okay. When did the state say to you, you have immunity?
I don't know.
It was before now, correct?
Yeah.
And after the incident, correct?
I guess so.
Thank you, sir. Nothing further.
So Ms. Mignot, in the future, there wasn't an objection, but I'm going to tell you, your follow-up with the juror questions is limited to the space that the jurors explored. No sneakers, no immunity, no arrests. So the answers are evidence, but we need to cabin the follow-up to what was brought up by the jurors.
So Judge, may I, because of those?
Yes, you may, because we went into an area not covered by the jurors.
Okay.
Yeah, I'm confused.
Thank you, Your Honor. Jackson, do you know what immunity is?
I'm so confused.
Okay. Did I or the state promise?
Yes.
So remember what Ms. Mignot told you, which is don't answer the question till it's obvious. It's not Jeopardy. You cannot buzz in early, because she might have gone on to say, are you lying in all your answers? You just belted out yes. Wait till she finishes her question.
Okay. Yes, sir.
So you were just asked maybe 3 or 4 questions about something called immunity.
Uh-huh.
You stated you're confused.
Yes.
Do you know what immunity is?
That's where you're granted, I guess, free of charge. I guess. Maybe.
Do you know? Is that?
That's my guess. I don't know the definition, no.
I talked to you about that?
I think me and Reeves talked about it.
Okay. And what was that conversation to you?
Anything that I brought up with the drugs in court would not be used against me.
Do you recall in that same conversation discussing statute of limitations?
Yes or no?
Yes.
Okay, and that you would not be charged due to the statute of limitations?
Yes.
And the state asked you to be truthful in your testimony?
Yes.
Okay. And do you remember when that conversation occurred?
what was it, Wednesday of last week? Wednesday, yeah,
Wednesday of last week.
yeah,
So is your testimony that that conversation happened Wednesday of
yeah.
last week? Okay, thank you.
So for the accused, do you have any follow-up questions for this witness? We've had a little more bit of an exchange, and I make sure if there's something you want to ask, you get a chance to do that.
Not necessarily a follow-up question. I just want to clarify where the shoes green or yellow. I heard yellow and I heard green. I'm not sure what that.
Virgil Abloh, I guess, has a color combination of lime green and highlighter yellow. I can pull up a picture for you if you want to see them.
Well, you actually can't pull up any pictures, but State's Exhibit 16 is in evidence. It sounds like the question was, how would you describe it? So what words would you use to describe the color of the shoes?
A mix between lime green and highlighter yellow. In the picture on Exhibit 16,
can we put up 16, please?
Yeah. So there's a blue light in the background, which makes the color of the shoes appear a little bit more lime green than their highlighter yellow. So
it's going to be on the screen in front of you. You don't have to crane your neck.
yeah, so they're, I guess, more of like a lime green right now, but without the blue light, they're more of like a highlighter yellow.
Deputy Gordon, can you rotate the screen at the podium so that it faces the accused so he can see? Thank you. Are you able to see that a little better than whatever you were trying to look at? Okay, good. All right. That is it. Mr. Heil, thank you for your time.
Thank you.
You are free to go.
Cool.
Ladies and gentlemen, we're going to take our afternoon break. Give me 1 second. Can you take the picture down, please? All right. We're going to take our afternoon break. Please don't discuss the case. Do any outside research. Enjoy the jury room. If you're running low on any of the snacks in the big white basket, let Deputy Gordon know and we will replenish as available. And we'll get you back out here for a little more testimony before we wrap up the day. You have an event. We go until 5. We'll stop as close to 5 as we can. Tomorrow is Wednesday. In the morning, I have drug court. I will be having a bunch of folks who are participating in an accountability court. That takes up the morning. We're going to start at 12:30 tomorrow. So you should show up if you're a lunch eater with food in your tummy. Don't expect to get a lunch break because we'll hit the ground running at 12:30 with witness testimony. It would be great if we could go to 5:30 or 6 tomorrow, but it's Passover. And so I'm going to ask you all to talk amongst yourselves during this break so that you can let me know how late we can go tomorrow because of the late start. The late start is not a surprise to the lawyers. When I was giving you the estimate of how long we thought the trial would go, they knew that Thursday was a little more than a half day because of my drug court obligations. We didn't know we'd get the late start that we did today, but we're going to keep pressing on. So do talk amongst yourselves to see how late tomorrow you could go. Today, we'll stop real close to 5, maybe a little before, a little after. As I said, it depends on where we are with the witness. Any logistical questions? Nope. Enjoy your break.
All right, adjourned.
Yeah.
Mr. Hiles or Ms. Green, anything from the state before we break?
There you are.
Ms. Mignot, anything on behalf of Mr. Robinson?
No, Your Honor, nothing for Mr. Robinson.
All right, and last but not least, the accused, anything we need to talk about before we take a break?
No.
Okay, my plan is to bring you right back out, just like I'm going to bring Mr. Robinson out when we're done with the break. Are you good coming back in each time, or do we need to have a discussion each time when you come back?
We may have a discussion, but I'm going to come back.
Okay, we'll bring you back. Thank you. Let's all be back here on the clock on the wall, and you can coordinate it with your phones at 4:05. So do the math on your phones, but 4:05 on that special clock. Let's be back here.
Yeah, let's be back now.
What's going on, yeah? How you doing?
We've got some impressive performance by your deputies here. It's a complicated setup for this trial.
I heard.
You need me to go?
No, I was asking about him going read the cards.
Yeah, no, I just wasn't sure. I mean, like, he needed to see him. Like, hey, would you stand there? You could be there with us. Not so much? Okay. It didn't hurt to ask. It made you laugh, though. Like, what? Out there? Imagine him going down the hall. I'm going to go see Glanville.
No way.
Even if he's got, like, all his gear on? Okay, all right. Okay, I figured. Complicated.
The other thing. I know. I didn't want to sanction. Illegal. I mean, we were good. That was for free. No, we could be done for it. It's not that. No. Yeah. Oh, yeah. Oh, you're close to time, yes. No, I think we gotta keep stuff, keep taking time. They slow down the courthouse? Just in a different location every day. Oh, you talking about them? I didn't even need keys right here. That's cool. Yeah, I was like, that's hard. All right, boy. All right, that's it. You know, real quick as the best. Yeah. Yeah, real quick.
When you get a shit, you're trying to like.
All that. So, they can ask you those questions. Oh, yeah.
Which one? Oh, yeah, that they want to see.
You could have been.
You keep it in the suspense.
Yeah, they drift.
That was never on my list of things to do. I thought you were doing other things.
Yeah. Anything I can.
Only thing you gave me was the switch.
Well, that's because you were. He said.
I know, ooh, I didn't want to fell out of my I know you were right.
I know.
You were praised.
I got a better.
I've been running on fuel.
It's like, I think they.
I've been running you.
Yeah, no, we didn't know until he said it, and now I'm like, oh, yeah, he said it. I mean, you're being this, tell me. So I didn't think this was such a.
Oh, yeah. Oh, yeah.
I thought it was, they said.
What he did out there, Matt, he did say, well, I know.
Is that what she's doing? She's canceling. Well, we cancel.
So like, it's still
Cancel culture.
Yeah. I can't, it's not working.
You are using your phone.
Okay, so my baby has what's called a Dexcom, right? Best invention in the whole wide world. Like when I stop Maximo, I'm gonna invest in type 1 diabetics because there's the kids that have it and there's technology. It can be
How old your child?
just turned 19. Yeah. So he hasn't graduated high school yet.
You said that he's got some.
He's autistic.
Yeah, that's what you're
And I wear it like a badge, because that's my baby. And he's got an excuse, so he wears a pencil.
Well, the Lord, I see. That's gonna be. Yeah, but it's only one. That's the one.
Can we get Mr. Robinson, please? Actually, you bring him out whatever order you want. Apparently, we'll have Mr. Pritchett too, so whatever order you want to bring him out. I thought you might mix it up. Pritchett first.
Just don't let it come in. Really good.
Who's our next witness?
I'm
Holden
joking.
Carmen.
You're not sharing those trail mix and it
I
looks like
see
they're
him
pretty
chewing,
good. I see them
yeah.
chewing.
Where's the chairman?
No, so that row of students, my sister-in-law is their teacher, and when they come and I interact with them, I get a box of Tiff's treats. So I was eating a Tiff's treats.
That's good stuff.
That's a good sister-in-law.
I need to find a sister-in-law that's got some kids.
Yep.
He's got the carbs today.
Yep. Not a lot of protein in those oatmeal raisin cookies.
Eggs. They have eggs.
All right, Ms. Rivers, are you ready? Let's get back on the record. Mr. Hiles or Ms. Green, anything from the state before we bring the jurors back in?
Yes, I do want to, I would like to address this with you, on the record. Mr. Pritchett, the accused, I think he's entitled to be part of our conversation since he's representing himself. I know it's a production to take the jurors out. Every time we have to go over questions and have a discussion. But I don't want him, since he's representing himself and now electing to participate, to be left out of those discussions and cause something that, even though it's a production to send the jurors out, it might be a bigger production doing this again. I don't want to create any reversible error by leaving him out of those bench conferences, so to say.
If he is given the same opportunity to review the questions, tell me what you understand the harm to be, just that he's not participating in that particular exchange.
Well, I think it's more of an abundance of caution, but the conversation about what questions that you will and will not ask, and if there's a reason you're not going to ask them, that's the one, the conversation piece that I'm referring to.
Okay, and in the one instance, since we've been reunited, that we went back there actually wasn't such a discussion, but your point is there could be, and if there is, we all ought to participate in it. Okay, you're probably right. What we had to do in another trial I had, where there just were too many lawyers to have it make sense, and one of the lawyers for the defendant insisted that his client be a part of it, is that we made the jury step out. So that's probably what we'll do. All right, Ms. Mignot, anything on behalf of Mr. Robinson?
Nothing further, Judge.
All right, and on behalf of the accused, anything we need to talk about before the jurors come back in? You have a pen, correct?
Yeah, I have.
Okay.
It's in my work computer.
Well, if it's not working, I'll get you one that works.
Please. Please.
Okay?
Just really just discovery issues, the things that I haven't seen, and, you know, and the witnesses that I haven't been aware of. Can you prohibit the state from entering that in, because it's like I said, I have no awareness of some of the things that are going on. You know, of course, like I said, I still don't understand the nature and cause of the jurisdiction of the court. I have sat down, you know, to, you know, at least stop disruption. But like I said, just the things that I'm not aware of as far as the discovery that, you know, wasn't presented to me, can you prohibit the state from entering that? Because like I said, I don't, some, a lot of the things I haven't never seen and never even heard, you know, what he said.
Okay, what I will do is ask Mr. Hiles to get you a copy of the witness list. I don't think we got you that because I had that thought originally, but then you were choosing not to be out here. But now you're out here. We'll make sure you get a copy of the witness list. Here it comes. Thank you, Mr. Hiles. I'm not going to require the state to exclude, I'm not going to exclude anything from the state's case that was part of discovery that was properly provided to any one of your previous counsel. If there is something in particular, not videos or anything like that, that you'd like to see or get a copy of, I could make sure we get a copy of a police report or something like that. I don't know what's in, you have, the record should be clear. You got about 3 inches worth of paper with you. I don't know what's in there, if it's your legal research or if it is some of the paper part of the discovery or what.
If you want to see the paper,
I don't in particular, it's your belongings.
nothing what previously attorneys, you know, gave me. They gave me very minimum. Like I said, most of it was warrants and mainly warrants.
Hold on 1 second. Can you stop the clicky thing? Just, he's hard to hear. When it's a louder person, you can do your little whiteout tape. Thank you.
Yeah, like I said, I just received the bare minimum, you know, of what I thought I was entitled to see.
Okay. Mr. Hiles, is there any part of the paper discovery that is fairly central to what you and Ms. Green will be covering with witnesses? Or it's lots of witnesses, so it's lots of reports?
Well,
I think the lead, no, I'm not introducing necessarily any paper discovery.
No, that wasn't, I didn't ask the question well. I wouldn't expect you to try to introduce Maldonado's report, for example. My question was, is there a report or a series of reports that would be pretty easy either for you to email, and my staff could print them out, where then Mr. Pritchett, the accused, would have sort of the core of discovery? And I don't know if such a thing exists, or, you know, look, each witness gave a statement, there's a recording, and I can't get him recordings. That's not how this works. And he and I discussed that before.
I don't know what he already has in those stacked papers. It would be the reports, probably spans like, I'm not uncomfortable with the names and addresses going back to the jail. That would be.
So you'd have to engage in some redaction anyway.
Yes.
Okay.
Nothing if the reports only names and addresses that are listed.
Right.
I don't have any problem.
Well, it's just not your job right now in the middle of trial. So I just wasn't sure if there was something in particular. All right, I'll think about that some more. Let's bring the jurors out, please.
All right, for the jury. jurors are present and accounted for.
Thank you, Deputy Gordon. Ladies and gentlemen, we are set to resume. Mr. Hiles, if you'll call your next witness, please.
It would be calling Mr. Holden Carmody.
Before you sit, can you turn around and raise your right hand? Do you swear affirm that testimony you will be able to the truth, the whole truth, and nothing but truth so help you God? Yeah. Put it on there, please. Can you state and spell your name for the record?
Holden Michael Carmody.
All right, Holden. How old are you, Holden?
23 years old.
Where are you currently living?
Charleston, South Carolina.
Is that where you're from?
Yes, Your Honor. Yes, sir.
So, where were you living? What were you doing in November 2019?
I was currently living in Charleston, still working at PF Chang's, and then I went out to LA to go see a friend of mine, Jackson.
Okay. Was that a visit or did you move to LA?
It was a visit at the moment.
Okay. And when was this? What time of year?
When I visited?
Yes.
Around about maybe a week before I went to Atlanta, maybe about a week, 5 days, around there.
Okay. So the end of October, beginning of November?
Yeah, about.
Okay. All right. Well, you just brought it out. Why did you come to Atlanta in November of 2019?
I came to Atlanta with Jackson because our flight was out of here to go to Houston for the Travis Scott concert.
Okay. And do you remember what date that was?
That I got here?
Yeah.
I think the 18th.
Okay. So that's fine. Where did you stay when you came to Atlanta?
At an Airbnb.
Okay. And who obtained that Airbnb? Who all was part of hosting that Airbnb?
Hosting it or renting?
Renting it. Who paid for it?
Jackson and Chris.
Okay. And what's Chris's last name?
Chris Riggs.
Okay. And what was your reasoning for coming to Atlanta?
As far as I knew, I was traveling with Jackson he had a couple of friends up here that he wanted to see, and we had already planned to get our flights out of Atlanta as it was just cheaper, and it's about a 3.5 hour drive for me. So made that decision with him. We were like, we'll stay for a day and then get out of here, go straight to Houston. And yeah, that was pretty much my reasoning for coming.
And while you were here in Atlanta, how much time did you actually spend in Atlanta?
I want to say probably about 28 hours total.
And do you remember looking at pictures of that particular Airbnb? Did we have a conversation prior to your testimony?
Yes.
Okay. And do you remember going over pictures of that particular Airbnb?
Yes.
Okay. So let's talk about our conversation and explain to the jury what stands out to you about what happened at that Airbnb.
Can you repeat the question? What do you mean by what stands out? Like what?
So what sort of the events that happened? Okay.
Yeah.
I'm going to direct your attention to November 8th of 2019, early morning hours. What was going on at that Airbnb?
Well, we were having a party at first.
Okay. How many people were at the party?
Max, I'd say it was probably around maybe 18 to 20 people at most at one point. I wouldn't even really call it a party. I'd say it was more of like a get together, a kickback. It was probably at one point that I could remember totally about 11 of us 11 of us just all hanging out, drinking, having fun, just playing games. There was never a moment where there was a lot of people in the house and it was a bunch of unrecognizable faces throughout everyone. I didn't really know that many people besides Chris and Jackson. Most of the people that were there knew Chris or Jackson. So
When you say Chris, which Chris?
Chris Riggs.
So you met, how close were you with Riggs?
I had just met him. That was it. It's the only time I'd ever met him, only time I'd ever seen him, hadn't have known him prior.
How close were you with Jackson?
Jackson, we had went to high school together and we were known, we both knew each other. And we were never really close friends then. And then later in 2019, we were able to get closer and we became closer friends right then. And then we decided to make the plan. I came out to LA, we got closer then, and then we came back down here. And that's how we kind of were a lot closer friends because we were spending more time with each other. I just talked more. And so by that time, I'd say we were pretty good friends. So probably knew each other for about a year at that point, like of actual friendship and discussing with each other, constant keeping up.
So did you feel comfortable in the house with the people that Riggs and Jackson had introduced you to?
At the moment before things went down and I knew things were wrong, 100% yes. Never would have broken a sweat or turned an eye.
Okay. When did things seem weird for you?
The moment the two girls walked in.
The moment the two girls walked in. Okay. Now these two girls that arrived, did you know them?
Nope. I'd known that they were coming.
Okay. How did you know that they were coming?
Because Chris had told us that these two girls he had known were coming over.
Okay. Now, again, I'm going to ask you.
Sorry, Chris Riggs.
Okay. So if you're referring,
excuse me,
you're referring to Chris Riggs, would you please refer to him as Riggs?
Yes, Riggs.
All right. And at what point did these girls come over?
Ooh. It was like, that was when basically the only people left there were the people that pretty much who Chris was, I would say, closely good friends with. All people that Chris and Jackson knew on a personal scale to have at the house and maybe even sleep there because we were pretty much winding down and calling it a night. I think they came in at about 1 a.m. maybe. 1 a.m. they came in. I couldn't really call as it was so long ago.
Yes.
I would say yes. I knew it was late at night. I could not tell you the exact time. It was so long ago and it was late at night. I was tired. And yeah, I just know it was late.
What was odd about those girls when they came in?
Everything from their body language to how they walked, how they chose to not talk to a lot of us. Their eyes kept moving all over the places as if they were looking for exit points or things that stood out. It just didn't make sense to me. I had introduced myself. They completely disregarded me, kept moving about their way. So right there, that definitely said something to me like, huh, that's odd. You're not going to say some hello to the person who's letting you in the house.
Okay. How long were the girls present?
How long were they present? 10, 15 minutes, maybe, probably less. I would probably say 7, 8 minutes total, realistically. It was quick.
How long ago was this?
5 years.
Okay. Are these time frames you're giving estimates?
A lot, yeah. As like I said, it was 5 years ago, so I'm not going to be able to perfectly remember the exact time.
What happened after the girls arrived?
Basically, they were just like going through the house downstairs first. Then they walked upstairs. I can't recall why they went upstairs, probably to smoke or something. But I just remember when I followed them upstairs, one of them out of the blue said she needed backwoods, which was just very odd to me, as I remembered someone was already smoking. And so
what are backwoods?
Backwoods are basically a wrap you use they're tobacco. You just roll it out, get all the tobacco out, and then you fill it with weed or whatever you choose. But most times marijuana. And right off rip when she said that, it didn't sit right with me, as she probably would have came in already with those. Someone probably here has them. And just the quick advancement of leaving the room of when she said she needed that stood out to me already, from how they were just looking around the room everywhere at everything. Just nothing about them seemed calm or like they were here to stay.
All right. Who arrived after the girls? Who were the next people to come in the house?
Two masked men with guns.
Okay.
Large guns.
Had you ever met these men before?
I don't think so, not to my memory. As again, like I said, they were wearing masks, so no.
Okay. What kind of guns did you do? Or, did you give a statement to police?
I think I did, yeah, because I did talk to the police. I don't know if I recalled telling them the gun, as I was very shell shocked in the moment, and I just had a gun waved in my face and hit with it. So,
Did you speak with me about the incident, types of guns?
yes.
And how did you describe the guns to me?
I described the guns to you as being a large assault rifle that looked very similar to what an AK-47 would look like, but it was not large as an AK-47. So I think it was either what's called a Draco or a modded AK.
Did you ever describe them to me as an AR style pistol?
I don't think I used the AR style pistol to you, but I definitely recall saying it was somewhat of an assault rifle. Maybe not AR pistol, but definitely assault rifle.
All right. I'm going to show you what has been marked and admitted as State's Exhibit 7.
It's like I have something on my screen. Should I hit unmute?
No, say,
Stay muted.
stay muted. Yep. Thank you.
All right. All right. Do you recognize this picture?
Absolutely.
Okay. And what is this picture to you?
That's where I was sitting actually when they walked in.
Okay. Who is they?
The intruders.
Okay. Masked men?
Yes, the masked men that had the weapons that
Was
committed
anything
the
said
overrun.
during when they made entry?
Say it again.
Was anything said by the masked men when they made entry?
As soon as they entered, one of them said, "Get the fuck down."
Okay.
And then after that, I don't remember much, because like right as he said that, he was already about gun out through the door. Jackson's already stood up to try to be like, what the fuck's, I mean, he was just confused, saying what's going on. And that's when I'm pretty sure it just triggered, get the fuck down, or because it's a robbery. He's telling us to get down. But as soon as he walked in, he says, get the fuck down. Immediately, I'm just, what the fuck's going on? Sorry, excuse my French. What's going on? And I had no idea if this is real or not. They had masks. So I immediately hit the floor as there's a gun waving in my face. And from there, it kind of just all hell broke loose. Everyone's like yelling and screaming for a second. One of them immediately runs upstairs while the other one was downstairs, thus trying to keep us just held tight and not going anywhere, I guess.
Was anybody attacked physically?
In the first moments, yes, Jackson was whacked over the side of the head. I saw that before I hit the floor because he literally shot up right as the door opened. It was almost like it was like a fight or flight reaction. And they immediately whacked him over the top of the head. So he hit the floor too. After that, you kind of just could hear a lot of rambling because at that point, I'm looking at the ground and one of them's already probably running up the stairs. Like the stairs was a weird stairway, it kind of like turned really sharp and then goes up. So as soon as that happened, I just hear him running up the stairs and the other one's downstairs, shit's getting broken. I hear people's bodies moving. I'm still just kind of trying to focus on the ground as I feel as if I look up, I might get shot in the head. So I had no idea what to do or who's even getting hurt at that point. And that all felt like it just felt like it was going by so fast, but I couldn't really tell how much time that I was down on the ground for, so I don't know how many people were getting hurt in that exact moment once I hit the floor, because there was a few of us down there.
Did you have any property taken from you?
Yes, my wallet and my Invisalign.
Invisalign?
Yes, which my
Like they took it out of your mouth?
Well, one of them first asked what was in my mouth or if it was in my mouth because he opened my book bag and he said, "What the fuck is this?" And it was they basically give you, I'm pretty sure it's weekly, and you change them out each week. And he was like, "What's this?" And it was just full of the retainers. And I go, "What does it look like?" It's pretty self-explanatory. And as soon as I said that, it was clear he didn't like the condescending tone I gave him. So he kicked me in the face. And that sent me back for a moment. I thought my nose was broken. So after that, he took the Invisalign and my wallet. Because then once I was on my back, he started grabbing my pockets and being like, "What else do you have?" And I was like, nothing, just obviously lying. And he took my phone and my wallet and then just threw the phone on the ground and then left with the wallet and the Invisalign and left the book bag too.
He actually took your Invisalign?
Yeah, I have no idea why, but he took them, oddly enough.
What about your wallet? So, were you ever able to recover that wallet?
Yes, actually I was.
Okay. And how did you recover that wallet?
I recovered the wallet because someone who lived, I'm almost certain it was the street behind or over, I don't recall. It was placed in his yard. He called me about 8 to 12 hours after the incident. Once I was in Houston, I'd just gotten off the flight to let me know that he had found my wallet because thankfully I had my ID in there. So he was able to trace it back to my number, give me a call and let me know, "Hey man, your wallet was in my yard." And so I retrieved it when I came back from Houston to Atlanta airport.
If you didn't have your wallet, how were you able to board the flight?
I had to go through a screening with the TSA agents that required me to verify where my father and my mother lived, what their maiden names were, birthday, just questions about my life and their life that would prove I was who I was representing, which would be Holden Carmody.
And so you got the wallet back. Did you meet this individual? Where did you meet this individual?
I met him at the airport. He actually met me right outside of the entrance to the airport.
So if you look at your screen, if you look at the bottom corner, there's a little tool, or tap it once.
Right here.
To the left. You'll see that stylus, if you tap that.
Yeah.
So you'll be able to draw, and then you'll see on there's also a eraser mode to put it in.
Yeah.
So, all right. If you could, would you please tell the jury by circling where you were sitting when the armed assailants came in?
Yeah. I would say it was about right here.
Okay. Were you sitting or standing?
Sitting.
Okay. Describe what they were wearing.
So if you've ever seen the movie The Purge, the first thing that I took to was that it looked like one of the masks that's worn in that movie. And it's like this creepy Halloween mask, just it looks very sinister. And then another mask I saw, it looked exactly like this monkey that's specifically from a video game called Grand Theft Auto. That immediately stood out to me as well, because I'm like, I've seen that in the video game. Like, why does that look so familiar? And it was just this one weird looking monkey mask with almost like ears on the top of it, but I couldn't see the ears. That's just what I remembered as. And because it so closely resembled a mask that I had been used to seeing so much in a video game. And I was like, wow, I cannot forget that. That's a very creepy monkey mask. And then the other mask almost looked like a clown face, but wasn't a clown, just a creepy smile on it.
Okay. And was everybody completely covered?
Yeah, for the face part, yes. Yeah, for the face, yeah, 100% was covered.
Were you able to determine anybody's race?
100%, yeah, I could see it in their hands.
Okay. Okay. Do you recall if they were wearing gloves?
I'm almost certain they weren't wearing gloves, as I could see, as soon as I saw the gun, I could see his fingers. And especially because I saw it on the trigger. So that's what immediately triggered my thought to thinking, I'm gonna get shot. Maybe let's not try to get up or do anything crazy.
Now, who else was present in this particular room when these armed invaders came in?
If I recalled correctly, it would be me, Jackson, Rebecca. Chris was asleep on the couch. Not Riggs, sorry. Not Riggs, the other Chris. I forget his last name. I think it's Hooper. He was asleep on the couch. Jackson, Rebecca, and then Noah, I'm pretty sure, was also downstairs as well.
Do you recall where they were sitting or just that they were present?
I do not recall where they were sitting. No, I don't. I just remember that they were present. I'm almost certain Noah was next to me on the couch as Chase was on that couch sleeping.
We've talked in preparation for your testimony, correct?
Yes.
We discussed the presence of drugs at this party.
Yes.
Okay. What sort of drugs were present at the party?
So I know Jackson was doing some ketamine. As far as I knew prior to that, there was weed. There was a decent amount of weed there. There was a lot of smoking, alcohol. Aside from that, I didn't recall seeing any other drugs.
Okay. What form was the marijuana in?
Mostly edibles. It was, I'd say, just a large abundance of edibles.
Okay. Was that the target of the invasion?
Objection, Your Honor, leading.
Do you know what was targeted? As far as property, what was demanded from the armed assailants?
I figured a bit of that out once one of them was using me as the ploy to go find it, and basically as like a hostage. He asked me where the money was, and I immediately go, I don't know what you're talking about. And then from there, while searching all over he takes me upstairs, the gun to my head, to the second floor, doesn't find anything in any of the rooms, leads me to the third room, which is upstairs, and then he finds the edibles. And so then he starts just grabbing away and still is wondering, he's like, where's the money? Throwing shit around, telling me like, give me the money. I have no idea what he's talking about. I knew nothing about any money being there. I didn't see any money, so I couldn't help him. He was just grabbing all the edibles out of the bag that was placed basically directly in front of me when we went upstairs. It was like at the edge of the bed, and he just starts grabbing away with his back turned to me.
Bring your attention now to what's previously been admitted as State's Exhibit 22, which is identified as doorbell footage in front of the house. Do you recognize the front of this house?
Yes.
I'm sorry, it's because of I'm playing video with sound, you're gonna have to turn. All right. And is that the Airbnb that you were staying in on that night?
Yes, I don't forget it.
Does that? This is at the 6-second mark of the video of State's Exhibit 22 of armed suspects entering the house. Do you recognize what the first individual to walk on the porch pulls out of his bag? Did you recognize what was pulled out of the bag?
Yes,
Okay, and what did you recognize that to be?
an assault rifle or an assault rifle-like pistol, maybe, like I was saying, like you said earlier, an assault pistol.
Did it have a full stock on the back end of it? Or was it just a handle?
It looked like it had it didn't look like it had a bump on it. It just looked like it had a handle and then a big drum on it. Like 30 rounds, I'd say. Looked like it was enough to hold a decent amount of ammo.
And what were your thoughts when you initially saw that firearm?
I'm gonna die. I'm gonna get shot in the head tonight.
Okay. Did you have any actual, outside of what the comments with the Invisalign, did you have any other dialogue with these individuals?
Aside from when he had the gun to my head to be like, let's go, and basically walk me around the house and to try to find the money and I guess to find the other stuff that he was looking for. Just being like, no, I don't know where it is. Like, I just kept saying, I don't know where it is. I don't know what you're talking about. I don't know what you're looking for. That's really all the dialogue that went down between us. And then the dialogue that when they were basically going through my book bag and he said, what is this? And I further told him what it was. That was about it.
Play some more of these videos.
What's this one called?
Sorry. This is still State's Exhibit 22. It is labeled in the discovery and turnover as girls arrived to party. Did you, or whoever let the girls in, were they unlocking the door to let them in?
As you can see in that video, that's actually me unlocking the door and opening it up for them.
Okay. Did you make a point to keep the door locked throughout the night as people were
Yes.
coming and going?
Yes.
Okay, why?
Because we knew we were in a dangerous neighborhood and just I've always been taught to lock the door behind me, especially considering that we were young and we had the edibles in there and that we were in an Airbnb throwing a slight party. So probably just didn't want any random associates walking into that house.
And you mentioned girls looking for backwoods. I want you to pay attention. This is the still State's Exhibit 22, labeled as LR leaves party inside the exhibit.
Your Honor, I just want to be clear for the record.
Pause.
Yeah.
Yes, ma'am.
So 22 was tendered, as if it were one clip, but it appears that 22 is several clips. If we could label it just for purposes of reference, each video as 22A, B, C, so that it's clear because it looks like there's more than one different clip.
Okay, so two things. One, my recollection is that when Mr. Grady testified, he said it's a bunch of clips from the Ring camera at 1040 Wiley, his arbitrage, Fort Fiesta. But two, it would be helpful if we did that. We're not gonna do it right now, but you're gonna agree with Ms. Mignot and the accused with some kind of nomenclature, because the record is already gonna be a little spotty. You are occasionally remembering to give the name of the clip, and the name of the clip is something like girls walk into building. So let's give them letter number, letter designation. So 22A, 22B. Don't do that right now. Keep going right now. Okay?
Go forward.
Yes, sir. Well, like after today. Yes. Thank you.
For the record, as it is labeled now, it is labeled LR Leaves Party.
Okay.
Yeah. I don't think I have them. Oh, yeah, I do.
Was that the exchange that you were referring to earlier?
That was the exchange when she was claiming she was going to get the backwoods.
And this is the last video I'm going to play with you. It's labeled for the record states Exhibit 22. It is labeled as armed suspects leave party. I'm going to move now to what is labeled States Exhibit 1A. It is the audio of the 911 call, previously admitted through Ms. Latner's.
And about the one number, 363 was the address of the what? See, what's the other, what's the other, what's the address? What's the address? 1040 Wiley Street. Okay, 1040 Raleigh. Yep. 1040 Raleigh Street. Just about two African American men. Gun coming to our face, please help us. Okay. And we heard all of us in the summer law. Anything else for something we're gonna do, we need your help now. Okay, sir. And there's a house on Park. I know, see, and we need your, Okay, did anybody get shot? No, he's just bleeding. He's just leaving a lot on the top head, he has stopped in the face. I need you right now, I'm not. Okay, yes, sir. He's fine, that's a lot of help. Hi, this is, 1040 Wire Street, hello, sir? Yeah, 1040 Wire Street. Okay, is that house business or first? So, just for the job, hang on. What's the phone number you're calling from? It was 3-812-700. And your name? Oh, we come on all and everything. So tell me exactly what happened. No. This was found at gunpoint, lady, and one person got hurt. Okay, thanks. Now, please get here now, he's done. I need your help now. What do you mean he's dying? What happened? He fell to the floor now, and he's bleeding from his head. He fell? Okay. Yeah, he's up now. Okay, he's up. Huh? Sir, how many people are injured? 3 or 4. I mean, are you with them now? Yes, I'm with them. Okay, then how many people are injured? 3 or 4? 3 to 4. 4 people are injured now. Just send back up right now. Is everyone awake? Yes, everyone's awake. Is everyone breathing? Yes. Are they male or female? Male and one female. Hurry, please come. Sir, listen, the ambulance is on the way. I need you to focus on answering my questions right now, because you talking to me is not slowing anything down, okay? All right, is everyone breathing? Yes, ma'am, everyone's breathing. Okay, is the assailant still nearby? Is the what still nearby? Assailant. Is the people like the attackers? Yes. No, I don't know. Okay. And they had a gun, any other weapons? Yes, 2 weapons. What was the other weapon? Two ARs. They're large ARs. Okay, and you said someone's bleeding from the head. Is there serious bleeding? Yes, it's serious bleeding. Okay. Is everyone completely alert? Yes, everyone is very, very comfortable. What now, right? Okay, your friend is bleeding from the head. I know that. Sir, listen, calm down for me. I understand you want to wait. I'm gonna give you some instructions. I need you to listen carefully to make sure we do it right. I need you to get a clean, dry cloth or a towel and place it right on the room. Press down firmly and don't lift it up to look. Wait there. Okay, I know you did. But then you're gonna be okay, right? I told you to come to the okay. So, let's not happen. So, hello? I'm not we should okay, I need a description, right? Okay. Sir? Yeah, no, I'm not need no, sir. We need a description of the assailant for the police. Okay, they were wearing all black. They both was wearing all black? One guy was black, the other was black. They were calling you okay. Okay, one man was black, he had a mask on, and what color clothes was he wearing? Okay, no. Okay, sir, is that bleeding controlled now? Yes. Okay, good. All right. What about the second assailant? We make black, white, and black, you know? They were both black. But sometimes it's almost the same. Do you have a camera? Just can you plug it in and you can stay on the phone with me? Is there another phone in the house? Oh, no. No one else has a cell phone that you can give me the number? Sir, this is so, did they leave on foot or were they in a vehicle? I think you're right. Okay. All right, thanks, Greg. We will definitely be safe. Yeah. Thank you. Start fire also for the, multiple victims, we gotta start fire. Okay.
Do you recall making that 911 call?
Yeah.
All right. What was going through your mind at the time of making that call?
You know, as much as I want to say it was focused on the robbery, I was more so thinking that someone's about to die in my eyesight because of how much blood I saw coming from his head and the fact that he stood up and then he fell down because he didn't even have enough, what I'm assuming is blood or energy to be even able to walk. Because he tried standing up, and as soon as that happened, you can hear on the call, I'd say he's up, and then nope, he's back on the floor. So honestly, I was thinking that I'm actually about to witness someone die. So making that call, I was just very scared and still so confused because I had just gotten robbed, and now not even a minute later, I'm focused on hoping that this ambulance can get here in time because this guy that's literally in my hands is about to bleed out all over me.
This guy that you keep referring to, who would that be?
The guy would be the DJ.
Did you know him before this incident took place?
No, I did not.
That night or the early morning hours of November 8th would have been the first
That was
time.
the first time I've ever met him.
So what did you do? You said you were kicked in the face.
Mhm.
Were you kicked? Did you say you were kicked or did you say you were kicked?
Both.
Were you given the opportunity to seek medical attention?
Prior to the ambulance getting there?
Well, once the ambulance arrived, were you given the opportunity to seek
Oh,
medical
of
attention?
course, yes.
Okay. Did you go to the hospital or did you go anywhere to seek medical attention?
Seeing that I was not bleeding anywhere and my head wasn't raging with a headache, so I assumed I didn't have a concussion. No, I did not. Besides just like the eye light, but no like actual go see a doctor, go to a hospital. I just had the EMS, the guy in there, he like waved a flashlight in my eyes, said, does anything hurt? How does this look? Can you follow my eyes? Kind of see if anything in my brain got messed up, which I passed and I did fine.
When was your flight out of Atlanta?
I think 7 a.m.
Well, this occurred around 2:30. Why did you decide to go ahead and make the flight?
You know, seeing as it was, as I had just gone through such a traumatic experience and it had just hit me, I was like, I'm already here. I refuse to just get back in my car now and go all the way back home and have to think about what just happened. So honestly, it was also the fact that I just put so much money into going to Houston. I was like, I'm still going to go to this and go have a good time. And hopefully that will help maybe make this experience not as bad as it was and ideally help get over it.
All right. And you went with, who did you go to Houston?
Jackson, Ohio.
Did you make it to your final destination where you were going?
Yes.
What was that?
Houston.
Well, what was your reason for going to Houston?
To go to the Travis Scott's festival that was called Astro World.
Did you make it to Astro World?
Yes.
Okay. Did you attend?
Yes.
All of it?
Mhm.
Was there anything else that was taken or that you told police that you don't recall me asking you about as it regards to this home invasion and home robbery?
No, I don't think we missed anything.
And did you ever hold yourself out as being able to identify the individuals, the two males that robbed you at gunpoint? Did you ever hold yourself out that you would be able to identify them?
I think I would be able to, in the moment, identify body structure and maybe I knew that they were black as I had seen their skin color and I saw their hands. So I knew their race. But facial, no, I do not think I would have been able to identify or still could be able to do that with the face, as I did not know.
Okay. That's all the questions I have.
All right. Ms. Mignot, we are close to the time where we need to call it for a day. Do you have a bunch of questions for Mr. Carmody or a few? You should take as much time as you want. If you know you only have, sometimes you stand up and say, I'm going to be brief. Sometimes you don't say that. Is this a brief or not a brief?
Not a brief, Judge.
Okay. Are you able to come back tomorrow or are you driving back to Charleston?
We are driving back, but I think I can definitely stay another day if I have to.
You have to. I apologize. The goal was to fit you in today, but I've committed to the jurors that we'll stop close to 5 and we're actually a little bit past 5. So I apologize for that. We need you back here 12:30 tomorrow. So you can sleep in. 12:30 tomorrow. You'll be our first witness. It's important that you not talk about your testimony with anyone because you're partway through that process. So talk about anything else, but we need you back here a little before 12:30. We'll get you on the stand, see if there's any cross-examination from Ms. Mignot, from the other party, and then if there are any questions from the jurors, okay?
Okay.
All right. Mr. Hiles, anything else for Mr. Carmody before he goes?
No, Your Honor.
Okay, you can step down, sir. Thank you. And ladies and gentlemen of the jury, we are, just want to shift the camera angle. We're going to stop for the day. Again, tomorrow, Wednesday, we're going to start up at 12:30. I don't know that the shuttles run quite as often in the middle of the day. They may around lunchtime, every 30 minutes. So you really want to catch the noon shuttle because you roll, if you're one of the folks who parks in the lots that have color names, and you roll in at like, well, but maybe there's a 12:30. You'll be late anyway, though, so don't try to catch the 12:30 shuttle. Try to catch the noon shuttle. If you don't park down there, just be here by 12:30. Please have had your lunch. Because I'm going to view the lunch break as ending at 12:30. It's all morning. It can be a brunch break. Any logistical questions for any of you? Your notepads, take them with you and leave them in the jury room. Yes, ma'am.
We did speak about running later tomorrow.
Oh, right. Yes. Thank you for reminding me. What is the collective will?
To run late tomorrow.
Okay. Then let's assume that we'll go till 6. And 6 will be like today's 5. If it's 5:50 and we finish the witness and the next witness is an hour-long witness, we won't start that witness. But otherwise, we'll go till 6. And if we go to 6:02, because that lets us wrap up a witness, I'll know that that's not stressing any of you out. Okay? So thank you for consulting and reminding me. 12:30 tomorrow. We'll see you then. No outside research. Don't talk about the case with other folks. Thank you so much. Let's let juror 19 get out of here. All right, you all can be seated. Couple things. One, now that I have heard more of the defense presentation in form of openings, and I'm speaking specifically to the Robinson presentation, because I'm right now thinking about Ms. Mignot's motion to reconsider my ruling about the 2 music videos. I'm going to maintain my ruling, assuming there has been a redaction of all the parts of Guns Up that showed little kids.
Yes, so I haven't seen it. They're working on it. I will absolutely make it available before I even attempt to play it. So in the intro, there are kids, but it is not the part where, I mean, they're just in the neighborhood, but it is the end of the video where they're actually sitting down and instructing them as to how to commit a crime, the rules of the gang. It is very difficult to get the kids out of the complete frame of the video. They're like walking in the street.
You're talking about at the beginning?
At the beginning.
I'm less worried about that. A streetscape could have a little old lady walking down the street as well. What was particularly alarming was when the performers were interacting with the kids to say, basically, someday you're gonna be like me, or you should wanna be like me. That's out, and that's easy to remove. It doesn't require any cropping. It is removed. And so if it gets too tricky, just end it before that starts. I just don't know if there are things after the kids are gone that you wanna use.
There are, but I think it makes it might just be easier where it's just a hard cutoff. I think they got my point.
I think that that's a wiser move, but that's your call. My direction was to remove the segment that involved the tutelage of the young children. So once that's done, please make it available to all the parties on the other side so they can review it and share any concerns they might have. Okay?
Do you have scheduling matter I'd like to discuss with everyone, maybe off the record? I think I told you about an appointment.
Yep, we'll do that in a minute. So thank you for flagging that. We'll just, you let them leave. Are we not starting at 12:30? Well, we could start and Ms. Green will take care of things.
It's asked for Thursday, so
Okay, so let's pause on that. I'll circle back. Anything else from the state
no, nothing else.
about tomorrow?
Nothing about tomorrow.
All right, Mr. Carmody will be available 12:30 and then we'll fill the rest of the day.
Yes, and I had originally asked Miss Nelson has done a production order for Miss Riley. I'm not sure that we will get to her, but I'd like to have her brought in case we do, because I don't want to forget, especially if we're going until 6.
So it's 5 o'clock now. If you haven't told Ms. Nelson you want her here tomorrow, that's a little problematic.
Oh, no. She's already, I just wanted to make sure she still comes. She already, the order's in.
Good, then she's still coming. She has no reason not to be here. And if we don't reach her, understand, because tomorrow's a half day and then we'll just need to give in, yep, she's coming, I'm told. If we don't get to her, then we'll renew the production order. She's at the city jail, so it's not a particularly complicated one. It's just better to be a day ahead of things. And I'd ask, unless it really throws your case upside down, if we're bringing her over tomorrow, let's try to get her on the stand tomorrow. But we'll see. All right, anything else from the state?
There.
Okay. Sir, anything from you before we wrap for the day? And so the record's clear, I'm referring to the accused. You're good? Okay. That pen that you have, you should leave here. I promise you can have it back tomorrow, but I don't want to get you in trouble because you're bringing that back. Great. Ms. Mignot, anything on behalf of Mr. Robinson?
Yes, Your Honor, we are still concerned. We understood the court's ruling as to the video that the children were going to be removed. Now, today is the first time we're realizing the state is having difficulty removing the children from the video. It is still our position that even associated with the testimony that this court has received, that there's been no allegation of any gang. There's nobody who's testified that they seem to be gang members or we saw them as gang members. So we're still objecting and renewing our objection regarding the guns up and the play nasty video. But I am concerned that if we're gonna show these jurors videos of guns that we think are dangerous and that we're trying to make a connection to this case, that any child, if it were an adult or a grandmother, they'd be like, she's old, she's seen the world.
Right.
But it's still impressionable and it's still making sense, some of the jurors to see a child.
I don't disagree with you. And so here's where we are. Mr. Hiles is going to share with you and with me and with the accused what he's come up with the edits. And if it's not sufficient, he can either fix it in the available time or not use it. The second video doesn't have that problem. And you're not waiving any objections by saying, oh, okay, the kids are out now. That I'm understanding that you maintain your original objections. And so the record's clear. These are videos that are being introduced only as to Mr. Robinson, not as to also the accused. So that's why you and I are having this discussion. But let's see what they put together. And if I need to say, look, I told you no kids and they're still kids, they could always rush and say, oh, we're going to cut out the first 30 seconds where there's the street shot and their kids playing in the street. I may look at it and say, I view that as harmless because That's just footage of walking down the street. It also has trees in it, and that's not an issue that there are trees in it. So I am open to your concern. I need to see it. It sounds like Mr. Hiles has focused on the area that I know I directly referred to, which was that footage of the performers interacting with, blowing smoke on, having guns with the little kids. That needs to be out, and it sounds like that's coming out. Let's see what's left, and we'll address it then.
Thank you, Your Honor.
Sure. Anything else?
That's the only matter.
Okay. All right. Accused. Your family at one point was providing street clothes for you to wear. Are you interested in that? Because they'll be back tomorrow and we can have you dress out if you want to. That's your call. I don't force it on you in any way. I'm just simply offering it up because there's been a little change and you've been with us for part of the proceedings. So if you want to wear clothes more like what Mr. Robinson is wearing, we can make that happen. But it is not a requirement. I'm not ordering you to do it.
I'm gonna try to connect with them and happens to do that.
You're going to take care of it. You don't want any assistance from me.
Not current.
Okay. All right. When that changes, let me know. Okay. All right. That's it. Thank you so much.
Thank you, Your Honor. Enjoy your evening.